Well,
with your lordship's leave, I wanted to move a matter on the 13th. I will be filing it. My lord, if your lordship permits it to be taken up as a leave matter on the 13th. My lord, this petitioner, there is some urgency. This petitioner is a
13th already you filed it. 13th, yes.
My lord, then I'll hand it over to your lordship's court.
Leave 13 তারিখের জন্য লিখ দিন।
I'm deep. Leave matter to check this one.
Bali municipality, my lord, is not holding an election for the last 10 years.
So police will do what? Police will do what?
The finance officer, my lord, under the West Bengal Audit Accounts Cadre. Now, my lord, being a whistleblower, my lord, I indicated and pointed out, my lord, the financial irregularity, and for which, my lord, the entire, my lord, the contractual staff, my lord, blessed by, my lord, the ruling dispensation, my lord, they are hunting after me. Not only that, my lord, there is a threat perception, and I made an application.
13 দিয়ে দাও 13th.
Some compelling circumstances, may I permit to mention the matter? This is a matter, lordship, of Ramnagar police station, lordship, under the South Chobbish Pargana. While lordship, in spite of lordship dying declaration, one co-accused already granted bail. And lordship, another, the principal accused, lordship, has been surrendered. No remand has been called for. This Honorable High Court rejected the anticipatory bail. District Court rejected the anticipatory bail. Lordship, I am not in a position to enter into the court premises. No lawyer, lordship, accepting the lordship. I have informed the police officer. They've advised lordship not to enter the court premises and withdraw my withdraw my complaint, lordship. And lordship, 8 is the date for lordship production and lordship bail hearing of the.
That for cancellation you file 13th.
Because 8 is the date, lordship. In respect of the lordship co-accused, lordship, we have lordship taking steps for lordship filing the cancellation of bail. And lordship, the principal accused who has surrendered, lordship, just day before.
Then give it, I'm releasing the matter. 13th, if you don't do it before other court. Either listen to me or do it before other court, sir. I can't take up all leave matters at a stage.
May I be permitted to mention
13th, if you are ready, it'll be.
Actually, I can appear, lordship, before the
13th দিয়ে দাও leave.
May I be permitted to mention one matter? My lord, I had mentioned earlier this matter that the petitioner is in custody and he is preferring this state on the ground of the illegal arrest. Your lordship directed me to file it and thereafter to mention the matter before your lordship. My lord, this is the matter. If your lordship
13 তারিখে দিয়ে দেবেন।
May I have your lordship leave to mention for correction, madam?
Give it. Tomorrow এটা কালকে দিয়ে দেবে। Correctionটা কালকে দিয়ে দেবে।
on 8, lordship, before the.
I can't do anything, sir. Not.
Lord, may I permitted to crave leave to file, my lord? May I permitted to crave leave to my lord, to file this petition, my lord. The urgency is that, my lord, the petitioner voluntarily left her, my lord, parental home at Jharkhand, my lord, is staying at Kolkata, my lord. But, my lord, on the basis of FIR made by the mother, my lord, the police at Jharkhand, my lord, trying to, my lord,
Lordship, anticipatory bail.
Lordship, under extreme urgency, I am mentioning that matter of POXO victim.
That matter, sir. Tell me the matter.
So the matter
What is the urgency?
Victim mother is before your lordship. Victim has not been examined before the judicial magistrate after 30 days of commission of offence, and victim's father has been illegally arrested, lordship, without in violation of the judgment of Vihan Kumar, lordship. That is the urgency I have filed. On the previous week, lordship.
What are you wanting, Vihan Kumar?
No, lordship. I am urgently now. I am wanting before your lordship to pass an order for recording of 164 of the child, lordship.
Already 13 তারিখ।
Lordship, that is within the list, lordship, 143. Can it be hard on tomorrow, lordship?
Serial I will not break.
My lord, complaint has not
It
been
is in
filed.
the list. List
It is in the list, lordship, 143.
It will be called tomorrow, sir.
My lord,
143.
কাল ডাক হয়ে যাবে
my lord, complaint not lodged against the petitioner.
Mention tomorrow if it is not called.
Grateful, lordship. Grateful. Obliged.
My lord, with regard to the leave matter, my lord, may I
Go before other bench. Go before other bench. I'm granting you leave.
Lord, I will try.
Yeah. In the order dated 2/5/2025, inadvertently in the last sentence of the order, it has been referred to as June 2024. The same should read as June 2025. This may be treated as part and parcel of the order dated 2/5/2025. Department is directed to incorporate necessary corrections. Only June 2024. Next. Yes.
Supplementary. Normally, regular list.
Yes. Yes, where is the supplementary affidavit?
Regular list.
Huh?
Regularly statement है मैं.
Where is the supplementary affidavit? Supplementary affidavit filed by the petitioner we kept with the record. List the writ petition on 16th of May 2025 under the heading assigned matters. Chalo. As original application. List the writ. ডাকো আর কি করো।
Item number 2. Item number 2. My lord, in this matter, my lord, yesterday, my lord, yesterday your lordship, my lord, granted leave, my lord, to keep it today at 10:30. My lord, this is with regard to small, my lord, meeting which will happen, my lord, in front of the West Bengal Human Rights Commission office. My lord, the petitioner is the secretary of a public charity.
Tell me one thing, human right.
My lord, I'm telling you, lordship. My lord,
Just tell me one thing.
500 victims of Malda and Murshidabad.
Just tell me, is it a designated place
My lord, for what?
for holding the AAs?
That's nothing political. We have 500 victims.
Political, I'm not bothered. Gathering of persons in front of an office of an adjudicating body. It must be, is it any person, any political party has done that? Or any individual has a group of persons have done that earlier?
My lord, over here, my lord, what we are, my lord, coming for.
See, I'm telling
there is
you,
a deputation which
very good. You go to the Y channel, do it in the Y channel over there.
My lord, this is in the front of.
There's a Y channel at Salt Lake also. There's a Y channel at Salt.
I can suggest other places, my lord, but 1,000 persons gathering in front of Purto Bhavan.
No.
Bhavan, my lord, entire working day will be.
My lord, over here, my lord, over here.
Come to the persons first. Not
There
before
will, be,
the.
there will not be 1,000 persons. There will be 400.
Not
persons.
before the state human rights. Then somebody will come and say before the High Court one day.
No, my lord. That
Yes.
has happened
Matter of
in the governor house. My lord, over here, that has happened in front of the governor house.
Don't say.
That is, I'm not no negative equality, but I want to. My lord, over here.
I have got no issues, sir. You do whatever you want. Go do it somewhere. The persons will be going giving deputation. They will be going to the office. But so far as the gathering is concerned, do it elsewhere.
Lordship, I'm telling you, Lordship, my lord, over here, it's a 40 feet wide road. So there'll be.
Share FE block.
No, my lord. Over here, this is
You
BF
stay
block.
where? FE block.
BF block, my lord.
हाँ GD block. GD block is सामने EZCC. Go to EZCC and do it. हाँ? ওটা ময়ূর ভবন ঠিকই বলেছে
Purto Bhavan is there.
না ওখানে হবেই না
Same line.
let the three or five persons could be going for
There'll be
deputy
10
let them
persons
go
around who will
do
be
the gathering of 200 persons somewhere else কোথায় করো EZCC
Central Park, footpath, my lord, Central Park. On
Central
that
Park.
side, Central Park.
But
ওখানে
that is
আছে
about how long away from you?
My lord, no, it's just on the other side. Because Purto
It's
Bhavan is on
near
a
DD10.
narrower road.
near opposite to DD10 তাই তো
Yes.
Opposite to DD. Yeah, that is.
Alright.
Where, because in
That-
front
that
of
is-
Purto Bhavan, there is no footpath.
That is.
I am
Only
against
one.
before any adjudicating authority somebody will go and
Yes, yes.
protest something like then somebody will come against in front of High Court and say we are going to do
Oh, Kalke.
My lord, only one prayer, my lord. Wherever we do it, my lord, there should be one small pandal which, my lord, so that there are people who will be accumulated. It's the heat. My lord, it is nothing, my lord, absurd I'm praying for, my lord. Over here.
don't block the road if you
Nothing, no
places
blocking the road, my lord.
On the footpath.
On the footpath we will do it. On the footpath we will do it.
Footpath adjacent to Central Park.
which side your police officer is there who can
That is about
understand.
1 kilometer away from.
your instructing officer is there এরা ভুল বুঝিয়ে আবার অন্য কোথায় চলে যাবে এই তো মুশকিল ময়ূকে
Purto ওখানটা ম্যাপ করে বার করে রাখো Purto
এটাই কতক্ষণ?
চলে আসুন petition
These are just Purto human rights is just on the round the corner from there.
হ্যাঁ ওখান থেকে কাছেই
It will showing, my lord, 12 minutes away.
না না
হ্যাঁ তো ওই কাছেই
Lord,
Same-
any-
same.
Any place which is 5 minutes away, my lord, it would be easier.
12 minutes is enough sir
একদম কাছে
designated places you do I have got nothing to say but creating a new designated place I have my reservations sir
That, my lord, your lordship's judgment is there.
acha petitioner has prayed for
My lord, only verbal direction
permission
as of now can be passed. because-
permission small order I am giving permission for organizing a public meeting on 6/5/2025 between 11 a.m. to 5 p.m. near the office of the West Bengal State Human Rights Commission so far as the venue which has been proposed by the petitioner is not acceptable to the court. On a consensus, it has been arrived at. The petitioner be allowed to hold a gathering of 200 persons in front of 500 লোক ধরবে না ওখানে
500. 1,000 I reduced to 500.
This is a deputation, this is not a
500.
speech.
500 over there, people will be assembling there. There are victims
200.
of Malda and Murshidabad.
Malda Murshidabad victims, you go over there, do it, and over.
Over here, give the deputation to the West Bengal.
The whole of them will go.
Not 10 of them will go. They will not stand.
500 লোক সল্টলেকে ঢুকিয়ে দিলে মানে গাড়ি বাড়ি কিছু যাতায়াত করতে হবে না।
Malad, how many cars? Malad,
200.
Malad, 400, your lordship was giving 400. Malad.
No, I did not give that. মুখে মুখে মিথ্যে কথা বলে দেয়
400. Malad. I'm visiting.
200 is a good way. এমনি গাড়ি ফাড়ি নিয়ে ড্রাইভার টাইভার নিয়ে 250 হয়ে যাবে 200 200 persons in front of the footpath of the Central Park. What do you propose, Mr. Huh?
Footpath adjacent to Central Park.
Footpath adjacent into Central Park to the effect, if any
Adjacent to Central Park na kore
stage
opposite to this.
opposite
Opposite to
DDT nursing home. Huh?
This is opposite to staff selection commission.
না ওদিকটা বাজে
না ঠিক আছে
ঠিক আছে বলে দিলে হবে না কেউ যে সল্টলেক আমি বেশি চিনি ওর থেকে
Wherever lordship.
That's opposite to DD10 is better. Where the commission's office, earlier chief minister's house was there, no? Opposite, you understand that place, na? হ্যাঁ কিসের জন্য বললাম to that effect, if any stage is constructed, the petitioners will coordinate, the petitioners oblique organizers will coordinate with the local administration and accordingly ensure that there is no traffic congestion for or any stage being constructed and the gathering of the people. ওইখানটা না অপোজিট টু DD10 নার্সিং হোম নাকি মেট্রো কার্ডশেড কি একটা বলে কি মিস্টার স্বপন ব্যানার্জি ইজ ওভার হিয়ার হি ওয়াজ দেয়ার ইন একটা ম্যাটারে আমি অর্ডার করেছিলাম ওখানে কিন্তু ওই বলেছিল যার জন্য এখানে একটু ফাঁকা হ্যাঁ দ্যাট ইজ দ্য প্লেস ইউ আর ওয়ান্টিং না হ্যাঁ অপোজিট টু DD10 নার্সিং হোম করে দিন ওই যে প্লেসটা যেটা বলছি ভেনুটা অপোজিট টু DD10 নার্সিং হোম নাহলে বনবিতানের দিকে মিলনদা ঝামেলায় আচ্ছা and the gathering of the people will be should be monitored by the organization.
I'm requesting. There'll be 400 people who are already there. Malad. Let it be, Malad.
Let them on the other side of the road. Let them be on the other side of the road. But organizers in coordination with the administration. এর বেশি দেবেন না আচ্ছা Mr. Bandyopadhyay has forwarded the following conditions. ওইটা কন্ডিশন যেটা আমার ইউজুয়াল আছে রামনবমী নয় গ্যাদারিং এ যেটা সিটিং ডেমনস্ট্রেশনে কদিন আগে একটা দিলাম না
These are the
দিস
conditions.
ইজ অফ হোয়াট
This is of a public meeting.
নিউ মার্কেট
New market.
নিউ মার্কেট
New market.
নিউ মার্কেটে অনেকগুলো মাইক্রোফোন আছে সল্টলেক
Not
কতগুলো
those,
Three, they have brought 3 in the morning.
হ্যাঁ
They have brought 3 in the morning. 3 microphones in the morning. They have already gathered there.
ওই 3টে মাইক্রোফোন করে দেবেন খালি হ্যাঁ দিয়ে ওই কন্ডিশন করে দেবেন মিস্টার মুখার্জি হ্যাজ অ্যাকসেপ্টেড দ্য কন্ডিশন
Awesome.
from 1 o'clock they will start that.
Malad, not 1 o'clock, but 12 o'clock. Let it start from 12 o'clock. We are already, Malad, gathering that. Lordship may allow it from 12 o'clock.
When are you going to meet?
Malad, 3 o'clock.
কোনটা
3 o'clock?
সল্টলেক কি অবস্থা হবে
Malad, if we get a copy of the order, Malad, I don't mind. I'll communicate it. Malad.
Huh.
But Malad, kindly gives the time by which I can communicate the order for everyone's sake, Malad.
11 that's why I'm saying 1 o'clock
12:30 to 4:30.
order dite parbe.
No, আমি জানি, but verbally, Malad, he can
It is
communicate.
difficult, Malad. It is
He can
difficult.
communicate.
There's no need for any confusion. We'll communicate the order. My learned friend will communicate the order. Matter will end.
1 o'clock, you 1 o'clock, you carry on. Deputation team will go on 1 o'clock to 4 o'clock. In the meantime, your deputation team can go over there. আর ওই টাইম পিরিয়ডটা দিয়ে দেবেন বিটুইন 1 PM to 4 PM অন আজকের ডেটে দিয়ে দেবেন আর করে দেবেন আর টিম অফ how many persons will go?
But I think 4 persons is enough.
3 persons you say.
5%. They have only allowed.
আচ্ছা ঠিক আছে
5%.
I have it is to their office, whatever.
হ্যাঁ a team of 3 persons would team 5 persons who is making this application, sir?
Or the secretary of the Ram's Home Swabiman Partition or a public charitable trust, or who is organizing this?
কি বললাম would would go to the office of the Human Rights State Human Rights Commission and submit their deputation to the chairperson or any authorized person, any authorized officer, deputy aid by the chairperson of the State Human Rights Commission. Full stop. এই বাকিটা একটু দেখে করে দিন with the aforesaid disposing it of, sir. With the aforesaid observations, WPA 10275 of 2025 is disposed of.
Deeply careful, deeply.
With the administration, পুলিশ বলতে যাবে coordination with the administration. এটা একটু টাইপ করে দিন, কাউকে টানিয়ে নিন এক্ষুনি। হ্যাঁ 12:30 আমি সই করে দেওয়ার চেষ্টা করব।
Item number 1.
আপনি না ছাড়লে তো কেউ আসতে পারে না। এটা আগে This I am sending. Who is appearing for the state in this matter?
The matter, there is some element of seriousness, my lord.
Who is appearing for the state?
Sir, I am appearing for the state. Led by Learned Advocate General.
Second, police excess.
Let this go to the division bench, sir.
No, primarily, essentially, my lord, it is against, my lord, the Bidhannagar Police Commissioner. What they have done. This stems from
Whatever it is, let this go to the division bench, sir.
my lord, the difficulty is, my lord, we are being hounded. My lord, what happened, I'll tell your lordship. Now, my lord, the petitioners are the widows of the victims
This matter
who, my lord, were victims of, my lord, an unfortunate incident of rioting, my lord, in Murshidabad.
Right now, nothing is there, sir.
No, my lord, the police has been hounding us, my lord. We, out of our own volition, my lord, we came to the Honorable High Court, my lord. We came to Calcutta for filing a petition before the Honorable High Court. My lord, the police, we were camping at Salt Lake, my lord. They broke open the doors. We were, my lord, harassed. We were heckled. There were abuses, my lord, which were heard. Now, around 40 police personnel, my lord. And, my lord, thereafter, my lord, the learned advocates reached the location, my lord. They rushed to the spot because the petitioners therein, they said that
Mr. Bhattacharya, this stems out of the Murshidabad incident.
but I understand. No,
My lord, if I may be allowed to make some submissions, my lord.
predicament, my lord, is,
You
my
are
lord,
who?
I am for an intervener on the basis. One.
the predicament is, my lord, the police finally, my lord, on being cornered, they said that no, there is some
Respondent, I'm
movement regarding
asking for
kidnapping on the basis
respondent.
whereof we have come to
Nothing is there before me.
No, it is everything has been narrated in the
It's only on averments, then I have got to ask for affidavits from them.
There
No,
are video recordings, my lord. There are video recordings. The police has also
You don't have any interim order, you don't require. What?
My lord, there is an interim order required.
no interim order, my lord. If my lord is desirous, my lord, to place it before the honorable division bench. my
I'm
lord.
desirous of that
First is,
only.
first is, my lord, we as individuals, my lord, will, my lord, lose our right, my lord, to prefer any appeal, my lord. In the case we are aggrieved, we are not, my lord. We are very poor people, my lord. We have lost our husbands, my lord. We are not as rich as
I
the
have-
state, my lord, that we can
I have
go to any
I
person,
have
my lord.
no, this is not. I have full sympathy. Earlier, all Murshidabad matters which have stemmed out of violence of a different character, which is ordinarily not
Bow
there.
down to that, my lord.
Even for permission of the leader of the opposition, I have referred the matter to the division
Correct.
bench. Division bench is in thick and thin of the local incidents which are happening. The police reports, but whatever is there, that's why I want the division bench to consider the same.
Stems out of a kidnapping case. That is what is.
Where is the kidnapping case?
My lord, that is where lordship, I want to make some submissions if Mr. Bhattacharya permits me and my lord permits me.
Who are you?
Lordship, I am the purported complainant of that kidnapping complaint, he is present in court, the petitioner, the intervener is present in court. He has been forced to sign on certain papers on the basis of which that kidnapping case was purportedly lodged. Lordship, there is some protection, at least required for my client.
I am releasing it.
For the moment, my lord, till the matter is taken up by the honorable division bench, my lord. My lord, may kindly, my lord, protect us, my lord.
If I am not taking up the
No,
matter,
my lord is releasing the matter, my lord,
Huh.
because, my lord, no, the assignment is not automatic, my lord, because in the other cases also, my lord, we had to play, my lord,
if Honorable Chief Justice reassigns the matter, I'll
15th is
hear.
the date fix. My lord, kindly appreciate. 15th of May is the date fix, my lord, before the honorable division bench, my lord, because that is not a regular division bench, my lord. It will be next sitting, my lord, assembling on the 15th of May, my lord. Till then, my lord, the police should not harass us, my lord. My lord,
But that will be an order.
the prayer E, my lord. Or, my lord, let there be an assurance from the, my lord, from the state, my lord. My esteemed senior friend, my lord, the London advocate
should
not
not-
there, my lord.
Had I entered into the zone of merits, I would have definitely.
This, first of all, my lord, my lord, for the my lord, sake of repetition, my lord, this is not pertaining to Murshidabad. This is against police excess, my lord. The police attempted, my lord, to kidnap us, to abduct us, my lord, without any
On
authority
the
of
basis of a false
The
kidnapping.
final prayer would be to transfer it to CBI, na?
But if my lord finds, my lord, that
My lord, at least for the intervening
I
period,
have
some
got
protection.
to
my lord.
have every total circumstances in mind. Division bench is insisting of everything, sir. Go over there.
my son is being represented by Mr. Das, my lord. My son,
My lord, some protection has to be given.
government, my lord,
He has been hounded for 3 days by the police officers. The police today also yesterday has made tweets
Achha,
giving
since,
open threats.
Since the honorable division bench is insisting of the issues arising out of the incidents of Murshidabad, and the present petitioners are victim of incidents of violence at Murshidabad as has been submitted aid by the learned senior advocate,
we are against the police excess, my lord, the police atrocity.
as has been submitted aid as has been
Commissioner.
submitted aid by the learned senior advocate appearing on behalf of the petitioners. Petitioner is presently aggrieved by the act and actions of the Vidhannagar Police Commissionerate. Next, having considered that the honorable division bench is in of the issues stemming out of division bench is in of the issues relating to the litigations relating to police administration and or further prayers made therein in the litigations before in the say public interest litigations and several other writ petition. I am of the view that let the writ petition be released from the list, records be placed before the Honorable Chief Justice for appropriate assignment.
My lord, one submission only. My lord, at least a recording of submission of the learned advocate general. The learned advocate general has not even opened his mouth. Sir, submission sir, please. Sir, please. Sir, please. Sir. My lord,
This is
my lord,
regularly I'm facing. This is the culture which has developed. The culture.
I apologize. I tender my sincerest apologies, my lord.
Difficulty now is that lawyers are alienated to all political parties. Their source of power is outside the court, and they are behaving accordingly within this court. Exactly. All respect, I am not mentioning one political party, all political parties.
Has happened from today morning. Lawyers are not on air in regard to this matter.
My lord, I did not mean any disrespect.
With the litigants in this matter. And see, my lord, where we are taking our profession. We are supposed to belong to a noble profession.
I've told you. Lawyers have aligned themselves with all the irrespective of any political party, sir. And since their source of power are those political leaders, they are showing their heat before the court.
I apologize.
There are outcome of a litigation.
But I take it upon myself. We are to blame. We have not been this people.
I apologize once more.
of our profession has gone.
There were earlier lawyers also who were alienated to political parties. I have seen them. But they did. Mr. Bikash Bhattacharya doesn't behave like that. I've seen his behavior in court. I've seen Mr. Bolai Chandorai. He was also,
Of course. So no, but
Think about the discipline glamour of Mr. Siddhartha Shankar.
observing the classical aspect, my lord, of this particular fraternity is the
Yes,
greatest
you are-
responsibility of all of us. That is what I feel.
Yes,
I feel it is on the
I
first decade.
blame myself for this.
This is the first decade, my lord.
I blame myself for this. We don't find juniors stand up when the seniors are standing beside them. Because they are not going to be seniors chamber.
This has become common now after this.
My lord, I am responsible for the, I apologize.
Nowadays, juniors don't call themselves as juniors, they call themselves as associates. This is where, Milord, we have dragged our profession.
very unfortunate.
We were always
I
taught,
find people, because while arguing matter, when a phone call comes, they go down below the bench and attend calls. And after the court, find lawyers running towards the cameras. This is where, Milord, we have crossed our profession.
You cannot behave. There must be some behavior, some court crafty. Why do you say?
Any Milord unfortunate incident, your lordship will find members of our fraternity over there. Whether it is Hamsharganj, whether it is Sandesh Khali, wherever.
that is on a different aspect. Being public spirited, that is on a different aspect.
You are a
We are on maintaining, we are on preserving, we are on preserving and protecting the integrity and classicalness of this
I
profession.
apologize. I apologize.
You should not go down to the streets. Litigants must come to the lawyers. Lawyers will not go to the litigants. Is it our profession that
This
lawyers
I will
go
not
to
allow in
litigants?
court that because you are alienated to a political leader,
Doesn't mean that you are going to come here and shout.
this then we won't be able to run the institution. As simple as that. Every case has an outcome.
Definitely,
Somebody must aggrieved. You go to the appeal court.
definitely. This is
No
the
issue.
hierarchy which has been created.
Yeah.
for them.
As we have learned, my lord, once we don these robes, my lord, these black robes, it is about everyone being equal, my lord, rising above individual political affiliation, my lord. That is how it was supposed to be. That is the concept of this holy robe. But most of us, my lord, do not even realize that or keep on forgetting that.
But to accept a verdict of a court or an opinion of a court.
I am here to make my submissions. I will try my heart and soul to make my submission.
Definitely, that's
on
a
the
different
questions
aspect.
of law. Thereafter, my lord, whatever the
On facts
decision
also you should make that. I have got nothing to
no,
say.
thereafter, my lord, whatever the decision is, my lord, there are other forums available. We should never identify ourselves with our clients, my lord. And this is applicable to everyone, my lord. To everyone, all the lawyers.
I wish the members of my profession remembers this.
And the more we remember this, my lord, the better it is for the fraternity.
Profession that will carry
The
on.
better
Sir.
it is for the
So
fraternity.
to accept
We
the-
cannot, my lord, recollect the time when we joined. Way after, my lord, Mr. Dotto, my lord. I have learnt a lot from him also, my lord. That, my lord, the
No, he
gharana was
hardly
completely
loses his.
difficult.
I have seen hardly he loses his temperament.
No, I have not lost yet.
No, I hardly loses his temperament.
Whenever he loses it, my lord, that is not out of tension, my lord. That is, my lord,
Professional.
pretension.
Chalo.
That is pretension.
I am grateful.
Grateful to you, lord.
List new motion item number 3. Item number 3, I am for the petition.
Yes, Kirtan, where do you want to do?
Structures, your lordship. This was relating to one.
And it's not only one for only one occasion. On the several occasions they got the threat.
So when do you want to do, sir?
Kindly sees the dates.
Last year there has been the occasion has been here.
This 5th of February representation.
May I hand over my report, your lordship? I'm in Sassin of only one copy today since my website is done.
There is no problem of doing this.
We have allowed it. Kindly see the last.
Now we are
Wherever you
When-
go,
Whenever
whenever
you
you
applied for
you
permission.
apply, you just inform, intimate, no permission. You intimate the police authorities, they would accordingly ensure protection for you. That's what you want basically, na?
And kindly sees my report, your lordship.
চলে আসুন petitioner হ্যাঁ আপনি এইটা কিন্তু আগে করবেন না গিয়ে একটা থেকে আরম্ভ করতে petitioner has preferred the writ petition as he submitted a representation on or about 5 to 2025 being obstructed by some miscreants for performing in Kirtan.
Dada?
The representations were made to the authorities. However, the petitioner has been facing inconveniences. Learned advocate for the state has submitted a report of the officer in charge, Tamna Police TAMNA Police Station, Purulia, full stop. Having regard to the fact that the time period for which petitioner applied before informed the police authorities has expired. The foundation of the writ petition has become infructuous. However, it is directed that henceforth petitioner will inform the police authorities in case he faces inconvenience or any apprehension of untoward incident and before or performing any program within the vicinity of the said police station. With the aforesaid observations, WPA number 8465 of 2025 is disposed of. Reports are submitted. It be kept with the record. Server copies. Chalo.
Faithful, your lordship.
Maybe I'm Bolbo. But I belong to a scheduled
My
caste.
lord, I am appearing on behalf of the state, my lord.
তাড়াতাড়ি কি read
My lord, I am
করতে
a lower division clerk at the.
What are you wanting?
My lord, I have been harassed, heckled by the department, my lord. For that,
হ্যাঁ কি হয়েছে? You are a lower division clerk.
My lord, as per the report I have received, due to the misbehavior of the petitioner, he was transferred to the Uttar Dinajpur.
So he is what, a police officer?
No, my lord, he is working as a lower division clerk in Consumer Affairs Department of Legal Metrology, Government of West Bengal.
What is your problem?
My lord, please come to the paragraph 3 of my report, my lord.
Lady, please.
belong to a scheduled caste community, my lord. I was heckled over there. I made an application before the controller of the metrology, my lord. Without drawing up any my lord, inquiry, my lord, I was transferred at.
For transfer in government offices, you don't
No, my
require.
lord. My lord, for being a scheduled caste in a community, my lord.
Sir, what will police authorities do?
My lord, let them lodge if because there are specific provision in the scheduled caste scheduled tribe act, my lord, that if a person is being heckled and or is being, my lord,
Go before the special court, lodge that. এইগুলো police
but let
I'm giving you liberty. Go before the special court. You file an application under 175(3) or 4, whichever suits you. Special court can take up that, sir. Petitioner direct FIR হয় না, আমি দিই না. Has approached this court being briefed by the information furnished to Bardhaman Shodor officer in charge Bardhaman Shodor police station in respect of certain incidents which he aims to involve. Where have you said SCST allegation in the?
In the during the allegation there, but I belong to that caste, my lord.
That you
my
can
appointment
belong
letter, it has
to.
been
কি বললাম?
categorically stated, my lord.
In respect of some of his office colleagues. Full stop. The state has submitted a report. The report reflects that the petitioner has been transferred to a different office
To Dinajpur.
to Dinajpur. Having regard to the nature of the contentions, prima facie, I do not find there was any mistake of the officer in charge of Bardhaman police station. However, if the petitioner has materials in his possession, petitioner will urge before the jurisdictional magistrate or the jurisdictional special court by invoking the relevant provisions of law. The courts, the learned magistrate or the special court will assess regarding the substance of the accusations, and exercise the discretion in accordance with it. We therefore say aid observation WPA 8473 of 2025 is disposed of. Reports are submitted. We kept it as our copy. Next.
Deeply obliged, my lord.
সকালবেলা ভালোই গেল কি আছে
My lord, I am appealing for the respondent.
Yes.
Sorry, petitioner, my lord. The
Uh,
allegation of the petitioner is that the petitioner is the owner of the plot of land. This is a subject matter of this writ petition, my lord.
Yeah.
And certainly the private respondent tried to encroach the land and
Yes.
thereby,
try na encroached already.
yes.
126 done to
My lord, we have taken steps. under
petitioner
the- This is a report, police report.
On humble indulgence, my lord.
was
No,
mutually
with the
exclaimed and both in plunder. You go to the for ascertainment. What is your outcome of the LR office? Who in whose name is the land mutated?
actually, my lord,
They, yes. There's a history. Actually, they all are
Respondents are cultivating the land.
ancestors. Respondents are not
Cult-
cultivating. They are co-owners of the land.
But the private respondents are cultivating the land. Their ownership is different.
Ownership is different.
But the
they are
cultivation,
literally
according to
occupying
your report, the private respondent, second page,
My
the first paragraph at the last sentence, the private respondents have been cultivated in question, being the recorder in question at that time.
My lord, now, but in front
Anyway,
page they have.
petitioner is agree if by the inaction of the police authority is as
Maybe also calculate also, but
the officer in charge, Shashon Police Station,
yeah.
did not respond to the information on submitted aid on or about 23/7/2024. The accusation of the petitioner is that the private respondents are trying to have forcefully grabbed his property, and when the petitioner resisted aid, he was abused and threatened to be murdered. Full stop. State has submitted a report or reflects that there is a long-standing land dispute between the petitioner and the private respondents. To that effect, a police authority have kept us vigil and also have drawn up proceedings under section 126 of the BNSS. Full stop. Since the dispute is relating, since the dispute is relating to ownership of the land, police authority, the party is who would approach the appropriate authority is or the civil court for deciding or for deciding for demarcation of the property if so called for. Now, if so apply, if so would approach the civil court or the appropriate authority is bus full stop authorities full stop. It would the right title interest age of the property will be decided by the same forum. So far as the police authorities are concerned, they are not supposed to interfere with the same. However, since under section 126 of the BNSS, police authorities have already drawn proceedings. They would continue their surveillance and ensure that no untoward incident in results because of the strained relationship between the parties. With therefore say 8 observations. WPA number 8474 of 2025 is disposal reports submitted. We kept with the record. Open every service file. We kept with the record. Go to the next.
My lord,
I'm for the state.
Ready. Ready.
my lord, complaint laws, that is the last feature. But police has not taken any step, my lord. Let the
My lord, this is the instruction of the police. No such installment has been done.
So, police কাজ নাকি এটা? The
consider the complaint that will purpose.
petitioner is agree. Petitioner has approached the court as the private respondents are obstructing the business of the petitioner by affixing a big door. Full stop. To that effect, information was furnished to the police authorities. A report has been submitted by the officer in charge, Calcutta Police Station. Full stop. Next paragraph. I have considered the contents of the information also furnished to the police authorities, and and it is reflected that the property is a Thika tenancy property. considering the same, the concerned authority is and or the civil court would decide in respect of any civil dispute between the parties. Police authority would oversee that there is no breach of the peace and or tranquility and or any untoward incident resulting from the strained relationship existing between the parties. With the aforesaid observations, WPA number 8476 of 2020 এটা 25 to 2023 লেখা আছে কেন? 2025 is disposed of. Report for submitted, it be kept with the record. Correct. Correct কথা হবে না, ছেড়ে দাও, হয়ে যাবে।
Seven, my lord, I appear on behalf of the state. On behalf
এই
of
তুই appearing? বাবা, আগে ছিল বন্ধুত্ব, হ্যাঁ?
the last submission, my lord, matter was
Yes.
adjourned, my lord. This is
এখানে violation of
well, my prayer, my lord, the petitioner and his family
petition and
member
family member
with the
confined.
folded hand praying before your lordship to protect his life and the property, my lord. The dispute arose sometime in the month of the June.
Yes, what have you done?
Millard, two things I would like to point it out. Kindly come to Millard, the P2, which is at page number 25. It appears that the dispute between the family has been amicably settled out, which is at page 2. Just a moment, Mr. Chatterjee.
তারপর
Kindly come to this. This is a Mimamsa Patra which has been written. উভয় পক্ষ একই পাড়ার বাসিন্দা সাথে সকালে ঝামেলা, উভয় পক্ষ কখনো ঝামেলা ঝগড়া করবো না, কেউই কাউকে গালাগাল বা সাথে করবো না, মারধর করিব না. This is the understanding.
that is
Prior to that, Lordship would see at page 23, there is a complaint, and this complaint has been taken into the consideration, and the investigation has been concluded. Thereafter, Lordship would see another things, which is at page Millard, yes, page 31. The matter is pending before the senior citizen maintenance forums at Kalna.
May I allow to submit, my lord?
no, but the thing is that is there any criminal case?
Criminal case is there initially, Lordship. I can show to your Lordship.
My lord, kindly allow me.
আমাকে জিজ্ঞাসা করেছি, আমি বলবো না?
This
There are
is
two things, Millard.
no, but this is 6 to 2025 when the information was furnished. Yes, what do you say?
So for the information of 7 to a concern, this information doesn't disclose any cognizable offense. Of Millard, page 27 are concerned. This 27 speaks of Millard to give the protection to the Millard, the parents. Now, this is pending before the Millard another forum. This is one. Second thing is that Millard, the matter which was pending before the Millard, the court complaint which I have received, that has been ended up in a charge sheet, Millard.
ঠিক আছে, দেখছি, yes.
My lord, my learned counsel pointed out the annexure P2, my lord. These documents was received from me by using the force and coercion. That's I have stated in my complaint. That is the annexure P4. Now, my lord, the situation is that not only I have been assaulted, me and my family member have been assaulted on the number of occasion. Now, at the present moment, I am not residing at my premises. Day before the yesterday, I went back to my house and they attacked me. In relation, the private respondent is my brother. They attacked me and I informed the police authorities. Police rescued me.
Where is the report?
Yes.
Now, at the present moment, I am not staying at my property, my lord. This is the real problem. And one thing is that, my lord, they are threatening me to withdraw the case pending before your lordship, my lord. The petition have sent me one the video. If your lordship allow me, I will show you your.
কেন আমার
Side B নিতে হবে তাহলে।
Now that is
you have already this one is who? Montessor PS charge sheet 31/1/2025 has been submitted.
Yes.
number of incidents take place after this police case, my lord. I am under the constant
There are-
threat of the private respondent.
Starting from Millard, first paragraph, NCR has been done. Second is the Millard, the FIR has been drawn up and ended up in a charge sheet. Second,
Where are you
Millard,
staying?
My lord, I am not
Where are you staying?
staying outside. Outside.
আরে where outside? Montessori থাকে?
No, yes, yes, yes.
তারপর ঠিক আছে বলে। So which court is this? Kalna court?
Kalna.
Case is where before ACGM Kalna?
SCJ. My lord,
You want protection basically, na? Protection will be given by the SCGM, not petitioner is aggrieved by the fact that he is confined, comma, he or she, Anhara Mullah, she is confined, subjected to abuse, threatened, and to the effect. For withdrawing the cases pending against the private respondents, and the same is at the behest of the private respondents or their associates. Informations have been furnished to Montessori Police Station. However, no steps could be taken, and presently the circumstances are such that petitioner is unable to stay at his residence. State has submitted a report. Report reflects that Montessori PS case number 548/24 dated 21/11/2024 has been registered for investigation, and subsequently charge sheet has also been submitted. Achha. Police authorities have also drawn proceedings separately under section 323 IPC and also under section 126 oblique 135 3E of the BNSS. Gallo.
23 has been separately drawn up.
I've said that. Achha, I've considered the report. However, the present grievance of the petitioner for approaching his court is not in relation to the merits of the criminal cases. The same is relation to the threats, abuse which she had been facing because of the criminal cases pending before the courts. In view of the learned, in view of the court of the learned ACJ Kalna, or a jurisdictional magistrate within the aforesaid court being in CC in of one of the cases being Montessori PS case number 548 of the 24. I direct that in case the petitioner approaches a concerned court for protection, the concerned court will call for a threat perception report from the police authorities, and on an assessment end of the same will consider the issue relating to protection as has been incorporated under the Witness Protection Scheme 2018. Full stop. If such an application is filed within a week from date, learned magistrate would within a week thereafter dispose of such application.
Only one.
In the meantime,
বলতেই হবে kindly indicate the Mahinder Singh Chawla's case. Otherwise, I felt a difficulty in the Jalpaiguri military. It was, I will not say. বলতেই হবে এটা।
পুরো তো ওইটাতেই স্কিমটা আছে আর কি।
Yes, yes, kindly
ওই ওখানে মহেন্দ্র সিং চাওলাটা দিয়ে দেবে আছে। Yes. ফিটনেস প্রোটেকশন স্কিম ও ব্র্যাকেটে মহেন্দ্র সিং চাওলাটা দিয়ে দেবে। রিপোর্টটা দেখাতে হবে, বাকি আছে।
He's from Kalna. The others is also from the Kalna.
আচ্ছা কি হলো? আরেকটু বাকি আছে। হ্যাঁ। In the meantime, police authorities would ensure that no further untoward incident results because of the strained relationship already existing between the partition. With the aforesaid of the WPA 8565 of 2025 is disposed of, reports are submitted, be kept in the record server. A copy of the report be handed over.
Lordship, I am for the private respondent 6 and 7.
My lord, here this case, my lord, the petitioner, my lord, the seeking, my lord, removal of padlock, and my lord, barricade in entrance pathway at brick build wall, and my lord, the barbed fence were given, my lord, by.
How is the egress blocked?
My lord, the photographs, my lord, have.
Photographs now in the representation.
Yes, yes.
Page 30, where
My lord, the FIR registered, my lord, but my lord, the subsequent steps has not been taken. Kindly see, my lord, FIR, page 20, my lord.
how is your blocked? Where is it written? Tell me.
My lord, in page 20, my lord,
20 I am on where
first
which part?
paragraph, my lord, the original Aadhaar card, voter card and other personal belongings সেই অবস্থায় নেই মিলট that was taken away by the therefore মিলট theft has been মিলট committed and subsequent page মিলট page 21
You
page
say
20 yes
ingress
page
and
page
ingress I am
21
saying.
page 21 মিলট can you see
Theft police will look after.
মিলট এমত next page মিলট
Ah.
এমত পরিস্থিতিতে 17 11
Where are you reading, sir? 1 minute. Where are you reading?
মিলট middle portion of the মিলট page 21
Middle portion. হ্যাঁ এমতো অবস্থায় কোন জায়গাটা এটা?
Page 57.
এমন এমন পরিস্থিতিতে
মিলট অভিযুক্ত ব্যক্তিদ্বয় আমার ঘরগুলিতে নিজেদের তালা লাগাইয়া দিয়েছে এবং আমার যাতায়াতের রাস্তাটি ইটের দেওয়ালের ব্যারিকেড দিয়ে সম্পূর্ণ বন্ধ করিয়া দিয়েছে this is milord I am ousted from the house milord I could not enter into my own house milord this is the this is milord I am seeking double to your lordship's come
I did not get the place where you are referring to. Page 21.
yes milord এমন পরিস্থিতিতে on
তালা লাগিয়ে দিই 17/11
7/11 2024 তারিখে বিকাল আনুমানিক 4টের সময়
Here's what happened, Mr. Sengupta.
Millet, it appears to be a dispute between the husband and wife. Wife made a complaint.
No. I am the elder brother.
So, have you completed, sir?
No.
Do not make it in the installment manner.
Yes.
Millet, the dispute is starting out from a marital dispute, Millet. He was in the custody. After that, Millet, he came back and find something, Millet, missing. Millet, police has started the case, Millet, so far the theft are concerned. So far the padlocks are concerned, Millet, we have nothing. It is purely between the Millet, the private respondent, and the Millet, the petitioner here. Millet, neither we have given a padlock, nor we have obstructed him. Millet, possibly there is a civil
dispute is pending. Lordship, civil suit is pending.
But then, is there any room of this petitioner?
Yes, milord. There are milord.
I believe
there are milord 8 rooms in the first floor, milord. Milord, that was I could not enter into the said room.
Is a civil suit pending? You have referred to a civil suit?
Yes. I have
you
paragraph 6, milord.
Paragraph 6?
Yes, in my petition. Milord.
Where? Paragraph 6 of the petition?
Yes.
তাহলে কিছু করার নেই
Milord,
indicated
milord, 2 criminal case against them, milord, private respondent.
চলে আসুন
1 suit, milord, for partition, milord. But I could not enjoy my property, milord. This is the property of myself, milord.
to inform the civil court for entering into the room. Petitioner is agreeing.
I am ousted, milord.
Read court will not. When a civil case is pending, how can I?
Civil case is pending in other way, milord. In thinking petition.
I will not decide. This is your room. That is his room. It is not my.
Nobody can decide.
2014, milord, that was filed, milord.
Petitioner.
Taking partition, milord. Not other.
Title suit number 453 of 2022. That is what you have written, sir. In page 5 bottom. Petitioner is petitioner has approached the court as is agreed by the inaction of the police authorities. The main grievance of the petitioner is that pursuant to the information unfurnished with the police authorities, a case has been registered being policy para PS case number 31.
Yes, 31.
Dated 14/1/2025. But the principal grievance of the petitioner is that the private respondent has a fixed padlock. Respondents have a fixed padlock at the on the rooms over the rooms which were in possession of the petitioner. And as such, there is no free egress and ingress to the rooms which the petitioner claims to be his own. Full stop. Learned advocate for the private respondent submits that already a suit is pending before the civil court, and the remedy sought for in the petition is for circumventing the powers of the civil court. Mr. Sengupta, learned advocate appearing for the state, has submitted a report. কি হয়েছে তো ভালো টুলটা ওখানে দিয়ে এখানে বাজে টুল দিয়ে দিয়েছে ওকে বলো না ও আরো ঝামেলা পাতায় যেখানে কি বলো A report reflects regarding the steps taken by the police authorities and a history of cases already pending intercede the parties. Full stop. So far as the prayers will, in view of the aforesaid, I am of the opinion that the police authority are already in ceasing of the nature of the dispute between the petitioner and the private respondents. So far as so far as the criminal cases are concerned, however, since already a case being titled suit number 453 of 2022 is pending before the learned aid civil judge senior division Tehoto Nodia, I am of the view that the issue relating to egress and ingress is be brought to the notice of the concerned court. In case the civil court passes any direction upon the police authority is relating to egress and ingress, the police authority is would respect, obey, and implement the order of the civil
The
court.
personal belongings which is milord under the milord my rooms milord original Aadhaar card and other
That
necessary
there are
documents.
criminal cases, you make an application to the magistrate, sir. A criminal case is there, local magistrate is insisting of the issue.
Case is there milord on the Hanson I made an application for RTI thereafter they lodged the milord FIR.
And a
Before
criminal
that, milord,
magistrate is insisting a criminal case is before the magistrate. The High Court মামলা আছে যার মধ্যে আচ্ছা reports are submitted, be kept with the record, dispose of with the
we'll get the copy of the
reports so submitted, be kept with a copy of the report be handed over to both the parties. A report without annexures করে দিন, না দিতে পারবে না state. কি হয়েছে পুলিশ এত মোটা মোটা রিপোর্ট পাঠাচ্ছে কেন?
I was also started to see the thickness of the report.
Next.
Well, 9, I'm for the petitioner.
I'm for the statement.
This is the affidavit of Sardi. The petitioner purchased a land for cultivation, and my lord, thereafter, they were obstructed by the private respondent to cultivate their own land. My lord, kindly turn
Yes,
to
what
page
is the
number
report?
28.
Civil suit is pending.
My lord, civils, I have filed the civil suit, and my lord, kindly see the page number 28. They have
Kindly come to page.
restrained from disturbing the peaceful possession of the plaintiff and ousting the plaintiffs from the suit for property till 31/5/2022. Thereafter, it has been
রিজেক্টেড তো 151 তো রিজেক্টেড হয়ে গেছে।
yes, your lordship. My lord, kindly
আমি কি করব? আমি অ্যাপিলেট কোর্ট নই তো সিভিলে। You got to pursue that. Police protection has been refused by the civil court.
This is my report. Yes, but 126 has been made. 126 was.
Your you made for police protection applied. So if you are aggrieved by that, you have got to approach the appellate forum of the ad authority, sir. Means appeal will lie against that. Why are you coming?
kindly pass any order when police will not.
Kindly
After filing this application,
Kindly come to page 35, my lord.
petitioner is a
after filing this application,
petitioner claims to be owner of a land, of a land where his peaceful enjoyment, peaceful possession is being interfered at the behest of the private aid respondents, and they are trying to oust the petitioner from the say aid property. As also grab the same. So the informations have been furnished to the police authorities, but the but the same did not yield any result. Why I yield? Achha, learned advocate A8 appearing for the state submitted the report reflects that on receipt of the information, a GD entry was recorded at the police station. Consequently, a proceeding under section 126 of the BNSF has been drawn up. Full stop. I have considered the records of the case, and I find titles TS 184 of 2022 is pending, very in the Civil Judge Junior Division Second Court Behrampur Murshidabad was pleased to restrain the private respondents from ousting the present petitioner from the suit property, as also not to disturb their peaceful not to disturb their peaceful possession. However, the learned aid civil court refused to grant any direction when the petitioner approached the CAAM court for rendering police assistance. Having in regard to the circumstances presently existing. I am of the view that the proper remedy so far as the prayer of the petitioners are concerned should be before the appellate forum of the civil court.
My lord, kindly appreciate one thing, my lord. My lord, kindly appreciate one thing. After filing this application, police authorities threatening the petitioner not to cultivate anything over my land.
That is not his case.
That is not the case before. These are changed circumstances you are saying. Acha. Police authorities would continue to oversee that no untoward incident results because of the strained relationship existing between the parties. With the aforesaid observations, WPA 8588 of 2025 is disposed of. Reports are submitted. He kept with the record. A copy of the report be handed over to learned advocate appearing for the petition.
Item number 10. I pay for the state respondent.
YOLO. Nobody? None appears on behalf of the petitioner. Mr. KJ Yusuf appears on behalf of the state. Please the read petition on in the monthly list of July 2025 under the same heading. Cholo next.
But I am for the petitioner.
Yes, please.
Your Lordship, I'm appearing for the on behalf of the private respondent herein, but the learned advocate, Mr. Sudhanshu Nath, who is appearing on behalf of the private respondent 5, 6, and 7, is unable to appear before the court because he is not well.
Let me hear him.
Yeah, sure.
Thereafter I'll
Yes, yes, Your
wait.
Lordship. Yes.
Well, the private respondent has manufactured a fake dalil. On the basis of that, they have filed a title suit before the learned court below. That suit fails. My lord, the learned high court.
There was earlier order of Justice Boshak.
Yes, my lord. There was a cost imposed at 1 lakh rupees. And on the basis of that.
So what is your accusation now?
Acquisition now, my lord. My lord, despite of losing all the things, my lord, they are disturbing me to cultivate my land and all the things, my lord. This
Yes,
is the
Mr. Dotto.
They have lost
By
everything.
registered, their prayer is to take steps in accordance with the representation.
If I reach
My lord,
disposing
only
of this.
protection, my lord.
Give your name of your senior. I'm disposing of this. No use of keeping this pending.
Your Lordship, I know that, but I don't have the brief and I've not been assisted.
This is on
You
record.
give the name. They have filed an application. Police has registered FIR. No use of keeping this matter pending.
As Your Lordship pleases.
You give your name and the respondents in respect of whom.
Yes, Your Lordship.
Learned advocate appearing for the petitioner has approached this court, being aggrieved by non-consideration of the representation dated 12/3/2025. Mr. Dotto, learned advocate A8, appearing for the stay A8, has submitted the report which reflects Bangor PS case number 62 dated 22/4/2025. এই ভাঙড়ে এখন এই অবস্থা বেঙ্গল পুলিশ আছে নাকি?
That's the middle
হ্যাঁ
sections in IPC.
কলকাতা পুলিশের এই অবস্থা হয়ে গেল কি করে? আচ্ছা কি বলে has been registered for investigation. In view of the police authority is responding AAing and registering AAing the criminal case. I am of the view that at further pendency of the purpose for which the writ petition has been in record has been in subserve. Accordingly, EWPA 8610 of 2025 is disposed of. Reports are submitted. Be kept with the record. Server copies. চলো ওনার নামটা দিয়ে দিও। হ্যাঁ কেস রেজিস্টার হয়ে গেছে, আবার রিপোর্ট নিয়ে কি করবে? আপলোডেড আছে তো, আপলোডেড
পুলিশ প্রোটেকশন at least be
আর কিছু হবে না। এফআইআর হয়ে গেছে, আবার পুলিশ প্রোটেকশন 156 করে দম বেরিয়ে
private affidavit of service has been
পিটিশনের নেই মনে হচ্ছে, পিটিশন আছে ও আছে।
I'm appearing on behalf of the private respondent number 7 to 12.
কি হয়েছে? কিছু হয়েছে?
Yes, my lord, there are complaints, counter complaints. My lord, in both cases, my lord, FIR has been registered.
Your Lordship,
After 12/3/2025, case has been registered. Just check that, because over here,
Yes,
I find
my lord, the case has been registered in respect of a complaint made by the writ petitioner on 19th of April. And in respect of a complaint made by the private respondents, a case is registered on 20th January 2025.
page 97 come. Page 97 of the writ petition.
Page 97, my lord.
You see, there are two dates over here.
Yes.
10/3/2025 and 11/3/2025. The main accusations are that the students and the teachers were threatened. Have you dealt with that as subject matter of the FIR?
My lord, the complaint has been registered. This is under investigation.
No, but then the subject matter may be different in different cases, sir.
My lord, kindly appreciate this.
Your lordship,
Now, my lord, the petitioner has made several complaints.
Several complaints
He's
complaints relating to the same incident of the students and the teachers feeling
So,
insecure.
my lord, I find that this, my lord, the complaint, the narratives do changes. His prayer in the writ petition is this, that complaint has to be registered in respect of a complaint made in being annexure P7. Now, annexure P7 starts from page 38 till page 140. Now, 38 to 140, my lord, there are several complaints. That is his specific prayer in the writ petition.
Lordship, if I may.
Yes.
And my lord, the narrative changes. My lord, let me make
Complaint, your
submission.
Lordship. Lordship kindly sees they have registered an FIR. I have a copy of that, but the
which number?
Then page 97, your Lordship, is referring to the March 10 and March 11 incident. They have registered, but why I'm seeking investigation by a different authority, Lordship kindly sees this and 97. It has been received by the Amdanga police station on 15th February March 2025, as per as per page 97. And in this,
Just 1 minute, 1 minute, 1 minute.
Is on received on April 19.
19th আছে তো পেছনে পাতায়।
Yes, my lord, 19th April. That
is his complaint. You are pointing to him. 19th April.
Yes.
Is in relation to the petitioner. The complaint during for
Yes, the complaint
the above noted
lodged,
trust
FIR lodged
entered into the college premises and has taken
that
some
is in
action
respect
following
of
an
a
old
complaint made by the writ petitioner.
19th April.
Yes.
I did not make, your Lordship, I did not make that complaint on 19th April. I made that complaint on 15th March 2025. The stamp is specific on that at page 97. They are saying in this particular complaint, your Lordship sees, they are saying they have received it on April 19th.
No, the informations relate.
Information received on April 19th.
In my report, 10th of March and 11th of March is written over there.
That is written, your Lordship, but they are saying that they have received it on April 19th, the information. When this complaint was received, although their stamp in the my writ petition, it shows March 15, 2025. And your Lordship kindly takes up the other complaints once at page 80.
ভয় দেখায় এবং অফিসের তালা ভেঙে না এটা
Your Lordship, at page 80.
Already you submit a subsequent progress report, sir. Let them, you investigate, come up with a comprehensive report.
At page 80, they were
So wanting transfer of investigation, I have got to check, sir.
Yes, your Lordship, but the other complaints with regards to Castis remarks,
I will see, let them submit a investigate. They have just 19th of April is not very
if your Lordship so pleases, certainly I will come back with the progress report. But my lord, prayer is very specific. Now the writ petition that they have to register complaint. The complaint
no. CID they are wanting.
No, my lord, Lordship kindly sees. First prayer, annexure 7 made against the private respondents by initiating a criminal case. Amdanga police station to investigate, or in the alternative. So, my lord, this is the specific prayer. Lordship, page 15, prayer A. Or first prayer is register a complaint. Let the Amdanga police station investigate. So, my lord, on 19th of April, complaint has been registered. Let the police authorities investigate.
This college is operating or no?
My lord, yes.
তাহলে একটা রিপোর্ট পাঠাবে কলেজের ঝামেলা তো একটা অনেক লোকের লাইফ আছে
Your Lordship, one thing
let them submit a
regards to
progress.
criminal intimidation, caste remarks, they had pointed a gun
I'll
at
see
page
the
80 on the
complaint.
complaints. Denying it, Your Lordship. They may be considered a
Petitioner petitioner has approached the AS court as the information which was furnished on or about 15th of March 2025 was not acted upon. State has submitted a report which reflects that Amdanga PS case number 303/2025 has already been registered for investigation. There are several other criminal cases which are pending inter the parties, which is also reflected in the report submitted by the state. However, since the subject matter of the case relates to a college and number of criminal cases pending, let the state come up with a progress report on 2nd of July 2025 when the
And
writ petition will
Your
appear
Lordship,
under the heading for
Your
orders.
Lordship,
Chalo.
police protection, what they did was by
Pilot,
these
pilot.
criminal intimidations, they have not allowed me to
No
come.
police protection. The police authority is in the
And they have
meantime
sent,
no protection. Police authorities would ensure all that there
Your
is no
Lordship,
breach
kindly,
of the
Your
peace
Lordship, kindly help
and
me
or
just for 30
any
seconds, Your
untoward
Lordship.
incident.
They have sent an expulsion notice by not preventing me from.
That is not my job to see.
I am not able
And
to
of
enter
any
the college. I am the lifetime
Good,
trustee,
ma'am.
Your Lordship.
No, these are subject to
I am
correction,
the
my lord.
lifetime
These are not
trustee.
the subject
Your
matter of the
Lordship, kindly
police in
this
action.
page
He has to go before the appropriate bench.
The body. Yes. Who is for the state?
Your Lordship, I am for the state, Your Lordship.
Yes,
Your Lordship, 2022 civil suit pending, injunction order enjoined, no 151 for police protection. However, we have drawn a procedure under 126. Mr. Dotto is having the report, Your Lordship.
এই জমিটা ও জমিটা দিয়ে দিতে হবে
Kindly see 21, my lord. Kindly see 21, the ordering portion, my lord. Kindly. My lord, the plaintiff as well as defendant are also direct to maintain status quo with regard to the nature and character of the suit property, and they are hereby resistant from raising any construction.
চলে আসুন চলে আসুন
My lord, that is there, my lord.
No 151 preferred, Your Lordship.
My lord, representation kindly come to page 23. They are
Taking
giving
it,
construction. That's why, my lord, I have come.
Very-
Kindly direct the police to honor them.
ভেঙে দিতে বলবো
No, no, my lord, but they
সবাইকে
will not. They will not construct. My lord. Kindly see. Kindly
petitioner is
direct the police.
agreeing
to
by
see.
the fact that his representation dated 12/3/2025
Basically,
was not considered by the officer in charge of the Noida police station in spite of a status quo কি দিয়েছে? status quo order
ordering portion.
passed হ্যাঁ ordering ই
Not
দেখছি
getting raising
status quo order passed in partition suit 320 number 329 of
Yes, my
2022 wherein the learned civil judge senior division first court Behrampur Murshidabad was pleased to direct that the nature and character of the suit property should not be changed and also restrained from raising any construction on the say eight suit property. Happy as a in, on the suit property. Therefore, full stop. Petitioner is aggrieved because according to him, the private respondents are raising construction and the police authorities on being informed are not responding to the same. Full stop. In view of the civil court already insisting of the issue, petitioner would seek for police rendering police assistance from the concerned civil court. In case the civil court passes the direction upon the police authorities, they would the police authorities would respect, obey, and implement order. In the meantime, police authorities would see because of any illegal construction there is no breach of the peace and tranquility and not any untoward incident resulting in because of the strained relationship. With the aforesaid observations, WPA 8629 of 2025 is disposed of. Reports are submitted with a record copy of the report behind the road.
Grateful, Your Lordship.
Lordship, I am for the petitioner. The petitioner herein has come with a very limited prayer, that is to take strict legal action against the Pradhan of the Kalinaga Gram Panchayat for taking unlawful gratification in discharge of his official duties.
What is recommendation letter to কি হয়েছে কিছু হবে না তো everybody will come inside.
Allegations of bribe against the Pradhan.
Petitioner is petitioner is agreeing that in spite of informing the police authority is regarding the activities of the Pradhan of Kalinagar or Gram Panchayat wherein it has been contended that for issuing recommendation and letter the say aid Pradhan demanded aid bribe and or illegal gratification. To that effect, information was furnished to the officer in charge Uluberi police station, but till date no action has been taken. State has submitted a report. Report reflects that
Kindly see the second paragraph, last 3 lines.
Second paragraph.
Last 3 lines. But after completed an inquiry, a report was already submitted before the SDPO on 2/4/2025.
This refers to Uluberia police station dispatch number such and such. Has the
Petitioner is there, family received injuries on their person.
clearly indicated the story of bribe which alleged to be demanded by such and such in exchange of providing.
Acha, so far as the information will, so far as the it reflects that the SDPO conducted a SDPO which Uluberia SDPO in charge of Uluberia police station conducted an inquiry. However, no evidence were forthcoming from the petitioner. So far as the other issues are concerned, police authority is have taken steps. Person, and the petitioner's wife and other family members in respect of an incident were rescued, and to that effect, Uluberia PS case number 75 of 2025 was registered for investigation. Full stop. In case the petitioner has materials in his possession or chain of circumstances is leading into the accusations complained of against the Pradhan is concerned, petitioner would be at liberty to approach the jurisdictional court under the relevant provisions of law. Learned magistrate would consider the same on the basis of material also produced and exercise his discretion, adhering to the provisions of law.
Lordship, may
Since proceeding under section 126 has been drawn up by the police authorities would oversee that there is no breach of peace and or tranquility taking place any further. With the aforesaid observations, WPA 8634 of 2025 is disposed. Yes.
Lordship, may I get a copy of this report?
Reports are submitted, we kept with the 8634 of 2025. A copy of the report be handed over to learned advocate appearing for the petitioner.
Item number 15, Your Lordship, Mr. Partha, who is appearing for the petitioner, Your Lordship. Due to sudden death of his relative, my lord, is not.
Learned advocate appearing for the petitioner prays for an accommodation.
Not today, Your Lordship.
Not today, আমি আর পারবো না।
My lord, tomorrow he will appear, Your Lordship.
List the writ petition in the monthly list of July. The state is present.
My lord, kindly make it not today, Your
Of
Lordship.
July 2025 under the same meaning. Next.
16. Lordship, monthly list of July.
Under the same meaning, yes. Who is for the state?
I am appearing for the respondent number 5.
I'm appealing for the state.
Ragging. Yes, Mr. Ganguly, have you done anything? Ragging করেছে তো?
My lord,
Correct or incorrect?
We have to look at the
Antecedents.
I am for the
what
college.
he has withdrawn.
Huh?
My
He
lord,
has withdrawn his allegation. What has transpires from the documents?
my lord,
Yeah, but where is it?
Kindly see the book page of the report. The own writing.
So I'm accepting this, sir. You
my lord, may I just
withdrawal to the case lodged in Khorda PS and Barrackpur Police Commission.
My lord, may I for the college. My lord, what has happened, my lord? There is no question of ragging here. No question. I'll tell you what happened.
না না আর শুনবো না হয়ে গেছে
My lord, no. Difficulty is this: his attempt to suicide or whatever happened subsequent to this. His attempt. That's why I want to. Because ultimately, they are students, my lord. He has made complaints against the students, the other students. I'm for the college. What happened was, my lord, there was some fake Instagram post. According to the other students,
that is
no, that is the subject matter. My lord,
that is not the subject matter now. If subsequent events,
my lord,
From that the issue cropped up.
that is not the subject matter. Over year, the Shomodip Banerjee has died.
No, my lord. My lord, how did he, in his home, he is supposed to have taken 30 sleeping pills. How did he get access to 30 sleeping? Whatever, my lord.
Police has submitted a report.
And the college also, he has withdrawn the complaint. I have that.
He has annexed himself
Yes,
this
letter.
Report.
Last line.
It has been enclosed that a communication was made to the principal that the petitioner intends to withdraw the information lodged with Khordha Police Station and the Barakpur Police Commissionerate dated 22nd of March 2025. What are you wanting now?
21 of the writ petition, well, kindly see.
What are you wanting now? তাহলে go to এইগুলো কি?
He has not been hampered,
So that you have not said that to the principal. In case the আরে প্রিন্সিপাল কে বলতে হবে তো, পুলিশ যাবে নাকি? Where have you petitioner if he faces an inconvenience we would inform the
His father was called on second. We had a meeting.
The principal of the college who would assess regarding the inconveniences regarding the inconveniences faced by the petitioner and take steps in accordance with the college rules and regulations. Chalo.
But if a student doesn't talk with another student, can the college force the student? That is the only issue.
Report submitted 8 be kept with the record. A copy of the report be handed over to learned advocate appearing for the petitioner with the aforesaid observation WP 8656 of 2025.
Platforms are destroying this social media, Instagram.
17.
Your Lordship, item 17.
This is not a matter of police inaction.
Yes. Grateful, Your Lordship.
My lord, what has fallen from your lordship, my lord, I'll just pay, my lord, in spite of an order of my lord, DM, my lord, but the police has not.
That's not my job. That's not my job to see. Go before other benches, sir.
Yeah, Your Lordship, one humble submission, Your Lordship, one humble. A writ petition is not maintainable.
Subject matter of the writ petition do not fall within the classification and or determination assigned to the AS code. Accordingly, let the writ petition go out of list. Petitioner would be at liberty to mention the matter before the court having determination. Next. Ajay baje mamla amar kache. Next 18. Who is there?
I'm for the petitioner.
Is case registered?
Lord, no.
Hello. Why?
FIR has been lodged. We have sent it to the cyber crime. They are dealing with the matter.
The case has been registered.
So, only the GD has been.
They come with a fresh report. এটা তো ডিলারটা এইভাবে অ্যাপ করে সবাই থেকে টাকা তুললে আর
with regard to the allegation.
হ্যাঁ দেখো আমি নামবো যখন নিয়ে যাবো। কি হয়েছে?
With regard to the allegation regarding one person that he has been arrested with in connection with several other cases, I have personally inquired. No, nothing.
আর পার্সোনালি কিছু করতে হবে, প্রফেশনালি করলেই হবে। হ্যাঁ ঠিক আছে, সাবমিট আ ফার্দার প্রোগ্রেস রিপোর্ট।
Yes, I will, my lord. I will
see what is happening. I am not because এই ফেক জবটা একটা হেডেক বেসিক্যালি। চলে আসুন।
Fake identity card.
হ্যাঁ করবে পুলিশ আছে এখন, রেখে দিচ্ছি তো। 2 months time I am granting you. In the meantime, do whatever you want. The subject matter of the writ petition relates to a WhatsApp group created by a company named BNBE Group. According to the full stop. According to the petitioner, they took a sum of rupees 1.4 lakh for providing job as assistant under Amta Panchayat, along with all the educational documents. After the ad, there was no response from the concerned from the private respondents.
No. Not been made private.
From the from the said BNBE group. Consequently, information was furnished to the police authorities. An advocate appearing for the state submit that the police authorities are working and inquiring into the issue in detail. Also, later further progress report be submitted by the police authorities on 2nd of July 2025 when the writ petition will appear under the for orders. আর কেস রেজিস্টার করে যদি থাকে 140 দেখবে ট্রান্সফারটা, তারপর একটা কেস করে আর লোক কি পাবে, এর বেশি তো কিছু পাবে না, টাকা তো আর পাবে না। Yes, sir. 19.
Item 19, my lord, the petitioner intends to not place this application.
All right.
My lord, I couldn't get the written instruction from the petitioner.
But I'm recording your submission. করবে না কি করা যাবে?
Not press.
Not press.
But not will be in the embarrassing, my lord. I needed written instructions.
But then I've got to put it. I cannot call second time, sir. I've got huge number.
After the vacation, my lord.
After the vacation.
Monthly list of July, lordship, kindly keep it in the monthly list of July. In the meantime, let him receive.
I'll mention it.
Or go out of
get this. Not
if he wants to not press, it's
not press.
discretion of your lordship.
You are not pressing, na? আমি রেকর্ড করে দিচ্ছি। Petitioner has instruction earns. Learned advocate appearing for the petitioner has instructions at present not to proceed with the writ petition. Learned advocate for the state is present. Accordingly, WPA number 8710 of 2025 is dismissed as not pressed. চলো সাবা কপিস ফেলে রেখে লাভ নেই, অনেক মামলা জমে যাচ্ছে।
Your Lordship, I am for the petition.
বাহ,
I'm on behalf of
আর
the
কি আছে?
private, forceful taking of possession. They are trying to construct. I'm on behalf of the private respondent.
না, স্টেট কে আসতে হবে, প্রাইভেট রেসপন্ডেন্ট কি করবে? এই স্টেট not today, come tomorrow. Tomorrow. State
That is total bogus.
হ্যাঁ হ্যাঁ, ওই প্রায় সবাই বলে এদিকে তো।
So my title.
চলো চলো চলো, নেক্সট নেক্সট।
I am for the petition. Kindly see the photograph.
My lord, I am the private.
আরে স্টেট কোথায় গেল?
This is the photograph.
My lord, I'm paying for short passover, my lord. He's
আমি
coming.
ট্রাকে আছি তাহলে। এই ফাইলটা নিয়ে চলো তো, কারেক্ট করে দিন আমি টাইম। হ্যাঁ, আজ দ্য স্টেট অ্যাডভোকেটস টু কাম। সো একটা স্টেটের অ্যাডভোকেট নেই এখানে, 226 স্টেটের অ্যাডভোকেট ছাড়া হয়? এটা একটু কারেকশনটা করে নিয়ে আসছি।
I am for the petitioner, my lord, kindly see
I
photograph.
am for the state part.
Yes, hold on.
What they have done, my lord, the petitioner is the my lord, by virtue of order of this honorable court, the prescribed authority declared as the petitioner Borgada. Now, my lord, every time, my lord, what is happened when I cultivating the property, my lord, at the time of harvesting, they looted all the articles. Now, my lord, today, my lord, they are not only able to, my lord, terminate me in accordance with law. What they did, my lord, they, my lord, cut out the art and it is converted to the, my lord, the water body, so that it cannot be a cultivated property and the Borgada cannot cultivate the property. My lord, kindly see the photographs also, my lord, and my lord, they sold in the market without any obtaining any statutory permission from the, my lord, concerned authority.
So your title suit is pending, two title suit.
I filed title suit. There is an injunction to that extent also.
So have you informed that court? Why have you come over here?
No, my lord, kindly see, my lord, what they have did. My lord, they, my lord, cut down the art and, my lord, this is sold by through, my lord, the kindly see the photographs once, my lord.
My lord, may I submit, my lord?
Yes.
My lord, this is absolutely suppression of material facts. My lord, actually, there are two civil suit is there. One has been, at first, I have filed the civil suit. I got the order of status quo that has not been mentioned in the writ petition. That is suppression. Secondly, my lord, the Borgada, they have surrendered their Rastroy, their father has surrendered the Borgada, their right of Borgada. I have the deed of Borgada.
Status quo against whom have you obtained?
Against this,
So then if there is a status quo,
I got the
no,
been mentioned in the writ petition.
status quo in respect of what have you got?
My lord, they have tried to, my lord, I have purchased the entire
Very good. Status quo in respect of what? There is a civil suit.
civil suit, my lord.
At the status quo in this character of the status quo.
Kindly see this photograph.
On pedestal of the present facts and circumstances, my lord, order 39.
আরে what is status quo? Nature and character, something is there. Disturbing the ওটা তো কাগজটা দেখি কি বলছো দেখি। রিপোর্ট দিয়েছেন? So nature and character, you have changed the character of the land. How? You say you have lodged this case, civil case against this Vashov Loshkar.
Yes, this was of mass.
So if that is so, the status quo is for not changing the nature and character of the property. You have changed the character.
Since the entire land,
You-
they have no right, title, interest, and
That the civil court will see.
yes,
You have gone to civil court, but you have violated the order of the civil court because the civil court's order status quo is not to change the nature.
order, my
According to him, you have changed this into a water.
Only from the open market. Kindly see how, my lord, how much they have been done, my lord.
They are right of
They are accepting your contention excavation. Petitioner is agree that although two suits being TS 282 of 2018 as also title suit number ATS TS number 393 of 2017 is pending before the learning aid civil judge junior division Kagdeep. The private respondents have changed the nature and character of the property by excavating in the earth on the suit property is referred to in the civil suit. Full stop. Petitioner informed the CAM to the local police station, but the police authorities did not respond to the same. Learned advocate for the state has submitted a report. Report reflects that police authorities recorded GDE number 1028 dated 12/4/2025 and drawn up proceedings under section 126 of the BNSS. Learned advocate aid for the private respondents on the other hand submits that the petitioner's father surrendered the rights. Petitioner's father surrendered the rights of Borgadar. As such, the petitioner has no right, title, and interest over the property. Full stop. it is an admitted position that the civil suit is pending between the parties, and TAS 393 of 2017 has been initiated by the private respondents again by the respondent number 9 against the petitioner. Such being the situation, and an order being passed by the learned aid civil judge for maintaining status quo in respect of the nature and character of the suit property, and the complaint is to the extent that the character of the property has been changed. I am of the view that the petitioner will bring the same to the notice of the civil court for taking appropriate action for violation of the order passed by the civil court. Additionally, petitioner would inform the petitioner would be at liberty to inform the BL and LRO, as also the concerned authority is under the West Bengal Fisheries Act, for changing the character of the property if the concerned authorities are of opinion that there has been a change in the character of the property. They would inform the concerned police station for taking steps in accordance with law. With the aforesaid observations, WPA 8747 of 2025 is disposed of. Reports are submitted. Be kept with the records.
There is a threat of murder, that is kindly to that extent, my lord, kindly please directed to keep vigil for the matter. Kindly,
Police 126 is there. Police is keeping vigil. Sir.
already keeping. May fellow EDO service.
Every service, sir.
Time for the victim.
Yes.
I have filed a suit for partition and declaration, my lord. Learned
CS means
passed an order of injunction. I have annexed the order of injunction page 28. And
only
thereafter,
creating
my lord, I have-
disturbance, so disturbance and
Yes,
peace.
my lord.
Petitioner is aggrieved by the fact that in spite of the civil court directing the inspector in charge Mondir Raja police station to ensure that the order of injunction passed in connection with TS 193 of 2021 is not violated, comma, the petitioner is facing disturbances at the behest of the private respondents. To that effect, information was furnished with the police authorities. However, the police authorities did not respond to the same. Having a learned advocate for the private aid respondent submit that since the civil court is already insisting of the issue, the petitioner would in the circumstances is bring the same to the notice of the civil judge senior division Diamond Harbour, who is in CC of the subject matter of dispute. Learned advocate for the state has submitted a report reflects that police authority is on receipt of the information drew up proceedings under section 126 of the BNSS against the private aid respondents, having considered that the police authorities have drawn up proceedings under section 126 of the BNSS. I am of the view that the subject matter of disturbance, which is the main grievance of the petitioner, in respect of the peaceful enjoyment and be considered to the extent that if there are any breach of the peace and tranquility, the police authority would take steps in accordance with law. With the aforesaid observation, WPA 8803 of 2025 is disposal. Reports are submitted. Be kept with the record. A copy of the report be handed over to both the parties. Next.
23, my lord, I am for the petition.
Who is for the state?
But in a suit for partition, my lord, between the parties, my lord, preliminary decree has been, my lord, drawn up. My lord, by your, my lord, the advocate commissioner, my lord, demarcated the portions of the respective parties, and my lord, also, my lord, common passage. Now the problem is, my lord, my portion is backside of the property. So, my lord, I am, my lord, free ingress and egress through the common passage. The private respondents, they are, my lord, threatening us. My lord,
Your private respondent.
I am private respondent, my lord. By showing the preliminary decree, they are trying to construct boundary wall, my lord. Suit has not yet been finally decreed.
Not yet been finally.
No, my lord.
Even Milord,
preliminary
Next date is
petitioner
on 19th May, my.
huh?
Next date is on 19th.
আচ্ছা ভালো petitioner is aggrieved by the fact that the private respondents are violating the preliminary decree passed by the civil court and trying to grab the petitioner's property by flexing their muscles. Additionally, it has also been alleged that the free egress and ingress of petitioners are being obstructed at the behest of the private respondents. Full stop. Learned advocate 8 for the private respondents on the other hand submit that the final decree has still not been drawn up by the civil court in connection with আগে বলেছি PS 486 in connection with it partition suit number 486 of 2012, and it has been informed that the next day it is fixed on 19th of May 2025. Be that as it may, police authority is in know-how of the dispute between petitioners and the private respondents, and to that effect, it has been brought to the notice of the court by way of a report that proceedings under section 126 BNS has been drawn having by Nauda police station, NOWDA, having considered that the police authority is uh, keeping a strict vigil, they would ensure that no further breach of the peace and tranquility takes place and or any untoward incident results because of the existing dispute wherein the civil court is already insisting in of the issue. With the aforesaid observations, WPA 8814 of 2025 is সব বলে দিয়েছি যে এর বেশি আর কিছু বলা যাবে না রিপোর্ট সাবমিটেড বি কেপি দ্য রেকর্ড আ কপি অফ দ্য রিপোর্ট বিহাইন্ড both the parties চলো 23 হয়ে গেল
This matter, I am appearing on behalf of the petitioner. This
I am for the state.
is a very serious case. Respondent number 6 to 9 have been running a parallel government and parallel judiciary in the locality. But the same thing happened in 2021 and serious step was taken by this honorable court and also by the administration. What has happened in this case? The petitioner, before your lordship, is owner of a pond. Now, depthness of the pond was decreased and incident of theft was increasing. And there is a case of theft before the against the respondent also. The petitioner wanted to restore the depthness and allowed the pond to be dried, and depthness has been restored. Now, while the petitioner went to fill up the water through his submersible pump, the respondent number 6 to 9 raised objection.
So what will police do, sir? Pond police গিয়ে কি করবে আমি তো
Report is there, Millard. The
What have you
villagers,
Hear me, Malad, what is happening? Kindly hear me.
Millard, the villagers came there and raised, Millard, such demand before the concerned Millard petitioner. So there is no, Millard, such law and order problem, anything else, Millard. Millard,
no, but then he had been rearing the fish.
My lord?
He had been rearing the fish.
My lord.
That is pursuant to the direction of Justice Mantha, I believe.
My lord.
So, what is the problem over there? Why he is unable to carry on?
Millard, he is carrying out, Millard. Millard, kindly, if your lordship, Millard, kindly turn to Millard page 4 of my instruction.
Yes. 4.
Page 4, Millard.
Yes.
Millard, last second paragraph, Millard. On 17/4/2025, Rajan Hasda, your lordship got it, Millard? After that, along with 9 villagers came at Topun police station informing that they have some problems which was created by renovation of the
Krishnavati Borod Dighi by Dilip Lagra.
My lord. The problem he categorically mentioned as follows: height of the embankment is too high. As a result, the locals will not be able to use the water of the pond. Due to height of the pond, there will be flood-like situation during the rainy season, as there is no sufficient arrangement for draining out the rainwater in flood-like situation, and the houses will be get damaged. Due to renovation, some marks of the pond have been deposited in the land belonging to the other local residents, which needs to be cleared.
Take a copy, let him take out an exception. You take a copy.
And Millard, the last paragraph is very important.
The person who has sent this report in the pendency of the writ petition, and even after receiving the copy, taking gift from the respondent. Book, can't you see?
So this I don't see. This is when you take out exception to the report, you get the report. Take out exception. So there are certain grounds given. Grounds are also not very much acceptable to me. But you take out your preliminary objection in consonance with the informations which you have furnished before the police authorities.
Take a short date may be fixed. There is extremely urgency in this matter. Running parallel government and judiciary, they have given order.
Absurd.
Can you see page?
Wherever there is this
This rural dispute, my lord, the villagers used to come, my lord, very common feature.
Petitioner is aggrieved by the inaction of the police authorities. And as they did not respond to the information which has been furnished, a report has been submitted by the state, which reflects that the police authority police authority is claimed that the problem which was complained of has been taken
care of,
and communication has been made to the petitioner, which the villagers faced because of certain renovation work. Be that as it may, since there is a factual dispute between the information furnished to the police authorities at the behest of the petitioner and the reports submitted, a copy of the report be handed over to the learned advocate appearing for the petitioner. Exception, if any, be filed within 2 weeks. Rejoinder, if any, 1 week thereafter. Release the repetition under the heading for orders in the monthly list of June 2025.
Mobilized.
Affidavit
of service file we kept the record একটু লিখে নেবেন
Deeply obliged.
Yes. Learned advocate appearing for the petitioner prays for an accommodation.
I am appearing on behalf of the respondent.
List the learned advocate for the private respondents.
Respondent number 7.
Private respondent 7 is present.
I am the private respondent.
Private respondent 9. Private learned advocate for the private respondent number 7, comma. The private respondent 9.
And state respondents in 25.
I am both.
State respondents in 25.
And the learned advocate for the state
I am respondent 10.
is present. Since an accommodation has been in sought for on behalf of the petitioner, list the repetition in the monthly list of July 2025 and at the same meeting next. Chalo, next. July.
47.
Grateful, my lord.
Yes, come.
My lord, I'm appearing for the state. My lord, I'm appearing for the state, my lord. My junior is there to submit you the report, my lord.
Case nahi to.
My lord, execution case DW already has been reissued by the learned court, where mis-execution case number 663 of 24 pending before the learned judicial magistrate at Court Alipur. And my lord, on 22/4/25, DW was duly executed by SI Arif Ahmed of Bishnupur PS. He visited the residence of the warranty, a private respondent in presence of local witnesses, and conducted a thorough search. During search, no movable property belonging to the warranty was found at the premises. And Neil Caesar, Annexure B, my lord, and kindly come to Annexure C. My lord, kindly come to Annexure C, the compliance report, my lord.
September 10th of
And
September
my lord, in
subsequently informed the commissioner.
Separate explanation report, my lord, Annexure D, my lord.
56 clause 3 of Criminal Procedure Code. Order given on 8th of August 2024. Thereafter, no case was started. I came before your lordship and the case was started. But my lord, no progress so far regarding.
Sir, that went from, I'm telling you, that CJM's order of 156.3, which was dated 8/8/2024, was received by Goriahat Police Station on 24/4/2025. Yes.
Then and there, my lord, we have
Memo number you show me. Memo ever different. আরে ইনফর্ম করলে হবে না, কোর্টের প্রসেসে যেতে হবে তো।
through court process.
হ্যাঁ
My lord, I have served on the next day to my lord.
There is a memo number 608. I cannot their process. You understand?
I understood. But my lord, the fact is, kindly appreciate the
ঠিক আছে, এখন investigation হোক, পরে যাবে না।
on 8th of August.
চলে আসুন। Petitioner is
Malad, next date is fixed on 8/5/25 before the learned judicial magistrate 8 court Alipur.
Allegations, and I am appearing only for branch manager. Role of branch manager was confined to introduction only.
ঠিক আছে, 120 তে চলে আসুন।
Lordship, it was his role to introduce relationship manager. It was branch manager's role is to introduce relationship manager. But after that, what she has done, because of this, we have started disciplinary proceedings and we have dismissed her because this lady.
Petitioner is aggrieved by the inaction of the police authority is and
A report only can be called for
My lord, a compliance report also annexed to D, my lord. And my lord, police is under investigation and it is in progress, my lord.
2 days back, my lord, case has been started.
24th April, 21 week.
No, my lord. I
24th
strongly oppose to the petitioner's aspersion, my lord.
Aggrieved by the fact of the manner in which money has been siphoned by duping the petitioner at the behest of the respondent number.
Number 5, she's a relationship officer.
Who took the money? 5 or 6?
Five took
By
the
the
money. She
respondent
is no
number-
more in service.
By the respondent number 5, petitioner alleges that the respondent number 6 introduced respondent number 5
Owner from Axis Bank.
against
It is
whom
the duty of branch manager to introduce RM.
against whom several allegations have been made in the letter of complaint addressed to the police authorities and the application under section 156(3) of the CRPC filed before the learned CJM Alipur. Petitioner's further grievance is that although the order was passed by the learned CJM Alipur on 8th August 2024, yet the Godihat police station did not register the case. State has submitted a report. Report reflects that Godihat PS case number 74 dated 24/4/2025 under section 420, 499, 120B IPC has been registered for investigation against the respondent number 5 and 6. Full stop. The reason assigned by the concerned police station is that the order sheet dated 8/8/2025 was received by memo number 608 dated 8/24/2025 by the Godihat police station. Learned advocate 8 for the petitioner submits that communication was made pursuant to the orders passed by the in respect of the orders passed by the learned CJM Alipur. However, in view of the fact the case has already commenced and the petitioner's grievance is being addressed in respect of the huge amount of money which the petitioner complains has been siphoned by way of misrepresentation and or
Let the petitioner give blank check.
by misappropriating the amount which belong to the petitioner and her family members. I am of the view that the police authority would put in efforts for exhausting the issues canvassed by the petitioner, particularly with regard to the culpability attached and take the investigation of the case to its logical conclusion. Full stop. Since the preliminary grievance of the petitioner has been addressed, further pendency of the petition at this stage is unwarranted. If the petitioner is subsequently agree, if the petitioner is subsequently agree, if petitioner would be at liberty to approach the court with further praise. With the aforesaid observations, WPA 8910 of 2025 is disposed of. Reports are submitted. We keep the records. So,
Gratefully, your lordship. Gratefully, your lordship.
Yes. Pass.
Boundary wall around their own land.
State, you are waiting for the state. আর এই তো এসে একা খেলছে সকাল থেকে ও।
There are 2 or 3. I went over there in other court.
Definitely, it construction intended to go into
Their land, the private respondent restraining them, only strip some part of it.
কি হয়েছে কার জমিতে
Private respondent number 4.
জমিতে ঢুকে পড়ছে
Undivided property without taking the report of partition.
Do I have to submit anything? Milord?
এটা রেকর্ডে রেখে দিই
See to that, Milord.
petitioner is agreed by the fact that petitioner that the private respondents are interfering at the time when on the boundary wall is being raised by the petitioner. On the other hand, learned advocate appearing private respondents respondent must prove that the property is an undivided aid property. As such, the issue related into demarcation of the property consequently petitioner has rightfully interfered at the right, that is his submission, rightfully interfered at the stage when boundary wall was being constructed. Acha, petitioner has additionally alleged that he is being threatened when he goes to his office by the private respondent, and the boundary wall which was being raised has also been demolished. It has submitted a report. Report reflects at report reflects that proceedings under section 126, 135 has been of BNSS has been drawn, and the petitioner has also filed an application under section 132 of the
BNS. Local inquiry has been held and
the police authority have conducted an inquiry and submitted a report before the examination. Be that as it may, primarily the issue of boundary wall is a dispute to be adjudicated by the civil court. Police authority would only oversee that there is no breach of the peace and or tranquility and or any untoward incident resulting from a civil dispute existing between the parties. Having considered that there is a threat perception which is being faced by the petitioner, I am of the view that that in case further informations are furnished, police authorities would take steps in accordance with law. With the aforesaid aid observation, WP 8924 of 2025 is disposed of. Reports are submitted. Be kept in the record. Copy of the report দিতে হবে কিন্তু এই মামলা
definitely
to both the parties.
Milord, in the BNS or BNSS, in the draft copy, I have heard the Lordship have a greater contribution to that extent.
কি করা যাবে
I have heard so.
Yes, after a long time since the morning বাবা ওখানে ব্রিফ দিয়ে দিচ্ছে এখন
I appear for the petitioner. I appear for the petitioner with Mr. Shabir Ahmed. There are two angles to the matter. One is the constitutional angle, one is the criminal angle. A person has been, Milord, taken into custody
yes, please.
completely in breach of law. Completely in breach of law. Let Mr. Ahmed address in that event. If I am not audible.
Now, Mr. Bhatt, this is blood violation of Vihan Kumar's blood judgment, blood what has happened in this case. The Lord try to take blood the certain list of dates.
From the father of the বিয়ান কুমারে কি হয়েছে এখানে অ্যারেস্ট হয়েছে
But please see page 100 first. They came to your lordship's court
without any delay and transferred to Park police station. Yes, it is what you mentioned.
And the envelope in the envelopes with the report which was submitted before the court below, that was annexuary.
Police because of their atrocities.
বিশ্বরূপ মণ্ডলের তো হ্যাঁ what are you wanting জোর করে বিয়ে করবে নাকি আমি বুঝতে পারছি না
No, I don't want that. That's the reason.
What are you wanting? What is your prayer?
The Lordship would kindly
see the prayer.
Action of the police authorities, primarily blood quashing. The second is blood. There are grounds, blood. The second is police officials. The hiring police officers.
To be illegal for now. এইটা করুক এটা একটা ডিসাইড করে দিই নাহলে প্রবলেম হয়ে যাচ্ছে
Kindly do that, blood.
You file and ask your officers to prepare no arrest again arrest. This is a problem I'll be facing, you understand. 2 months time I gave in that matter. Nobody is attending to that. You come to the prayer page 34. ওই একই পয়েন্ট সবাই নিয়ে কিন্তু খালাস নিয়ে চলে যাবে।
Arrest of the petitioner dated so and so, petitioner to be illegal for.
This is something
from
more
the
in
Article
this
20.
particular. But I'm aware about that judgment, blood. But this is something more.
You file affidavit in opposition, sir.
Let
So
them
far as
find-
the arrest, Lord, I'm not found anything in the report.
That is what I'm on. They say that is what is said. Arrest of the petitioner dated 25th November 2024.
But I have not found in the report. And in the envelope, I do not know Lord, what is there. But in the envelope, annexure A.
এই এটা খুলুন তো একটু।
the report.
Must be the 160%.
You, Mr. Arrest has been challenged. খুলতে হবে না। Arrest, you
No,
filed.
whether arrest at all, Lord.
Arrest, Lord.
You have been arrested.
Has arrested
কোথায়
immediately.
মেমো অফ অ্যারেস্ট কোথায় আছে?
I was in custody. I've been.
আরে show me the memo of arrest, not the problem in the order sheet. 25 the victim কবে 7th August
You see the order of bail, Lord. I mean,
page
page Lord,
19A.
118.
118
18.
এগুলো সব মিস্টার ব্যানার্জি, this is a troublesome. All these cases I am putting under affidavit in opposition.
So 119 Lord Kaveri Mondal. Surrender and Lord the
I'll
victim girl আছে 7ই নভেম্বরের অর্ডারটা কোথায়?
Lord, she would kindly take, Lord.
25/11 an application section 483 on behalf of the accused person in connection with registration 110 come to 100
110 and 100 and production warrant.
এটা তো এটা anticipatory bail.
anticipatory bail.
You are granted anticipatory bail. কি না না
111.
হ্যাঁ 111 you are granted anticipatory bail. কি না না বলছি?
Custody.
Yes. No.
The petitioner may find bail upon furnishing bond of
Furnishing bond of rupees so and so.
this Vishwarup Mondal.
Yes.
This is the same person.
Session judge.
আরে anticipatory bail পেয়েছে তো।
3.
ও
483.
Are the landed one we have the petitioner? He was
148 is the bail bond filed.
she did not make any statement which neither any bail application is pending, relying on the CD. This is order dated.
This is order dated blood 20th 12 2024. This is bail blood 483.
Oh, 483.
Top blood your
এইখানটা হয়ে গেছে তো অ্যারেস্টের অর্ডারটা কোথায়?
এটাই তো বলছি
114.
Where is the inspection memo? You are challenging this?
Nothing has been supplied, but that.
All right, you sir.
Let them come, Lord.
Let them come. He has to satisfy first. He has to satisfy for his case. Thereafter, Lord, the coming question of coming blood will arise.
এগুলো these are here. This I am. এই মহা ঝামেলা হয়ে গেল এই
First
একটা।
information report. There is no arrest memo, nothing else.
You submit the all the documents in a. I'm
get a
keeping.
certified copy.
Keep it.
I'll file a supplementary affidavit.
File a supplementary. Thereafter, I'll take the motion. I'm keeping it after 10 days.
Next week, Lord.
10 days will next week. 4 দিনের সপ্তাহ এটা। হ্যাঁ।
Come back on 14th.
List the repetition under the same heading on 15th of May 2025.
No, Lord, he will come supplement. I will file supplement. I will kindly record that.
I'm petitioner will file a supplementary affidavit incorporating all the order sheets and the documents which are in his
And the
custody.
report will file will be kept on.
Chronology 7th order is not there, sir.
না বললে দে
That production order. That I've seen.
My lord, kindly, I'm the private respondent. Can directly supply copy of the
No
report?
report now. এই ল পয়েন্টের মামলা হবে এটা রিপোর্ট দিয়ে আচ্ছা report submitted by the state be kept with the record. Come up with that, thereafter I'll consider. 14th
Case is that the even memo of arrest was not.
হয় নাকি? এতটা বাজে নয় গো।
নাম দিলাম যে
This case.
My lord, kindly directly supply copy of the supplement affidavit.
আচ্ছা সেদিনকে দিয়ে দেবে নাকি? Affidavit in opposition, I'll give a direction. I've given my mind. You will also get an opportunity, sir. Next.
Complaint against the parent. Parents come up with a complaint.
কি আছে? Next. Who is for the state? 30. State.
My lord, Mr. Basu Malik is for.
Huh?
Mr. Basu Malik is for state. He hasn't come to court.
Not today. Come tomorrow. Not today. 30.
My lord, I am appearing on behalf of private respondent number 6.
My lord, the affidavit of service. My lord, the fact is that I am the owner of a property.
এই ওনার অফ দ্য প্রপার্টি নিয়ে ঝামেলায় পড়ে যাচ্ছি আর হোয়াট ইউ
Property, opposite party has respondent number 6 herein. They have filed a suit primarily that claiming that they are the owner of the property. That was dismissed. This is for default. They have taken no step against that. They have filed another suit. That suit was dismissed. I have already applied before the Gram Panchayat for making boundary wall on that property.
বলছি যে বাউন্ডারি ওয়াল লাগে না পারমিশন করে
My lord, that was allowed.
পাপড়াগুলো
I only prayed for a police assistance
petitioner ঠিক
to make the boundary wall.
petitioner cultivation boundary wall petitioner complaints that the private respondents have initiated
Suit, my lord, kindly come to
several suits before the
two suits are dismissed.
several suits before the civil court which were dismissed. In spite of the same, they are trying to interfere and disturb the peaceful enjoyment of property of the petitioner. To that effect, petitioner approached the local police authorities as he intends to raise a construction of boundary wall. Learned advocate for the private respondent number 6 submits
My
that
lord, his sanction plan become invalid, my lord.
the same boundary wall abar sanction plan.
He applied for
Acha, the,
sanction plan, but the Panchayat authority sanctioned, my lord, house building plan. Only house building plan. And
Acha, petitioner or learned advocate respondent submits that the sanction plan of the petitioner has become invalid. As such, the respondents have raised objection. So far as the issues relating to demarcation of property construction, as well as raising construction, the same are absolutely domain of the municipal oblique panchayat authorities as well as the act of the civil court. Police authorities are not empowered to interfere with the same. Gallo, having considered that the petitioner and the private respondents are at loggerhead, police authorities would oversee that there is no breach of the peace and or tranquility and not any untoward incident resulting from the strained relationship existing between the parties. With therefore 8 observations. WPA কত 8956 8 of 2025 is disposed of. Report the সাদা copy.
My lord, unless an permission has been granted, my lord, may I not be able to prepare my boundary wall on that property?
Police will not grant you permission. Police will not grant you permission, sir. Next কে আছে?
32 my lord, I appear for the state.
Yes, sir. এই যে কত?
3,10,000.
Where is your complaint? Page
42.
informed when informed if I had drawn.
Yes. No steps has been taken.
No, everything. Lordship.
The relevant provisions 43A and section 66 of the IT Act has not been incorporated. Point number two, that no documents has been seized from me till date. No attempt has been made for recovery.
Kindly see.
And third point, I am beseeching your lordship to pass an interim order. Why? Now, I have lodged a complaint before the ombudsman. Now, ombudsman has not decided the matter. Till date, the bank is.
Complaint lodged.
Kindly see these 2 pages report thereafter. What steps have been taken?
Same report নাকি?
No, no,
Two are same things.
no, no, not towards same thing. It is
Oh, acha.
relating to the case started.
The acquisition for providing KYC details, all organization details of the concerned have been out of which
Mhm. Then Lord, kindly turn to page 37.
already case put.
37 and 38.
I've seen, sir.
Then
Kindly have a look at page 94 and 95. The
Hmm.
lady recovery agents, what she has said. Kindly see the language. For
she
my
आमी
satisfaction,
देगी.
there is one provision for Reserve Bank of India that unless and until the dispute is solved, I have zero liability. Now the bank has started an obligation upon me to clear the amount. Kindly pass an interim order.
That's why he has come.
That is not my
Lordship, kindly dispose it of everything is on.
petitioner is aggrieved as the police authority is did not respond to the complaint lodged on December 10, 2024 and December 11, 2024. Full stop. Uh, it is reflected in the records of the writ petition itself that police authorities have registered a case being Technocity PS case number 197 oblique 24 dated 11/12/2024. Achha. Petition the inspector in charge cybercrime police station Vidhanapur police commissionerate has submitted a report also which reflects that NCCR portal was also obtained by the petitioner, and consequently information and communications have been made to the authorities concerned. So far as the investigation of the criminal case is concerned, the accused have been traced at a different state. Permission has been obtained from the superiors for ready for conducting raid. Having regard to the steps being taken by the police authorities, I am of the view that the police authorities are working on the information so furnished by the petitioners. At this stage, no interference is called for from the court. Uh, Petitioner is directed to cooperate with the investigating agency, and the investigating agency are directed to put in substantive efforts so that the investigation of the case can be taken to its logical conclusion within a reasonable period of time. Not now, sir. Vital part of the investigation is going on. Otherwise, I would have given you. If this is circulated, it will be difficult. In fact, very vital part of the investigation is going on. I'm deeply obliged to submitted. We kept with the record. Next.
As for the petition, my lord.
Which Samasti?
Lord, affidavit of service. But my case is that, my lord,
I am filing with
after depositing the fee of 6,000, I have obtained the plan of boundary wall, making the boundary wall. Your lordship kindly come to page 21. From the appropriate authority, my lord, I have deposited the money at page 22. In spite of that, my lord, these private respondents are making obstruction to construct the boundary wall.
Petitioner is agreed by the fact that in spite of obtaining permission for construction of boundary wall, the private respondents had been interfering with the same and creating disturbance. To that effect, information was furnished to the police authority is, however, they did not take any steps. Report submitted by the officer in charge Bhangur police station reflects that the private respondents were asked not to obstruct the lawful work of the petitioner, and subsequently proceedings have been drawn up under section 126 of the BNSS, having regard to the fact that the police authorities have taken steps I am of the view further pendency of the writ petition is unwarranted. However, the police authority is would continue their surveillance and ensure that no breach of the peace and or tranquility takes
My
place,
lord, get
and or any untoward incident results because of the strained relationship between the parties. We therefore say 8 observations. WPA 8976 of 2025 is disposed of. Reports are submitted. We kept in the record.
grateful to your
Copy
lord.
of the report we handed over to learned advocate appearing for the petitioner.
Service is not completed till now.
Learned advocate appearing for the petitioner submits that service has not yet been completed. Accordingly, lists the writ petition in the monthly list of July 2025 under the same heading. Next. Next.
Well, in 35, I do not like to open the mouth before the petitioner opens, but this is the possibly the fittest case where Mr. Basu would be appointed as a millet receiver to the end. Lordship, kindly peruse the millet the enter petition.
The heirs and the legal representative of their mother who owned a plot of land, 1 acre near about, along with a pond. Now the petitioner's position is this: they are doing the pisciculture in that pond to earn their livelihood. Now the private respondents, particularly in the private respondents group, one private respondent 12, who being the employee of the police staff, police force, and at the help of with the help of the local political parties or some hooligans, they did not allow the petitioners to catch the fish. On numerous occasions,
Yes, what is your report?
they have
পুলিশ মাছ ধরতে গেলে মুশকিল। Theft of fish, if you have a case, sir, you have got to produce the materials. এটা cultivation এর মতো হয়ে যাচ্ছে না?
No, no.
You approach the learned magistrate. I am directing. Magistrate will see. চলে আসুন।
the only kind, at least
Breach of vigil they will keep. Vigil they will keep. So far as criminal case is concerned, you file 175(3) before the jurisdictional magistrate. চলে আসুন। Petitioner is agree by the fact that
what you want to say the maintenance of peace.
কি বললাম? Petition.
144.
I am directing, sir. Petitioner is agreed by the fact that the water body which belongs to the petitioner is being involved in pisciculture, and the private respondent, particularly the respondent number 8,
সেটাই তো বলছি।
has been who is having respondent 8,
12.
respondent number 12 having clout in the area is trying to create obstruction on both by theft of the fish in the water body, as well as hindering the rearing of the fish. Full stop. State has submitted a report. Report reflects that police authority is have diarized the information so furnished being GDE number 302 dated 5/9/2024 and GDE number 436 dated 7/12/2024. Asha, having considered the nature of the accusation made by the petitioner, I am of the view if the petitioner is in possession of materials, including witnesses, petitioners would be at liberty to approach the jurisdictional magistrate by invoking the relevant provisions of law for satisfying whether the cognizable or non-cognizable offense is made out. Learned magistrate would appreciate it and thereafter take steps by exercising his discretion in accordance with law. Full stop. So far as the law and order issue is concerned, police authority would keep a strict vigil and ensure that there is no breach of the peace and or tranquility and or any untoward incident resulting from the inimical relationship existing between the petitioners and the private respondents. With the aforesaid observations, WPA 8989 of 2025 is disposed of. Reports are submitted. We kept with the record. A copy of the report be handed over to the London Advocate.
But I thought since the dispute related to the fish, Mr. Bose would be appointed to look after the same without any remuneration, Milord.
Yes. Who's there? 36. Anybody is there?
Your Lordship, 36, I appear on behalf of the state, Your Lordship. May I be allowed to?
I pay for the private respondent number 6 and 7.
Yes. Yes, Mr. Kololbos. What happened? Green Garden Agro. Ki kore chamos?
Shareholder of a was the largest shareholder of a private limited company, 76%. Thereafter, my lord, the respondent number 5, who happens to be the wife of the petitioner. The rest of the share she used to hold. Subsequently, she sold it to respondent number 6 and 7.
What are you wanting?
So respondent number 6 and 7 are not allowing the petitioner to enter into the office premises and the rice mill of the company.
Bah. You are respondent.
6 and 7. The entire allegation is false, Your Lordship.
Sabai bole.
It's the writ petition is outcome of suppression of facts. The respondent number 8 is the company of
What
which
have
the
you done, state?
Your Lordship, may I submit, Your Lordship, a complaint was lodged on 1st of April, Your Lordship. Thereafter, Your Lordship, on 17th, the police authorities had sought for relevant documents, and on 25th of April 2025, Your Lordship, already a case has been registered, Your Lordship, under section 318(4), 316(2), 351, 2 and 3 of BNS, Your Lordship.
The case number, tell me.
Your Lordship, the case number is 131 of 2025.
The police station?
And the police station is Dadpur Police Station, Your Lordship.
Dated?
The only difficulty is, Your Lordship, the physical copy of the police report is not
131 of 25 dated?
dated 25th April 2025.
ঠিক আছে Mr. Basu, enough. চলে লজিক্যাল
Enter into the office premises.
ওটা কি হয় নাকি ওটা সিভিল কোর্ট থেকে যেতে হবে
entire allegation is false, my lord. It's suppression. There is a memorandum entered into between the parties.
I have not sold my entire share.
পিটিশনার ঠিক আছে যাবে ক্রিমিনাল কেস আছে ক্রিমিনাল কোর্ট থেকে পারমিশন পিটিশনার ইজ এগ্রি বাই দ্য fact that in spite of informing the officer in charge Radpur police station regarding the act and activities of the private respondents, no steps have been taken. Learned Advocate 8 appearing for the private respondent numbers 5 and
6 and 7.
6 and 7 and submits that the entire petition is suppression of material facts. On the other hand, Learned Advocate for the state submits that Dadpur PS case number 131/25 dated 25/4/2020 has been already registered for investigation. In regard to the fact that the investigation process has already commenced, I am of the view that the preliminary grievance of the petitioner has been addressed. Police authority will take the investigation of the case to its logical conclusion and would also keep a vigil so that no breach of the peace takes place at the local. Cholo. With the aforesaid observation, WPA 8991 of 2025. ওটা সিভিল কোর্ট থেকে নিতে হবে ওটা আমি দেবো না
Consider, my lord.
না হ্যাঁ কনসিডার করে না ওটা বাজে অর্ডার হয়ে যাবে
Handing over the instruction to course of
37. Write the item number.
My lord, I'm appearing for the state regarding item number 137.
Shobnam Devardhan.
You got a copy of the report?
Yes, sir.
My lord, my junior will hand over the copy, my lord. It's a long. It's a long dispute regarding land, my lord. Demarcation.
And his wife.
Opposite party assaulted the petitioner and his wife. Have you got the medical documents?
Medical documents, my lord. But 2 times that was happened.
A petitioner is agreed by the fact that in spite.
My lord, One indulgence, my lord, civil court already pending suit, my lord. Title suit 21724 before the civil judge, senior civil judge division, second court, and it is regarding the property demarcation, my lord. Inquiry revealed that kindly peruse my report, my lord, and it's a partition suit already pending.
And in spite
And
of
prosecution already Domkal PS NCR 702
advocate
25 dated 19/4/25 already
admits that
case registered
there is a long
under
standing
section 126 BSS.
dispute. However,
BNSS.
as the issue relating to physical assault is concerned, no steps have been taken by the police authorities. Learned advocate 8 for the state has submitted a report reflects that already suit has been already the civil judge, senior division, second court, Berhampur is insisting of partition suit number 217 oblique 2024. There are dispute related
702.
of the property. The police authorities have further disputed in respect of any assault which has taken place arising out of the dispute relating to the land. Full stop. Learned advocate for the private respondent. Learned advocate 8 for the private respondent adopts the contentions advanced on behalf of the state, having considered that report also reflects that already a proceeding under section 126 of BNSS have been drawn up by the petition have been drawn up by the police authority is, and they had been keeping us sharp vigil. Acha, in view of the background of the case, I am of the opinion that the petitioner would be at liberty to approach the jurisdictional magistrate since the police authorities have disputed the issue relating to assault. Learned magistrate would consider the accusations made by the petitioner after conducting a preliminary inquiry, and thereafter thereafter take steps adhering to the provisions of law. Police authorities would oversee and continue their surveillance so that no further breach of the peace and or tranquility takes place. With the aforesaid observations, WPA 9000 of 2025 is disposed of. Chalo, come after recess. I'll. কি হলো? কি হয়েছে?
35 may be taken up tomorrow subject to
35 তো বেরিয়ে গেল তো।
30, 42.
42 you keep a junior, নাহলে চলে যাবে কিন্তু। tomorrow স্টেট কে করতে, স্টেট যদি অ্যাবসেন্ট না করে tomorrow হবে। স্টেটের সাথে কথা বলে দিতে হবে। না হলে অগাস্টে চলে যাবে। স্টেটের সাথে
August month.
And the petitioner, my lord, the petitioner is my lord, practicing advocate in Barampur court, my lord. He dealing with the many cases, my lord. One person out of grudge, my lord, attacked her, my lord, husband and brutally, my lord, seriously injured. But the police authority, my lord, given the most of the, my lord, bailable section, the hard section is a 117 is a 7 years magistrate tribal case, and this he surrendered and my lord got bail, my lord. And thereafter, my lord, the threatened for withdraw the case. Thereafter, the petitioner, he is a practicing advocate, my lord. He also made an GD, page number 38. But that thereafter, after receiving also, my lord, did not take any steps for protecting her, my lord. So, my lord, given liberty
Husband
to
of the
make an
petitioner.
application before the appropriate court to adding the section and direction to the police authority to take steps if the private respondent
You go before the court. I am giving that.
Yes,
Petitioner
my lord,
is
to
a
give some protection, my lord. Private respondent not appearing, my lord. I made a party.
the
Affidavit
petitioner
certificate.
is aggrieved by the fact that the police authority is in spite of registration of Berampur Police Station case number 459 oblique 2025 dated 5/3/2025 has incorporated eight sections which have facilitated the private respondent oblique accused to be released on bail.
Yes.
According to the petitioner, the injuries which were complained of at the behest of the petitioner.
Case totally changed, but now he is also presently also admitted in the Apollo hospital.
Warranted appropriate sections to be incorporated aid in view of the injury is inflicted aid on the injured oblique petitioner. Full stop. Petitioner additionally it has been alleged that after release on bail the petitioner was threatened for withdrawing the case. For what?
Yes, my lord.
For withdrawing the case, and the police authorities did not respond to the same. Mr. Karan London advocate appearing on behalf of the state submits a report or reflects that
Case has been started. Investigation is on, my lord.
investigation of the
so far as his
126 देखिए दीजिए क्या बोला case is in progress relating to the subsequent information furnished of threats. A case under section 126 BNSA has been drawn against one Viman Das.
Viman.
VDA. Full stop.
THIMN.
Be that as it may, since the petitioner complains that he has medical documents in his custody to substantiate the nature of the accusations and the sections of BNA is to be incorporated, petitioner is granted liberty to approach the jurisdictional magistrate to take out an application relating to the sections which relating to the sections under which the case has been registered. If the learned aid magistrate on perusal of the materials produced before the court is of the opinion that there has been dilution of sections at the stage of registration of the FIR, in that case, learned aid magistrate would pass necessary directions upon the investigating authority. Full stop. So far as the other issue is concerned, there is police authorities have drawn up a proceedings under section 126 BNSS. However, having in regard to the fact that the petitioner is a victim.
Lady Miller, senior citizen.
Victim. Petitioner is a victim.
No, husband.
Petitioner being the de facto complainant. She's a de facto complainant. Petitioner being the de facto complainant and is a necessary witness to the case is entitled to apply before the learned magistrate.
She was not traveling with the car, my lord.
And she has lodged the complaint. She's a witness.
Yes.
As simple as PT. क्या बोला? Magistrate under the Witness Protection Scheme 2018, learned magistrate will call for a threat perception report, analyze the aid report, and pass necessary directions under the scheme. Full stop. Police authority. Next, police authorities will continue their surveillance and ensure that the petitioner is not faced with further untoward incident as complained of and which is being dealt with under the provisions of section 126 BNSS. Chalo. With the aforesaid observations, WPA 9006 of 2025 is disposed of. Reports are submitted. Be kept with the record. A copy of the report be handed over.
Only thing, Milord, if somebody, Milord, hackle, Milord, the petitioner, senior citizen, Milord, gives direction only police authority to take steps, or somebody unknown person.
I have given it to the magistrate, sir, already. Make an application.
আপনাকে ম্যাজিস্ট্রেটের কাছে পাঠিয়ে দিয়ে ওখানে যাচ্ছি পুলিশ
BNS.
More or less same, Milord, in this, in addition with Milord.
You mark it.
More or less same, Milord, another police station, but this is a Milord addition.
This is
with
not a
Milord
lawyer.
No, not.
No,
One
not
lady,
lawyer.
Milord, is a worker of the shop, Milord. She was also, Milord, tortured by the miscreants, Milord. She went to the police station, refused. Thereafter, Milord, page number, Milord, annex page number 12, annexure 2.
What happened?
These complaints are not, Milord, received by the police station thereafter.
Yes, my lord. Kindly see the report. The police case has started.
Sir, started, Milord, in respect of the complaint made by the other, Milord.
Both, my lord. PS case number 74 and 75.
In respect of my application, if any case is started, Milord, I have no problem. Yes, Milord.
What is your name?
Samprita, Milord, petitioner number
Bardhan.
1.
What?
Sampita Bardhan and another.
Sampita Bardhan.
One Zaid Khan submitted later. Complete.
Junaid Wasit.
Yeah. It a card. Petitioners have mentioned that the accused one.
Only direction, Milord, I short from Milord.
Yes, injury, the petitioner. If we are going to the available PC, it could be earned that. हाँ तो on Junaid Basid's complaint तो case has been
Case has been well, but my on the basis of my complaint, Milord.
you were both of you went together. There were two groups in the police station.
Yes.
There are two groups. There were two groups at the same time in the police station. One group is Junaid Basid, Abdul Ahad, Miss Shampita Bordhon Ria, and the other was Zaid Khan and others in another side. So far as your accusations are concerned, that would be adhering to the A's Abdul Ahad's accusation, Korea PS case number 75.
Later on, Milord, he make out this case, Milord. When immediately after Milord incident, Milord, I went to the police station.
Both
They, Milord, ousted from the police station. Thereafter made complaint to the deputy commissioner of police. What, Milord, on the basis of my complaint, what steps has been taken, Milord, you kindly take, Milord. Kindly give direction. On the basis of my complaint, will take into consideration.
Achha. Petitioner has approached the AA's court as
petitioner number 1. The complaint of the petitioner number 1 not considered by the police.
Where is your complaint?
Page number 12.
The 1917 you have enclosed.
No, there is another, Milord. I showing that, Milord. One FIR lodged, Milord. But
already lodged to our key.
But I stated, Milord, that police ousted me. Not interested to hear me. Thereafter, under compelling circumstances, I went to the Milord, deputy commissioner of police. I made a complaint to the deputy commissioner of police by stating inter alia the activities of the police authority, Milord.
So she's a witness. Approach the AA's court being agree that the information unfurnished on 27/3/2025 was not acted upon. State has submitted a report or reflects that two groups approached the police station on 26/3/2025, and Abdul Ahad was along with the present in petitioner. Abdul Ahad is a petitioner over here. Petitioner.
No.
No.
Here the Sampita Vardhan and Junaid Basit.
And
Junaid Basit.
Oh. Junaid, কি বলা? Petitioner, present petitioners. And on the other side, Zayed Khan and others, both at the same time went to the police station and narrated their facts. Full stop. Korea police station registered a case on the information furnished by Abdul Ahad, being Korea PS case number 75 dated 27/3/2025, and on the complaint of Zayed Khan, registered Korea PS case number 74 of 2025. Acha. Petitioner now alleges that the superior police officer should act on the complaint which has been registered, which has been lodged against the officer in charge of the said police station for not registering FIR. Since a case has already been registered, being Korea PS case number 75 dated 27/3/2025. So far as the main incident is concerned, I am of the view that the merits of the case at the stage need not be gone into. But there is one contention regarding insecurity which has been raised by either petitioner number 1 to that effect. The police authorities would ensure that she is not faced with any inconvenience is because of the criminal case being registered against the accused persons.
But in respect of the section, my lord, I am same.
Section,
Lord, kindly say the head injury serious, my lord. Lord, bailable section, most of them surrendered, got bail, my lord. Page number 15, my lord, kindly see 14 and 15.
কি head injury হয়েছে
Head injury, my lord, scalp injury.
স্কাল্পে কি ইনজুরি হয়েছে? অ্যাব্রেশন?
Now also he admitted, my lord. My lord, kindly see page number 15, my lord. History of the assault of the sustained head injury on such and such date.
Likely.
By some unknown persons and details, my lord, history, my lord, page number.
That's Junaid Basit, who's Junaid Basit's injury?
In respect of the case, my lord, assault someone, my lord,
All right, তাহলে বলে দিচ্ছি।
point to my lord,
Petitioner, all right, petitioner would be at liberty to submit the medical documents to the investigating officer of the case, which shall be within a week from the date produced before the Deputy Commissioner of Police, who would assess whether proper sections have been incorporated while registration of Korea PS case number 75 of 2025. Hello. With the aforesaid observations, WPA 9008 of 2025 is disposed of. Reports are submitted. We kept with the record. Server copies next. হয়ে গেল দুটো তো বলছো। Yes, sir. Yes. Who is for the state? Mr. Ganguly, yes. What is your accusations?
Lordship, what has happened is, Lordship, I have agreed. Lordship, I have entered into a loan agreement with the private respondents herein. Your Lordship, an amount of rupees 51 lakhs was sanctioned. Subsequently, he has defaulted in payment of the tranches of the installments. His account was declared as NPA. Thereafter, I have issued 13-4, and thereafter I have made an application under section 14 of the Surface Act, Your Lordship. Your Lordship, that application was disposed of, directing the Lordship, the order under section 14 is at Lordship page 14. Lordship, kindly see.
Yes.
Yes. Your Lordship, directing the respondent police officers to grant me necessary assistance for taking possession of the scheduled mortgage.
Page number?
14, Your Lordship.
14 is the district magistrate's order.
Yes, section 14 order, Your Lordship.
Thereafter?
Thereafter, Your Lordship, I have deposited the requisite amount for police cost in TR form. Your Lordship, thereafter, I have made but apart from, in spite of depositing the police cost, Your Lordship, the police is not rendering me assistance in taking possession of the mortgage asset, Your Lordship. And subsequently, I have made representation, which is at page 18 on 27th of January. No reply was given to such, and thereafter another writ petition I have given, which is of 7th of April. And also,
Yes, Mr. Ganguly, what has happened?
Kindly have a look at the second page, paragraph 5.
Yes.
Deputy Magistrate himself was present. At that point of time, some dispute arose. He himself postponed the date of handing over the possession. Thereafter, my lord,
At the same
paragraph
time,
7
some
and
local
8.
raised objection as there was no demand.
Lord, may I?
Then the Deputy Magistrate, Mr. Raja Bhumik.
So, authorities also.
Milord, I am the reason why, Milord, the order was not complied with. Milord, what had happened here is pure fraud. 2015, by a registered deed, after taking a home loan from LIC, I purchased this property. I am in possession of this property. Property is mutated in my name. Electricity connection in my name. Everything is in my name. One fine day, my lord, I find that some third party has allegedly purchased the same property in 2019 with a loan from, my lord, Aditya Birla Finance.
No, that is something different. You go to the tribunal and
No, I have filed, my lord, can number 1 for intervention because this order cannot be enforced. It is without jurisdiction. I am also filing a writ petition tomorrow challenging all of this.
No, but that you go to the DRT because
So I don't have to go to the DRT. This is the judgment, my lord. Kindly, I'll show your lordship. It says, my lord, that where there is no mortgage created, sorry, the copy chalega. Where there is no mortgage created, section 17 doesn't apply. I don't need to go to the DRT. My lord, please see paragraph 10. Now, in view of the aforesaid fact, we find paragraph 10, my lord, we find that no valid mortgage was created in favor of IDBI Home Finance in respect of the flat in question, either at the instance of the writ petitioner or his predecessor, who was undisputedly the owner of the property. The IDBI Home Finance, as it appears from records on the basis of an agreement with two persons, Gautam Kumar Bose and Bharati Rani Bose, exercise its right under section 13 of the Act, although by virtue of such agreement no such right accrued in its favor. We are of the paragraph 11. We have the view, in fact, of the present case where a citizen of India has been harassed in this way, dispossessed from property. 13.4 would not apply. Such a citizen is not required to go to alternative remedy provided under section 17. In the case before us, neither the writ petitioner nor her predecessor had ever secured the property in favor of IDBI Home Finance. And as such, its act was on the face of it without jurisdiction. Therefore, this is not a case of adjudication of a disputed question of fact, but on the face of defense made out by IDBI Home Finance Limited itself, it appears that it had no subsisting valid mortgage in respect
right
of
now you don't have a court order in your favor.
No, he also did not have. I mean, may I just show your lordship can one?
Then you are locally very strong. You have
No,
yes.
Milord, there is no question of local strength, Milord. My strength is in my documents, Milord. Please have a look at can one.
That is something else. That's the police authorities went so many times.
Sir, may I just show can one, Milord? He's coming for enforcement of a section 14 order. Milord, may I just, I filed can one. May I show your lordship just 3 documents?
No, sir, I'm not going.
No. Milord, please take can one once, Milord.
Sanjay Kumar Shaw was being residing in the Whom have you made a party, sir?
Lordship,
May I just take 2 minutes?
One
Milord?
minute, 1 minute.
Lordship, all the private the only one indulgence, Your Lordship, if I may appraise Your Lordship, I have also tried to serve all the private respondents, but the item has returned, Your Lordship. May I be permitted?
With whom have you entered into agreement?
I have entered into the agreement with the respondent number 4, Your Lordship. Private respondent number 4, Your Lordship. Abhay Kumar, he's the principal borrower.
That's Milord at page 79 of the can. I found that document. It's page 79.
Say did and
Milord,
put
4
the-
years back, I have purchased the property by registered sale deed. Property is mortgaged with LIC. And I've been paying installment for
From
10
whom
years.
have you purchased?
Milord, from the vendor. Milord, please see my application. Milord, the developer of the property. Milord, kindly take, Milord, page 60, 616 of can 1.
So somebody else is deciding how can you take the property, sir?
Lordship, I have no instruction.
Your due diligence was poor.
Yes.
Lordship.
As simple as that. Your due diligence was poor.
The Lordship, the only thing is that in my humble submission is before Your Lordship is that even any dispute as to my section 14 order was bad in law or not has to be challenged before DRT. As my learned senior has placed his case, Your Lordship, the only thing is whether the question of his instrument.
Leave aside him. Even the police is unable to execute. If the property is not named in your favor, I mean, the person whom you have lent, the person who has mortgaged the title deed, then only they will be able to execute the order. Police authority is, if certain other persons are staying over there and they are able to show title to the property, how will police authorities act, sir?
Your Lordship passes necessary order. With my instruction, I can act according to my.
You have got to fight here because your documentation was poor, your due diligence.
My representation is to be considered in accordance with law. If the police
No, there's no question of consideration. Should be dismissed.
Four times police authorities had been there. 4 times. That's what's in the report. There are GD entries.
I have no instructions as on that, Your Lordship.
Let affidavit in opposition be filed by them. Exchange of affidavits, let it take place. Thereafter, I'll consider.
Milord, may I? Milord, only one thing, Milord. May I be permitted to file a supplementary affidavit? Reason is this. In my petition, by mistake, I said that I have purchased, it's without any encumbrance. That's Milord, a mistake. It's mortgage to LIC Housing Finance, who is also a necessary party. Milord, may I bring those documents on record with this?
You've got to be added as a party. Chalo, aage add kori party.
Lordship, one indulgence, a copy of the application for additional party.
Of course. সবাইকে copy দিয়ে দাও।
Acha, in view of the contentions advanced on behalf of the applicants, I am of the opinion that they are unnecessary a party a to the writ petition. Accordingly, the applicants be added as a party. You bring that in your affidavit in opposition. How can you now file a supplementary?
That's true, Milord.
I'm granting you liberty to file affidavit in opposition.
No, only Milord kindly records that. Otherwise, that's absolute perjury on my part. Because I have said I am the owner of unencumbered property while I have mortgaged the
Learned
property.
advocate submits the ad. There has been an inadvertent mistake in the application being as ECA in 1 of 2025 is allowed for them. Learned advocate 8 appearing for the added respondents submit that there has been an inadvertent mistake in contending that the property is unencumbered while the applicants have availed loan facility from LIC Housing Finance Limited. Be that as it may, let affidavit in opposition be filed by the added respondents. Petitioner would be at liberty to file affidavit within before vacation, not possible, sir. By 9th of June, by 9th of June 2025, let affidavit in reply be 2 weeks or 3 weeks. Affidavit in reply, I'll be not there also. Affidavit in reply be filed by 30th June 2025. Matter be listed under the heading hearing in the month list of July.
Copy of the report, police report.
কবে হ্যাঁ আচ্ছা রিপোর্ট hearing করে দিলেন report submitted aid by the state be kept with the record. A copy of the report be handed over to learned advocate appearing on behalf of huh?
You don't have to file any opposition to this.
No, private respondent.
Yes, we are moving a writ petition, we will have to get everything quashed.
No use taking, they won't be able to execute. Their inspection was, searching was poor.
These are all some nexus between one or two errant employees of these financial institutions
And the developers. And the developer.
And the developer.
41. Nikki. Yes, what is it?
I'm on behalf of the petitioner, my lord.
Yeah.
My lord, this matter relates to the police inaction, my lord, in fraudulent action by the bank manager in convenience with the loan consultancy people. And my lord, their action is to dupe and allure the poor village people to grab their property and to give them and to allure them with exorbitant loans, my lord. Like a 20,000 property, 20,000 valued property, he has obtained 9 lakh rupees loan, and then from the bank they extract.
What is your grievance against the police? Tell me.
My lord, I had given different representations to the police, my lord.
Which is your representation?
My lord, from page 24 to 29, the victim has given the presentation, and page 30, I had given the presentation on his behalf, as he's fully. He's a layman, my lord.
Yes, have you done anything?
This representation never reached to us.
How have you sent this?
My lord, I have the affidavit in service, my lord. Everything is by through post, my lord.
Where is that over here? Where is that in the writ petition? The postal receipts.
Postal receipts are not there. This is the affidavit of service.
No, the affidavit of service is post after this. That page number 24
26.
where sent to the police authorities. Where is the document?
My lord, postal receipts are not right now with me, but I have sent, my lord, and they have received it.
A specific instruction we have never received.
They are saying not received. You are saying
after receiving the
come in the letter. Chalo. 1st of July. Learned advocate appearing for the petitioner submits that the information was sent to the police station. While the same is disputed by the learned advocate appearing on behalf of the state, learned advocate for the petitioner who would produce the documents in support of the contention that the informations sent to the police station were by way of speed post or any other mode. Full stop. List the petition under the same heading in the month list of July 2025. Under the same heading. Will give service fabricated. Next example.
Milord, I am for the state respondents.
Paragraph 5 of the writ petition may be taken into an account, Milord, by comparing, Milord, page 30 and 39. The fact is, Milord, that I wanted to construct a house on my own land. Municipality had granted a permission. Now, Milord, in para 5, Milord, I said, Milord, that there was a climate of threat, Milord, and Milord, the SP, Milord, was informed, page 30, Milord,
evidencing, my lord, the photograph of, my lord, the intrusion. Whether, my lord, the police has a duty under the new act, my lord, under section 168, my lord, ensure that the crime must be prevented, and, my lord, such duty is cast upon. Page 30, my lord. These are the persons, my lord, mainly Mr. Samad, S.K. Samad. He is blessed by the, my lord, ruling political dispensation, and, my lord, page 39, my lord, kindly sees. After this, my lord, my client, my lord, had addressed his grievances to the superintendent of
This is of 2023.
23, 24.
24. Now, my lord,
Let him
I
complete, my
cannot-
lord. I'll
I-
satisfy your lordship.
Travel beyond the records. I said, my lord, still today, my lord, the climate of terror is, my lord, this is prevalent. My lord,
Where is your last representation?
last representation, page 80,
80.
81. 25th July 2024. Then, my lord, now,
My lord, বলে নিতে হয়েছে?
This is of 25th July.
yes, my lord, I tell you, lordship, my lord, series of representation, my lord, ultimately, my lord, it is not, my lord, my case that I am not staying in my house. It is true. But, my lord, after the sunset, my lord, the situation, my lord, is such, my lord, there is no, my lord, the threat perception is all along the land. And they said, my lord, that they would set my house at play, my lord,
Right,
anytime.
go be, you are witnesses in these cases. Memory
Yes,
PS case number
yes, yes.
655.
Yes. Right.
Approach the magistrate who is insisting of the matter. I am directing him to
And my lord,
assess the
as
threat,
far as the
threat perception, to call for a threat perception. See, you have got to stay over there.
Yes.
Single order will not suffice your purpose.
See, I will be, whether I'm entitled to make this humble prayer to your lordship, my lord, that the police will be directed, but at least, my lord, because I am a.
Your continuous monitoring is, I will dispose of this matter.
Yes.
My lord, the report of the BLRO is absolutely in contradiction to what it is submitted. Your lordship, kindly.
I'm not bothered with the land matter, sir. There
And
are
as far as the criminal aspects are concerned, my lord, we have received complaints and counter complaints.
These
complaints
there are
from his side.
cases where he is a witness.
And in all the cases, charge sheet has been filed.
তো বলছি তো তাই। There are cases where you are witnesses. As such, under the witness protection scheme, you are entitled to protection.
And in cases, he is also.
And in every situation, you cannot approach this court. Try to appreciate. I'm giving this direction upon the jurisdictional court who are insisting of the issue that it will call for a threat perception report and will assess, and there are 3 degrees of giving protection. Accordingly, concern on protection will be extended to you. That's what you are wanting, basically.
I am wanting.
Upon considering the reports, my lord.
And, my lord, so far as the immediate duty, my lord, has cast upon 168, whether the police is, my lord, police can, my lord, take, my lord, any steps, my lord, at least, my lord, there should not be a breach of peace, my lord, in this locality.
That is always there, my lord. And for that, we have also initiated, my lord, 126.
See, that vigil, but what you are saying under the relevant.
The situation is such, my lord.
In the month of July, we have already initiated 107, my lord. And for a span of 1 year, it is still surviving.
Petitioner is agreed by the excesses inflicted upon by the private respondents. You have made a party or no?
Yes. I mean, there are reports from the BLRO contradicting his submission, and there are building plans as far as
by the private respondents.
All are attached with in my report.
Although many issues have been canvassed in the writ petition itself, for the time being, the petitioner has expressed his agony, particularly with regard to the insecurity faced by him because of the act and actions of the private respondents who had been interfering with the peaceful enjoyment of life and property of the petitioner. State has submitted a report.
And the report indicates that the petitioner has encroached the land, a portion of the land of the private respondent.
I am not going to interfere over this. Land construction, I don't interfere.
And my lord, as far as the complaints are concerned, my lord, all were attended, charge sheet filed, and in addition to that, my lord, proceeding under 126 has been initiated.
Petitioner?
To maintain peace.
State has submitted a report which reflects that number of criminal cases have been registered, which includes memory PS case number 655/24, comma, memory EPS case number 883/24. Acha. Since the petitioner is a necessary witness to the case, and the jurisdictional criminal court is already in CC in of the issue, petitioner will take out an application before the learned court in CC in of the criminal case. The learned court would call for a report under call for a report, call for a threat perception report, and pass necessary directions under the Witness Protection Scheme 2018.
Upon considering the same, my lord.
Obviously. Acha. The police authority have drawn up proceedings under section 126 of the BNSS. As such, they would continue their surveillance and ensure that no further untoward incident results because of the inimical relationship existing between the petitioner and the private respondents. We therefore say 8 observations. WPA 9029 of 2025 is disposed of. Reports are submitted. We complete the report. A copy of the report be handed over to the learned advocate appearing for the petitioner. Chalo. Next. Yes, sir. Who is for the state?
My lord, I am appearing for the private respondent number 5 and 6.
I am
for the petitioner, my lord.
8. Nobody. Not today, come tomorrow. Let's see.
44.
Private respondent.
No, I'm not for state. I'm on behalf of the private respondent.
Municipality. কিসের জন্য? হ্যাঁ? For whom are you appearing? Private respondent নাকি বলছো?
Private respondent.
সেটা জিজ্ঞাসা করছো তো? Yes, what happened, sir?
I only, my lord. There is a bond, my lord.
পুকুরেও নামতে হবে পুলিশকে?
My lord, thank you, my lord.
When have you lodged the complaint?
Lowered the pond, my lord. Lifting the water, my lord, and new fresh water, my lord.
কি হয়েছে? New.
My lord.
Your complaint is dated what?
My lord, just
If 14/3/2025 না 4/3/2025 কি বলছে? হ্যাঁ? এই submitted prosecution হয়েছে।
আচ্ছা লাগিয়ে দিয়েছেন।
পরিচিত against so what are you wanting the police to do?
My lord, they are disturbing me, my lord, not to withdraw the new water.
So you have a title suit pending to title suit 42.
May I submit one thing, my lord?
I've given the what?
কি হয়েছে?
May I submit one thing?
This
This is not the real story, my lord. The petitioner hearing in earlier made a construction without the consent or the prior permission of the Panchayat authority. I preferred a writ application before this honorable court. The honorable court was pleased to dispose of the order.
Also rearrange the
And my lord,
facial
due to the non-compliance of the said order, my lord, I preferred a contempt application that is still pending before the Honorable Justice Shampa Sarkar. My lord, kindly peruse the order.
Are obstruction activities of the petition.
What is the inaction or overaction of the police is concerned?
This is the original story, my lord.
Taken steps to try and
Once to
annex.
construction.
চলে আসুন এই
Lifting old water, my lord.
that is not the duty of the police.
What happened, my lord? Otherwise, my lord.
You want to construct a road around the pond.
Yes, that is there, my lord. But
Petitioner is agree if whether
I made a dependent because the my lord.
petitioner
That is
page
DC magistrate, my lord. DC magistrate also.
page 17 is your complaint.
Yes.
Huh?
I made an application before the district magistrate, my lord.
দাদা আইসি কাছে মন্টেশ্বরের petitioner inform the inspector in charge of
16, your lordship, can you see?
inspector in charge Montesor or police station.
Page 16.
16 is to the SP.
District magistrate ask the superintendent of police, my lord, to take steps, my lord. That is there, my lord.
Where is he? Take steps কি বলেছে? কোথায় আছে?
favor for your
হ্যাঁ ওটা petition Montesha Police Station to allow him along with other co-sharers to construct road around water body of the pond. And,
my lord.
and not to that is not my that
Nobody will be present, my lord. You will not be.
that is his problem, sir. Police's that is not police's
My lord,
problem.
he's
কি অবস্থা দাঁড়িয়েছে হাইকোর্টে মক্কেল এসে গেছে করে দিয়েছে হ্যাঁ
0.1%, my lord. He's
and not to disturb the petitioner while executing such construction. Stop. Report has been submitted by the police authorities, which reflects that because of the strained relationship between the parties. Proceedings under section 126, 135 has been of BNSS has been drawn twice. Acha. 42 of 2024 dismissed.
Yes.
না তো খালি ইনজাংশন উইকেট হতে পারে টাইটেল স্যুট তো পেন্ডিং
Suit is my lord dismissed. Injunction vacated.
আচ্ছা a title suit would be
Already vacated.
go to that court a title suit a civil suit being TS 42 of 2024 is pending. Having considered that the civil court is already insisting of the issue, petitioner would address his grievance before the civil court, and if the civil court directs for renewing police assistance, only in those circumstances police authorities would respect, obey, and implement the order of the civil court. Since already proceedings have been drawn up under section 126 of the BNSS, police authorities would continue their surveillance and see that no untoward incident takes place because of the inimical relationship existing between the parties. With the aforesaid observation, WP 9059 of 2025 report submitted be kept with the record. A copy of the report without annexures be handed over to the parties. Chalo. No.
Clever man, that is the main problem.
45.
My lord, I am appearing on behalf of state, my lord.
Yes.
For the petition.
Yes. Yes, madam.
Petitioner is the owner of a flat at Navadvip, and she purchased the flat with her deceased husband in the year 2021. While all of a sudden on 15th of February 2025, the private respondent number 5 and 6 disturbing the peaceful position of the petitioner and obstructing the ingress and egress of the petitioner. The petitioner lodged a police complaint on 15th February at Navadvip police station. After that, filed a title suit at
Who filed this title suit?
petitioner.
কোথায় তো ঠিকই আছে
Got a dictative order of injunction, and after that, she filed a police help. That is also allowed, but not complied by the respondent number 4.
Learned advocate appearing for the petitioner submits that there has been interference or there has been interference at the behest of the private respondents who are disturbing the peaceful enjoyment of the property. Petitioner as such was compelled to file a civil suit being TS 67N oblique 2023. The learned aid civil judge, Senior Division First Court, Shodor Post Mednipur, was pleased to pass an order of injunction and subsequently by an order dated 9/3/2023 directed the OCE Keshpur Police Station to ensure that the status quo order with regard to maintenance of the nature, character, and position of the property is not violated. Petitioner's grievance is that in spite of The civil court having passed order, passed direction, the police authority is have refused to render appropriate assistance. State has submitted a report.
Allot second page of my report, third paragraph. I have lost the FIR.
The son of the and the company is but the alleged person did not. The son of the son of the alleged person. On the information furnished by and on behalf of the complainant, Navadip PS case number 220/25 has been registered for investigation. One Aurobindo Dhar was arrested. Or Aurobindo Dhar respondent number what?
Respondent number 5, my lord.
Lord, then how police inaction is arise?
এটা কোন মামলা দিয়েছে বলো?
There are two title suit is filed, my lord. One is from the petitioner end and second one is private respondent side, my lord.
এই উল্টো পাল্টা নম্বর কি মামলা দিয়েছো আমাকে? স্পিডে যাই আবার ভুল দিয়েছে 7-3টা দাও কি মামলা করে যাচ্ছে
9073
কি অবস্থা বুঝতে পারছো কোর্টে একটু কাটতে ওই যেটা আছে 58 অফ পুরো উপরে দেখো 58 ঠিক আছে বাকি আমি দেখে নেবো একটু মনে করে দেবো একটু স্টার মেরে পুলিশ কেস ঠিক আছে তো এখান থেকে বলেছি হ্যাঁ
Lord, page 16 injunction order.
page 6
Injunction page 17 decide order.
হ্যাঁ ওটা ডেট আছে ওখানে কোনো ডেট কত বলতো 18/3 ওটা নবদ্বীপের মামলা যার জন্য মিলে নবদ্বীপ তো এটা আচ্ছা having regard to the fact that the police authority is কি বললাম Aurobindo Dhar bracketed respondent number 5 was arrested. The investigation of the case is in progress. Full stop. In view of the
Respondent number 5, 6, Uttam Chandranath.
5 is Aurobindo Dhar.
5 Aurobindo Dhar and 6 Uttam Chandranath.
No, 6 has not been arrested. 5 has been arrested. Aurobindo Dhar has been arrested. And son, that is not a respondent. This Pranto Dhar is not a respondent over here. Achha. Police authority is carrying out further investigation under the Foreigners Act also. Having regard the steps taken by the police authority is I'm of the view that so far as the aspect of infraction and violation of law is concerned, police authority is have already taken steps. However, so far as the issue relating to the directions of the civil court is concerned, if any inconveniences are faced by the police authorities, they would inform the jurisdictional civil court. Full stop. Let the investigation of the case which has already commenced be taken to its logical conclusion. এটা নবদ্বীপ পিএস কেস 220 না 220 be taken to its conclusion within the reported observation. WOP 9073 of 2025 is disposed of. Reports are submitted. We kept with the record. Copy of the report be handed over to the learned advocate appearing for the petitioner. Chalo.
Deeply obliged, my lord.
Well, I'm the
Wow.
well, I'm the my lord. Well, I'm
Yes.
well, I'm a senior citizen, my lord. I have a wife, my lord. He is also, my lord, suffering from different ailments. I have gifted some property to the restaurant, private restaurant number 10. She is my lord, daughter
Daughter.
and son-in-law, and with a promise that she will look after my wife. My lord, after the my lord give deed, my lord, they they are not doing it. They are now, my lord, trying to dispose me. They are with this.
SDO. Chalo.
My lord, kindly come to page 48, my lord. Everything is done, my lord, but I cannot stay in my.
Direct the SDO will direct, police will execute.
Well, kindly read the 48, my lord, page 48, my lord.
আছি তো 48 এই আছে আর কোথায় থাকবো?
Well, kindly see,
Petitioner
as
is
the whole person,
petitioner.
my lord, kindly see that
Petitioner is
they will
acted
not
by the fact that the private aid respondents who happen to be the daughter and the son-in-law,
and others also there, my lord.
along with 8 others have already along with the associates not you are at your home or no?
Well, they are trying to dispose of me,
আচ্ছা
and they are cutting down all the trees,
Yes.
my lord, all my fruits.
থাকতে পারছে কি বলছি?
My house.
Along with their associates are attempting to oust the petitioner from the
Cutting
residence.
down the my lord, bamboo
আর ঠিক
trees
আছে
and
ব্যাম্বু দিয়ে কিছু হয় না, ওগুলো সব সিভিল কোর্টে
they are cutting down, my lord. That is,
full stop.
my lord,
Information was sent to the police authorities, and petitioner has already approached the subdivisional executive magistrate. Full stop. Learned advocate for the petitioner submits that SDO you have approached. আচ্ছা ঠিক আছে কি বললাম? Rejected. কি করে করে এটা? ওই না পিডি হ্যাঁ আচ্ছা petitioner submits that the petitioner approached the subdivisional officer under the relevant provisions of the Maintenance and Welfare of Parents and Senior Citizens Act, but জানেই না SDO আর কি, but the same has been refused. Pension gift almost it's already settled position of law that the whoever the son daughter they are all licensee, gift deed can be cancelled under the act concerned.
specific provision is there.
Recent Supreme Court judgment also supports that. হ্যাঁ কি বললাম?
Kindly direct the police so that I can stay.
হ্যাঁ হ্যাঁ ওটাই বলে দিচ্ছি। আচ্ছা কি মেনটেন হয়ে গেছে তারপরে refuse petitioner submit is they intend to prefer an appeal against the say order. Be that learned advocate for the private respondents are present and denies and disputes the contentions advanced on behalf of the petitioner. State has submitted a report reflects that FIR because of the dispute and differences already Murutia PS case number 152/24 dated 19/5/2024 has been registered for investigation, and consequently charge sheet has also been submitted before the jurisdictional court. Oh, ঠিক আছে, ঠিক আছে. Oh, very good. Be that as it may, police authority are in know-how and seizing of the issue regarding this family feud. Regarding the family feud, as such, they would keep a surveillance so that the petitioner and his wife is not thrown out of the house and no untoward incident results because of the strained relationship existing between the parties. With the aforesaid observation, WPA 9076 of 2025 is disposed of. Reports are submitted. We can serve a copy. No. A copy of the report. Reports are a copy of the report. Next. 47, sir.
May it please the Lordship, my lord. Is my application, my lord.
Oh.
I'll kindly come.
State you are appearing. Yes.
I'll kindly come to page 16 of my application.
16.
My lord, there is a cooperative society in Gosaba. And my lord, the elections were supposed to be held there, my lord, on the 28th of March 2025. My associates were some candidates for the election. My lord, on the 26th of March, the officer in charge of Gosaba, which my lord will find at page 18, the officer in charge of Gosaba police station, my lord, addresses an email to the district magistrate with copies to others. And in the email, he says that I am writing to inform you that despite your request, I regret to inform you that I am unable to deploy adequate police personnel for the election to the board of directors of the Somiti, scheduled on 28/3/25. This is due to various upcoming law and order commitments. I kindly request you to consider postponing the election by at least 7 days. On the next page, my lord, will find that acting upon this, my lord, email, the elections were actually postponed. Now, one of my associates, my learned junior in court will hand over the emails. Well, one of my associates, my lord, then wrote an email complaining to the SP because, my lord, on the 28th, when we gathered for casting the votes, well, the same officer in charge, along with force, my lord, lands up at 12 o'clock to disperse the crowd. He is there till 2:30 in the afternoon. The same officer who had written to the DM saying he doesn't have, my lord, force to provide on that day, he was there. So, my lord, we wrote an email to the SP.
তো কি হয়েছে এই
Kindly comes to the first and second page of my report.
ফালতু ঝামেলা যে কেউ একটা this you should have filed before the court having determinations of cooperative societies.
No,
Why?
my lord, I'm not on that. I'm not on that. What happened, my lord? Thereafter, my lord, we addressed complaints to the SP. Now, this, my lord, has infuriated the officer in charge. Now, my lord, the petitioner on the 12th of, my lord, April. My lord, this is in Gosawa near Sundarban, my lord, my lord. So, my lord, on that day, a gang of 100 to 150 people, 34 of them we have named in the complaint. My lord,
you have against you.
All the cases he has been charged.
37 cases against you. Who are you?
37 cases against me. But I don't have that, my lord, instruction. I can take the instruction. Now, my lord, on the 14th of April, my lord, we addressed a letter to the SP, which I have annexed at page 21, saying that, look, when I received news that 150 people are lying in wait, armed to assault me, I contacted the officer in charge over telephone and informed him. And I was categorically told that I have become a busybody and no help will be provided to me.
All right. Petitioner is agree by the fact that the police authority is in order to render him assistance in spite of being informed repeatedly.
At 14th of April,
no protection was given to him in spite of informations being furnished to the superintendent of police on 14/4/2025, and the petitioner suffered the wrath of his adversaries. Petitioner as asked the superintendent of police for transfer of the concerned officers. State has submitted a report reflecting that charge sheet has been submitted against the petitioner in as many as 37 cases. There was a crisis which took place, and the concerning an election. Full stop. There are factions, as is reflected from the police report. All right. And the police report further reflects that the present petitioner has persistently sought to engage police resources unnecessarily and has made wild allegations against the police authorities to the superiors. Having considered the fact that the police authority is aware to the provisions of law and taken in steps for uh, uh, maintaining law and order, I am of the view that the writ petition fails to make out any cause of action. Police authority is have taken steps as and when called for in consonance with the provisions of law. Consequently, no interference is called for, and WPA 9082 of 2025 is dismissed. Reports are submitted. We kept with the records. Our copies.
And maybe get a copy of the report.
Report.
Well,
charge sheet has been submitted too.
There are also cases where charges have been submitted and details of the
Oh, তাহলে তো হবে না, wait. There are investigations going on against you.
that might be so. But I am only saying, my lord, this is the incident, latest incident that has happened. I brought it to your lordship's knowledge. That not even the SPs, my lord, refusing to, my lord, protect, when extend any help, my lord.
What do you want? How can that be as a matter of right? It's his petition.
But what is the fact of the matter is that I have been illegally resisted from enjoying my own house.
Yes.
In that house, she has the lock and petitioner is now asking mother-in-law and the daughter-in-law, the lawyer,
Let me kindly come to annexure. And let me kindly come to annexure P6, page 39. There are the photographs.
This is shared household. What are you wanting, sir?
My lord, I want please give adequate protection from the police to enter into my home.
Is this the jurisdiction you are repeatedly coming? What are the avenues of other statutes?
My lord, I am covered by a judgment of Ramaprasad Bosai passed by this honorable court, where the court has that the court can exercise its extraordinary jurisdiction under article.
That in that case, it exercise. I may not, because you are coming after a substantial long time.
My lord, my right has been invaded. I have been ousted. I have been declared.
So you bring it to the notice of the court concerned. It's impossible. Why the unnecessary writ petitions are being filed? An alternative efficacious remedy is available. PWD Act is pending before which court?
Court Judicial Magistrate, Durgapur Court.
চলে আসুন. Petitioner being the mother-in-law has been claims that she has been thrown out from her residence because of an order passed under the provisions of the PWDV Act 2005 by the learned judicial magistrate Fort Court, Durgapur. Full stop. The residential orders, if any, passed by the learned judicial magistrate Fort Court, Durgapur, presumably will be a proportionate part for an individual to enjoy in a property or exercise his residential right. But the same cannot ought in any manner take away the right of others in the shared household. Full stop. Report submitted aid by the police authorities substantiates the contentions of the petitioner, who happens to be the mother-in-law and has been thrown away from the property. Accordingly, the petitioner is granted liberty to the approach the learned judicial magistrate Fort Court, Durgapur, who would consider the number of rooms available at the house, the a number of exit and entries at the residence, and would in 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 a but in a in a proportionate manner earmark the residential rights to be enjoyed by each and every party who are supposed to be residing at the shared household. If any application is filed by the petitioner, the same should be disposed of by the learned judicial magistrate Fort Court, Durgapur, preferably within a period of 15 days from the date of filing of the application. Sure. With the aforesaid observations, WPA 9084 of 2025 is disposed of. Reports are submitted, be kept in the record. A copy of the report, but then she'll be unable to, because if your police goes and takes a different stand over there, here they are taking one stand. And this is difficulty with the police authorities. Over High Court, they will take a stand before the magistrate, and before the magistrate, they will take a different stand. Disposal reports submitted, be kept with a copy of the report behind both the parties. Like, Your
Lordship, I am appearing on behalf of the petitioner. Your Lordship, it is being led by Mr. Vikas Ranjan Bhattacharya, senior advocate. Yes. Yeah, I am praying for an adjournment on his grounds.
Keep চাইছি।
There are cases and counter cases, Your Lordship.
What are you wanting?
I am praying for an adjournment because he is in.
জুলাই মাসে এটা রেখে দিচ্ছি রিপোর্ট।
And at the same time,
রিপোর্টটা রেখে দিচ্ছি। I am keeping the report তো। Let him come. আমি এভাবে না শুনে মিস্টার ব্যানার্জি পরের দিন করে দেবো, পরের দিন monthly of July. Everybody I am giving the same order, sir. I can't do it. Everybody I am giving the same order. I understand, but somebody, have you seen any lawyer praying for time and I'm not fixing in the month of July? Chalo.
kindly consider.
হ্যাঁ কিছু না, চলে আসুন।
Hello, Mr. Bhattacharya is kindly be the coming week.
জুলাই না, ওরা রিপিট হবে না ছুটির আগে, আমার দমই নেই। Petitioner, learned advocate for the petitioner prays for an accommodation. State has submitted a report, lists the read petition in the monthly for respondent number. Mr. Chatterjee appears for respondent number 5. List the read petition under the same heading in the monthly list of July 2025. Chalo. Report submitted. Yes, 50.
I'm appearing on behalf of the petitioner.
তাড়াতাড়ি চলে আসুন।
Adjournment because
Learned advocate appearing for the petitioner prays for an accommodation. List the read petition in the monthly list of July 2025 under the same heading. তাড়াতাড়ি দাও। আর কেউ করবে না। Yes. Online, yes.
Lordship, in item number 51, 52, and 53, both are connected matters.
52-53 দিয়ে দাও। এই অমিত,
Petitioner in item number 51, your lordship,
yes, what are you wanting?
deposited a sum of rupees 3 lakhs with private respondent number 9 with the assurance that after expiry of 6.5 years, he'll be given.
What is the difficulty with the police authorities? Tell me.
Lordship, the case should have been also initiated under section 3 of the West Bengal Protection of Interest of Depositors in Financial Establishment Act 2013, your lordship. That section 3 of the act has not yet been invoked, your lordship.
Charge sheet has been submitted.
No, lordship, it is under investigation.
Petitioner is granted liberty petitioner is granted liberty to approach the jurisdictional magistrate to address his grievance, particularly with regard to the investigating agency not having not having conducted investigation under section 3 of the West Bengal Protection of Interest of Depositors in Financial Establishments Act 2013. In case such an application is advanced before the learned magistrate would, in the background of the legal proposition laid down as also the object of the said act, pass necessary directions upon the
Mobile mute got me.
in the back pass necessary directions upon the investigating officer in the backgrounds of the facts of the present case.
Lordship, the police authority may also be directed to attach the property of private respondent number 9 to 14.
That's part of the investigation. আর 25-এর মামলা সবে 12 তারিখে করেছে, অ্যাটাচমেন্ট চাইছে।
The difficulty is that the police authority is not doing nothing, anything, your lordship.
You are in 52 who is appearing. Say 52 also same.
Same, your lordship. Facts are same, amount may be different, but facts are same.
And the facts means prayer relief is same.
Everything same, your lordship.
তো সব কটা একই অর্ডার পাস করে দেবেন। নামটা 50 আর 150 আর 52 তে ওর নাম দিয়ে দিন। এর নাম 52 তে দুজনের নাম দিয়ে দিন। একটা লাইন অ্যাড করে দিন। Since none appears for the state, Mr. Banerjee along with Mr. Akash Dotto is directed to represent the state. Their appearance may be regularized by the concerned authority. হয়ে গেল একটা।
53 also, lordship. 53.
53 done. 50.
Grateful to you, lordship.
ওইটা 52 রিপোর্ট দেবেন না, 51 আর 53 রিপোর্টটা দিয়ে দেবেন। চলো হয়ে গেছে তিনটে মামলা।
Report may be given.
না, investigation is going on. I can't.
Lordship, we are the complainant, your lordship.
In spite of that, sir, we can't.
Lordship.
হ্যাঁ, নিয়ে ডিসপোজ হয়ে যাচ্ছে। 51, 52, 53 dispose of. চলো 54 ডাকো।
54.
My lord, I'm appearing for the state, my lord.
Who is for the petitioner? 54. None appears for the petitioner. Learned advocate 8 for the state is present. Learned advocate 8 for the respondent number.
My name to be recorded, my
Is the petition.
Give one line order, my lord.
Monthly list of July 2025 under the same heading. Chalo next.
Grateful, my lord.
Start. Start the matter. You are the advocate on record. Where is the advocate on record?
Please, code number 9. He is in
And the senior?
He's just coming. Just give me 5 minutes. Lordship, kindly give me 5 minutes.
Either you take in the month.
At present,
My lord, item 54 is running, my lord.
55.
Yes.
At present, the aforesaid persons and others threatening to cause physical harm and further threatening demanding money. And we not only based on this two dash not we have initial proceedings under 126. We are against the party. And 7 this part pillar. The charge sheet has been already filed long back in 2016 in connection with
It কি চাইছে?
this is
Are
only
it to protect?
10 minutes.
Protection চাইছে তো। আরে you are wanting protection. See, I'm granting you protection. চলে এসো, আর কিছু নেই। চলে আসো। Petitioner is aggrieved that in spite of Khordha Police Station case number 736 of 2015 dated 27/8/2015 pending before the jurisdictional court at Barakpur. Barakpur. Jurisdictional court at Barakpur. The petition, the petitioner has been threatened by the private respondent. There's a prayer only. They will be. Acha. Having in regard to the fact that Khorda police station case number 2000 in that in connection with Khorda police station PS case number acha, theek hai. Charge sheet was submitted in the year case number 736/27/8/2015. Charge sheet was submitted in the year 2016, and the present petitioner naam ki naam hi nahi likho. And the present petitioner happens to be a witness. I'm of the view that if the petitioner takes out any application before the court insists in of the criminal case, the concerned court would call for a threat perception report and thereafter pass necessary directions under the Witness Protection Scheme 2018. Acha, report of the next paragraph. Report of the police authority is reflect that already already proceedings have been drawn up under section 126 of the BNSS. Consequently, police authority is directed to continue their vigil and ensure that no untoward incident results because of the inimical relationship existing between the parties. So, with the aforesaid observations, WPA 9147 of 2025 is disposed of. Give the name. Reports are submitted, be kept in the records. Chalo. Who is for the state? Tomorrow.
57. Service, my lord.
What is your problem?
Problem is that I am the registered owner plus a vehicle, my lord.
Registered owner of?
Vehicle. One vehicle, my lord.
Uff, abar edir default are
My lord, the police what happened, my lord? The unclaimed property. Kindly see the page 27. My
issue commanding responding authority to return the truck.
page 27 under section 25 of the police act. Unclaimed property. My lord, kindly
The state vehicle of the petitioner was
relevant documents.
and entry was made for
Very well.
the land is civil
Private respondent has tactfully, my lord.
My lord, I am appearing on behalf of state, my lord. There is no chassis number as well as the engine number before the RTO, my lord. That's why I have written the vehicles.
I have annexed the vehicle.
Produce all the documents.
Matter is subjudice, my lord.
My respectful submission is that direction is given to the state, my lord, to submit the report by the police, my lord. If my lord, I am not produced.
You are who? Mr. Ghotok is appearing for whom? Who is he? Finance company?
Yes.
My lord, please come to the page number 3 of my report, my lord.
Madan Kumar Jadhav. Who are you, Madan Kumar Jadhav?
There is an agreement with me which has been violated.
You tell me who is having the documents?
No, I have
documents of the vehicle is with whom?
With me, my lord.
Petitioner is unable to produce the documents, my lord. That's why that is the case, my lord.
14, 15, 16, my lord.
চলে আসুন এইগুলো মামলাগুলো কিছু নেই এগুলো ফেলে রাখা আমার কাছে this is not matching this
He is saying, my lord, kindly direct the authority police, my lord, to file a report, my lord.
আচ্ছা রিপোর্ট দিয়েছে তো
Matching, my lord, kindly.
My lord, please come to the page number 3, paragraph number C of my report.
My lord, only tomorrow, my lord. Kindly, only not today. My lord, kindly consider, only not today, my lord. If it is so, my lord, I have asked my client, my lord. It is my document, it is my vehicle, my lord. And I have
Page 18, you see. You are Sharad Jadab to.
Yes.
So you have lost the documents. So.
No, lost the document. Yes, thereafter, my lord, Xerox copy. Thereafter, Xerox copy.
Xerox copy of
My lord, kindly from the RT office.
Go to the civil court for necessary orders.
Civil court, my lord, kindly consider, my lord. Civil court order has been given, my lord.
I had to direct the police authorities.
Civil court will order the
Ah.
third party. I am the owner of the vehicle.
Everybody. So you keep your documents properly. Petitioner.
Just 300.
অ্যাপিল কোর্টের মামলা এত শক্ত মামলা আমি বুঝতেই পারছি না
Kindly contact other. I am suffering, my lord. I have been suffering. My vehicle 300 per day.
Petition.
6 months, my lord. Kindly 6 months.
Who went to the civil court? You.
My lord.
Who went to the civil court?
Private respondent.
Madan Kumar Yadav, my lord, private respondent went to the civil court and there is direction.
এটা জুলাই মাসে
Transfer the vehicles in the name of third party, my lord.
কবে থেকে আছে ডিসেম্বর থেকে আছে জুলাই মাসে হবে গাড়ি তো
And order is extended up to the 7th May 2025. Today is 6th May, my lord.
Petitioner learned advocate appearing for the petitioner prays for an accommodation to produce all the documents.
Produce, my lord.
ওই তো হারিয়ে গেছে কোথায় প্রডিউস করতে
That is the
where Xerox copy না original করতে হবে go apply to the RTO না learn advocate
I am suffering a huge loss, my monetary problem, my lord.
কোর্টে এসে সাফারিং হ্যাঁ এক সপ্তাহ আগে ফাইল করেছে মামলা হয়ে যাচ্ছে
Second shelter, my lord. No other alternative way but to take a
এখন টাইম ওয়েস্ট করলে কিন্তু খুব মুশকিল হয়ে বলে দিচ্ছি আর কি বলতে That's why I'm
my lord, no engine number, no chassis number, vehicles is registered in Nagaland.
The more the petition
in connivance with the police, my lord, it has been acted. Unclaimed property from my house, by the police is arrested, my lord.
ঠিক আছে
Property.
এবার ডিসপোজ অফ করে দেবো এত সময় নষ্ট করলে কিন্তু হ্যাঁ ঠিক আছে নাহলে জুলাইয়ে দিচ্ছি জুলাই কি বললাম
June first week, my June first.
To produce all the documents, to produce all the original documents for it. Acha, by state has submitted appears on behalf of the release the writ petition in the monthly list of July. June আমি নেই দেব সার্কিটে থাকবো চলো ডাকুন থাকবো না তো আমি কোথায় করবো monthly list of July.
My lord, may I allow to submit subject to your correction, my lord?
Yes.
Give the direction to the petitioner to produce the original documents before the competent authority. Why he is not going to show it, my lord? Please come to the my report, page number 3, paragraph number C, my lord.
I am able to produce.
Yes, Mr. Mr. Got to come. I'm disposing it of. He'll produce all the original documents with the police authorities.
Then they have to release the vehicle.
He will produce all the original documents before the police authorities. Police authorities will consider
under section 26 of the Petition, when of the magistrate, where an order has been passed. In fact, I intended to make a submission whether that is a divisional order or an order against which a represents.
they have not, they have suppressed everything. ওসব কিছু দেয়নি হ্যাঁ টাইটেল শুটে তো ইউ গো টেক ইউ রেমেডি অ্যাক্ট petitioner তাহলে ওটা ডিসপোজ অফ petitioner would produce all the original documents would produce GD entry দিয়ে হয়েছে দেখি একটু রিপোর্টটা দাও তো না এবার GD entry is there তাহলে ম্যাজিস্ট্রেটের কাছে চলে গেছে দেখছি
GD entry is lying there, my lord. 495 dated December 24.
এই তো হয়ে গেছে petitioner
Under section 25 of the Police Act 1861, my lord.
petitioner
First page, paragraph number B.
petitioner submit that the original documents are in his custody in respect of the vehicle which has the subject matter for which is aggrieved as the same has not been released by the police authorities. Police authorities have seized the same by way of ফরিদপুরে থানা আছে কি?
No, investigation center, my lord.
By way of ফরিদপুর or by way of ফরিদপুর investigation.
Under the Durgapur police station, my lord.
Number 495 dated 10/12/2024. Is the vehicle full stop having considered the fact that the Durgapur police station is already insisting of the issue and the seizure has been effected under section 25 of the Police Act. Petitioner will go to the magistrate. That will be better. Petitioner will introduce all the original documents before the learned magistrate. Notices be issued to all the affected parties. Learned magistrate within a period of 38 days from date of application by the petitioner would exhaust the remedies after providing necessary hearing to all the parties. Sure.
I am able to produce the relevant documents, original, then to release the vehicle.
How can I say release the vehicle to the magistrate?
No, if I able to produce the relevant documents, original documents, then the direction is given to the magistrate to release the vehicle. Direction is given to release the vehicle.
তাই তো দেবে আর কি করবে আচ্ছা
Direction is given, my lord.
I can only say I cannot say release the vehicle to the magistrate, sir. কি বললাম? Hearing both the parties. This honorable, this court has not gone into the merits of it would apply it after perusing and considering the documents of the learned magistrate and in view of the settled proposition of law decide to release the vehicle in accordance with law.
Yes.
Either of the parties. And Ambalal Desai's case is that, sir. In your favor also it can be. Would dispose of the application in accordance with law.
Otherwise, the learned magistrate will
আর কিছু নয় কিছু
given to dispose of the same and to consider the same, my lord.
হ্যাঁ তা কি করব চলো চলো
Deeply obliged, my lord.
আর কি
Twice, my lord, the compelling set of circumstances, my lord.
কি হয়েছে
Twice your lordship's order has not been complied with, my
the
lord.
revisional application ওখানে যেতে হবে
My lord, a revisional application was preferred, my lord. My lord, your lordship was directed, my lord, to pay the amount 15,000 rupees per month while your lordship's in a revisional.
What are you wanting, sir?
Last order, lordship, passed in a similar writ petition.
কোথাকার মামলা প্রেয়ার কি আছে আর কি
My lord, to execute the warrant of arrest.
তাহলে ওই হয়ে গেছে ওটা Learned advocate appearing for the petitioner is agreed by the fact that the warrant issued by the
considers one
judicial magistrate 8th court albeit a revisional court.
In the trial court, what they are doing, my lord, they are appearing suo motu without giving notice, despite of your lordship's direction in the CRR application.
Judicial magistrate by the judicial magistrate 8th court Alipur in connection with MEX 288/22 is not being executed aid by the concerned police by Mohesola police station. Having regard, state has submitted a report. Report reflects that the warrant of arrest although could not be executed, but on 30th April 2025, the respondent Rajkumar Sharma appeared before the court and thereafter the said warrant of arrest has been
that is the game every time my lord is happening, my lord. My lord, kindly consider your lordship's order. Your lordship's directed the London magistrate to give an audience.
After depositing maintenance amount, it is said over here.
My lord, very meager amount, my lord.
Recalled.
Not even the lordship's direction. Your lordship directed 15,000 rupees to be deposited per month, and if they come up with a recall application, an audience will be given, my lord, to the petitioner wife. That also has not been given.
Right of the petition.
They are taking 6 months of time. Warrant of arrest has been issued, my lord. Police is not arresting, granting them time. They are taking recall.
আলিপুর কোর্ট এইভাবেই যায় হ্যাঁ ঠিক আছে, প্রত্যেকটা কোর্ট অনুযায়ী অর্ডার দিতে হয়, তার মানে হচ্ছে so since since the respondent has already appeared before the court, I am of the view that the learned judicial magistrate in in of the execution case will exhaust the process of law or and would compel for the amount would compel the respondent to
But there was a direction within 31st of January 2025 was the earlier direction of
to
your
pay
lordship.
আমার মনে হয় দিয়ে দিয়েছে to pay the ওই একটা
30
করে অ্যাড করতে থাকলে হয়
20%. Even that order of
pay
your
the
lordship has
to
not been
pay
complied.
the area amount to pay and clear the area amount
When your lordship
with the
exhausted
aforesaid
the
aid
directed.
with the aforesaid aid observations WPA 9158 না
I'm so
57 তো
grateful.
এটা 9158 of 2025 is disposal report is submitted we kept the server house next মামলাই করতে দিল না ভালো করে
I am for the petitioner, your lordship.
Hmm.
This case, the petitioner has made an application under section 100 and 144 clause 2 BA CRPC before the executive magistrate. The order was passed, the police did not acted thereafter. He again approached the landed magistrate. The magistrate passed another order. The executive magistrate, the police is not acting, your lordship.
they will not act sir executive
A
magistrate
direction may be given to act upon the order.
petitioner is aggrieved by the fact that in spite of the elections passed by the learned executive all right petition given petitioner is
Your
aggrieved
lordship, kindly have a look at page number 24.
কিছু have an executive magistrate what is the provision of execution high court then why are you coming over here landed executive magistrate no steps are being taken by the police authorities petitioner has repeatedly approached the concerned magistrate state has submitted a report reflects that there is a dispute over inheritance property between the petitioner and the private respondents, and no representation was submitted before the police authorities. Be that as it may, since the nature of the dispute has its genesis is before the has its genesis is in a land dispute. I am of the view that that the nature of the dispute has a civil flavor and the police authorities hardly have any authority to deal with the same. Full stop. Police authority would keep a vigilant and would ensure only that there is no breach of the peace and or tranquility and or any untoward incident resulting from the strained relationship existing between the parties. With the aforesaid observation, WPA 9164 of 2025 is disposed of. Reports submitted be kept with the record. Copy of the report be handed over to learned advocate appearing for the petitioner. So next. None appears for the petition. Learned advocate for the private respondent and the state is present. Leads the read petition in the 1st of July 2025 under the same meeting. Learned advocate appearing for the একই ব্যাপার can you bring and come একই order আগের মতো দিয়ে দেবেন learned advocate aid for the petitioner prays for an accommodation as service has not been completed learned advocate for the private respondent number 9 as state is present leads the read petition under the same heading in the month of July 2025 আর বললে কি হবে আর আমার কি আছে 62
my lord 62 my lord 62 I am for the respondent number 7 my lord
no petitioner none appears for the petitioner a learned advocate for the private respondents as well as the state is present leads the read petition under the same heading in the month of July 2025 respondent
I appear for the petition, my lord.
Yes.
My lord, your lordship kindly comes to your lordship's earlier order in the partition and earlier petition at page 94, annexure P11. Prior thereto, my lord, your lordship had recorded everything till that particular day when your lordship passed the order with regard to the subject matter. Your lordship kindly goes to your lordship's own orders, my lord. And thereafter, my lord,
Lord's order is at page 94.
94, your lordship kindly goes to your lordship's own order, my lord.
Mr. Banerjee, you are appealing.
Yes, I have already handed over.
What is the stage of the case?
Now, my lord, they have transferred it to the DCDD. They have transferred to the DCDD, the DD on their own violation in the month of February. Without giving any notice, the DC department has once again called us, issued notices under section 91 calling for the same documents.
Last page of the report.
Which we have already been filed with the Vidhannagar police station.
In between
the original certified copies are with them. They have to delay the matter.
No.
What is my language submitting? Transfer to detective department, everything I've stated.
No, it's all right. Investigation is pending.
Yes. And they have not even called. Your lordship wanted. Whether your lordship sees, your lordship directed that there is a government authority who is in session of the original documents. They may be called for and investigated. Nothing has been done. No steps have been taken even. Call from the registering authority as to whether or not the original document is there or not. Which is the original document? For the last
affidavit se jaak. Investigation চলছে তো.
What is first investigation? FRT was made in 3 months. Then your lordship set aside the FRT and then after directed fresh investigation. Now 5 months, nothing has been done. 5 months.
Multiple counsel speaking for in the same voice.
এটা affidavit দিয়ে দিই. এখন শুনতে পারবো না. অন্য লোকেদের ক্ষতি হয়ে যাবে.
Kindly consider we are accused persons, allegations are being made against us. How can we deal with the same?
On one occasion he says I have got nothing to do with it. Now he's saying that I have
Come up with an affidavit, sir.
Limited.
He is wanting investigation to go on. Coach stay চাইছে নাকি?
But only, may I only pray for the one thing, Manoj? Lordship only directs the investigating authority.
I am not getting time. That's why I am not applying my mind. পুরো ইস্টার্ন পেপারমেন্টস এর জমিটা জাল হয়ে গেছে.
Yes, they are the persons.
এটা হচ্ছে মামলা.
Yes, that is the thing. That has been settled.
So, Manoj, to prevent the matter to go further under 420 Manoj of the old act, Manoj, may I only pray one thing, Manoj? Lordship only directs the investigating authority, Manoj, to do one thing, Manoj, to call for from the registering authority a report from them. A report from the registering authority, Manoj.
Petitioner is agreed by the mode and manner of investigation being carried out and as such as approached the court.
ওটা তো এফএমএটি তে আছেই তো
Acha, Mr. Banerjee submits that the detective department end has been in carrying out and proceeding with the investigation of the case. Acha, will be private respondents would be at liberty to file their affidavit in opposition, preferably within a period of 3 weeks.
3 weeks is in the vacation.
I will move 6 weeks.
1 week after vacation. 1 week after vacation. That makes sense.
Or by 11th of June 2025, affidavit in reply if any by 24th of June, June 2025, list the writ petition under the heading for orders in the monthly list of July 2025. Pending hearing of the writ petition, the investigating agency would continue with the investigation and submit a progress report.
Only there. If Mr. Banerjee could provide us a copy of the report which has he has submitted before your lordship. May we have a copy of that?
You were the accused, so.
Yes, accused. But he has only stated about.
Next. Inland water is the key. Yes. পাগল হয়ে যাবো।
54 my lord, I'm for the
তাতেই mandamus to issue the employees and assign to set aside the
My lord, in this matter, I am for the petition. The issue involved is.
I'm for the respondent number 10.
what will police do?
There is a
Kindly see the prayer.
Kindly see the prayer, my lord.
there is a authority upon the respondent number 10 to handle this sand from the river bed. Now they are going to sell out the property. I repeated lost complaint before the school police authority. Till date nothing has been done.
But there is no complaint has yet been made against me. I'm the respondent number 10.
How do you know?
Yes, my lord.
That statement
Because, my lord, they have not annexed anything. They have annexed FIR that is not relevant to me. And kindly see the prayer, my lord. There is no prayer sought for
FIR is supposed to be given to the accused. Ask Mr. Banerjee.
Kindly look to page.
But can this prayer be maintainable before this police court, my lord?
Kindly consider page 21.
Please report the queue.
Page 20.
দেখেছি
20 of the writ petition wherein I have
Kindly see the prayer, my lord.
the stock permit not for sale. And they are now going to sell the entire minor sand from the riverbed of Rupnarayan.
With due respect, I'm going to report or submit a report in respect of the very the petition is Sheikh Masood Hussain. As per report from Officer V. Laro, got the permission.
Now this is. My lord, page 3, my lord. The last paragraph.
They have got
Permission has been granted to them and they are.
Yes,
permission has been granted.
Yes, I have the
For handling the sand, not for the sale of the sand. Kindly see. I attach the permission also, which is at page 17. Kindly look to page
And that's for
17.
dredging the sand only.
Yes.
Yeah.
Dredging permission, it is over. Inland Waterways has given the permission and the tenure is over.
No. I am holding the, my lord, present.
My lord, this is stock permit. So stock permit is still valid.
Now, my lord, kindly see the 3 permissions.
Selling permit is there.
Kindly look to page.
Yes, my lord, there is a permission. And it is valid for 60 days.
For selling.
Yes, it is issued on my 10th March.
This is dredging.
Kindly look to page 21.
Let them file every.
Page 20. Kindly see.
My lord, kindly see the prayer, my lord.
How do you know what documents he has?
Yes.
Not for sale.
My lord, we are submit.
Subsequent এই তো চারটে ডিপার্টমেন্ট চারটে করে দিয়ে দেয়।
Yes.
In the stock permit, it is mentioned that
first one is
for sale.
desilting permission is given by Inland Waterways. Second one is
চলে আসুন
given.
But, my lord, before passing my lord order, kindly see the prayer, my lord.
Affidavit.
Kindly see the prayer, my lord.
Affidavit you file, you are showing a document.
Yes, yes. I will definitely file. But
File
can
that in
this
the form
prayer
of an
be
affidavit.
maintainable, my lord, before this court, my lord?
Huh?
This is the prayer. Can this prayer be maintainable before this court, my lord?
If a public property is sold, police authorities have right to register a case, sir.
My lord, there is no complaint yet made in the annexed also in the petition, my lord. Kindly consider this aspect. That is his oral allegation before this
that
court.
you have the permission.
Yes, I will show, my lord. I will show.
Permission. This is dredging.
I will show.
I have attached.
I will show.
I have attached with the writ petition.
I will show.
Petitioner, he has got selling permission. He will show, sir. How are you?
In the meantime, my lord.
State selling to state authorities only.
See, Judge, you produce that.
Yes, definitely I will.
Petitioner is aggrieved by the inaction of the police authorities to the extent that the private respondents had been in selling the sand, which is outside the scope of the permission granted aid by the ADM and DLA and LRO. Full learned advocate for the private respondent opposes the same and submits that he has got permission to sell the sand so collected aid in course of dredging
to the government
to
only,
the government authorities. তাহলে তো আরো সুবিধা গভর্নমেন্ট অথরিটিতে থাকবে ডকুমেন্ট।
They are now selling the private persons. Kindly see page 20. Consider page 20.
Let them produce the documents. Acha, in view of the factual dispute which has been raised by the private respondent, let an affidavit. You are who?
I am respondent number 10.
I am for respondent number 7, Inland Waterways.
ঠিক আছে, the central agency তো। You are central government basically.
Lordship, we have given the dredging permission only. Our role is limited to that.
আচ্ছা, learned advocate 8 for the respondent number 7 and respondent number 10 will file their affidavit in opposition within a week after the ensuing summer vacation. 2 weeks. Affidavit in reply, if any, be filed 2 weeks thereafter. List the writ petition under the heading 4 orders in the monthly list of July 2025. আচ্ছা এখানে কি এ তো সবই বলছে এটা ঠিক আছে বলছে।
No, no, no. Kindly.
I can show herein now.
But in the meantime, let them restricted to.
অরিজিনাল সাইন বাই দ্য এডিএম দেখি
My lord,
ফটোস্ট্যাট কপি হলে ইম্পোজ করে দেবো। ফটোস্ট্যাট কপি হলে
recently I have photostat copy. I
না
can show original, my lord.
অরিজিনাল চাই আমার
Original আছে আপনাদের কাছে এখন?
কারোর কাছে থাকে না,
মানে it is
ওর উপরই আমাদের বিচার করতে হয়। চলো নাও নাও
you know, kindly fix it, my lord. Tomorrow, my lord, I will show the original.
চলো নেক্সট।
To the government.
Grateful.
May I please, Lord, for the publication.
ওইটুকু কনফিডেন্সে বসি, হ্যাঁ থাকবে না অরিজিনাল।
Lord, I appear for the state respondents.
Yes, sir.
My lord, the petitioner is the father of the victim girl. My lord, the case goes like this. On 30th of March 24, the minor daughter of the petitioner was kidnapped by the Ranjit Jana. Thereafter, my lord, and 363, 365 of the Indian Penal Code case was started. No POXO provisions were added. My daughter is a minor girl, man. No provision was added. Thereafter, charge sheet was submitted, and ultimately my daughter was recovered. Thereafter, my lord, on 26th of February this year, my lord, my daughter was again kidnapped by the same person, my lord. I lodged a complaint before the Agra police station. The Agra police station lodges another provisions with regard to only BNS, my lord. They have not added any POXO provisions, my lord. There again, my lord, till now, my daughter is not traceable.
The same person?
Same person, my lord. The person's father and mother was.
So far as the first case is concerned, there has been a charge sheet. Now, my lord, the victim girl came back to the parental house, and then, my lord, but then the local witnesses said that she is again mixing up with that fellow. My lord, it's very difficult.
All right, I'm keeping up. 2 months time I am granting. 2 months time I am granting. I'm keeping this after 2 months. Submit a progress report. You are carrying on the process. In
Yes,
the last paragraph it is seen. Petitioner is aggrieved by the fact that in spite of Agra PS case number 150/2025 dated 26/2/2025 having been registered for investigation, till day 8 the victim girl could not be recovered by the police authorities. The state has submitted a report. Report reflects earlier the victim girl the earlier an information was lodged for which Agra PS case number
198 of 24.
198 of 2024 was registered for investigation, and consequently the victim girl was recovered. Subsequently again
Started
the victim girl had been missing, for which an information has been furnished, and Agra PS case number 150/2025 has been registered. The police authority is putting in their efforts for tracing out the victim girl. Also, petitioner is aggrieved regarding the nature of the sections which have been incorporated. The same would be considered after the police authorities are granted opportunity to recover the victim girl by exhausting the remedies available under the law. List the writ petition on 3rd of July 2025 under the heading 4 orders. A progress report be submitted by the investigating authorities on the date so fixed. কি করে হবে এটা? How can not? Reports submitted be kept with the record. Next.
My lord, I am for the state respondent.
Yes.
My lord, we have received a complaint. My lord, inquiry conducted. FIR registered on 26/4/2025 under section 115(2), 118(1)(2), 303(2), and 35 of the BNS, my lord. 2 persons were arrested.
They left the house.
2 persons were arrested, my lord, and raids are being conducted to apprehend the others, my lord.
Yes, what is your contention, sir? You approach this court for registration of FIR. Prayer A.
FIR registered. My lord, the petitioner and his family members is compelled to leave the house due to this situation. Again,
You go return, police will see, ensure.
my lord, one thing.
That is not even in the complaint.
So, but that is in the prayers. Prayers
but not in the complaint. বাড়ি ফেরার ব্যবস্থা।
Dated 8/4/2025.
আচ্ছা চলে আসুন। Petitioner is aggrieved as the information furnished to the police authorities on 20th March 2025 and 8 April 2025 were not acted upon. Additionally, it has been contended that the petitioners are unable to return along with the petitioner is unable to return. Petitioner is unable to return along with his family members because of the atrocities inflicted by the private aid respondents. Full stop. State has submitted a report which reflects that on the basis of the information so furnished, Rajpur Peace case number 113/25 dated 26/4/2025 has been registered for investigation, and two of the accused persons, namely Sheikh Harun Rashid and Mokim Molli, were arrested. Full stop. Primarily, so far as the issues related to registration of FIR is concerned, the same has been subserved as the police authorities have acted on the information so furnished. However, the plight of the petitioner so far as returning to the residence still remains. In case the petitioner approaches the police authorities, uh, separate area, this same house, any land dispute or no?
The land dispute is there.
But the residence is theirs.
They-
The same residence.
Same within the same police station.
The residential building same or different?
Co-owners
Co-owners.
Of the building.
No.
it's not a building, my lord.
No. They are not the co-owners. They are not the co-owners, my lord.
Not the co-owners of the building. ওখানে একটু বলে কি বললাম এখানটা লাস্ট আরম্ভ করেছি না করিনি learned advocate for the petitioner submits that the petitioner has his own residence which is separated from the act of the private respondents, but they are unable to enter as in the vicinity the private respondents are abusing their influence. Full stop. In view of the aforesaid, if the petitioner approaches the police authorities, the police authority would ensure that in case the petitioner and his family members return to their home, no
Already approached the police authority.
I'm now directing no untoward incident should result, and the police authority would oversee that no breach of the peace and or tranquility takes place because of the petitioner and his family members staying at their residence.
Should we have to escort her back to?
You will just ensure that is your duty. How you will do it's up to you. With the aforesaid observations, WPA 9250 of 2025 is disposal. Reports are submitted. We kept with the record. আর কিছু নেই তো এখানে?
Grateful, my lord.
I'm for the private respondent number 6 and 7, my lord.
Very good. Yes.
The title suit is pending
Title suit pending, my lord, and
and already
what has already been gifted to the private respondent. Private
Occupied or trying to occupy? Occupied হয়ে গেলে আর কিছু হয়।
deed of gift, cancellation of deed of that is the main subject matter of title suit.
Petitioner is agreed by the petitioner is aggrieved by the fact that in spite of informing the police authorities, no steps have been taken and the private respondents have been disturbing, interfering, and finally has been successful in grabbing the property belonging to the petitioner by petitioners by flexing their muscle. Full stop. Learned advocate for the state has submitted a report. Report
Under section 34 of the Specific Relief Act.
report
Section 9.
that title suit is pending before the learned civil judge junior division second court Bolpur Birbhum being TS 51 of 2023.
Plaint is enclosed, my lord. Kindly see in my report. Plaint is enclosed. Suit for declaration that deed is a void one.
The prayer in the say a title suit is for a declaration for a declaration in respect of the gift deed which was registered with the ADSR office to be void as the same was forged. Full stop. Police authority. Next, police authorities have also drawn up proceedings under section 126, 135 of the BNSS. Learned advocate for the respondent number 6 and 7 submits that absolutely a civil dispute is attempted to be given a flavor of a criminal proceedings by invoking the jurisdiction of the court. Full stop. I have considered the submissions since and is of the opinion that since the civil court is already insisting of the issue, it would be for the petitioner to exhaust her remedies before the said court. However, police authority is would continue their surveillance and ensure that no breach of the peace and or tranquility and or any untoward incident results because of the strained relationship existing between the parties. With the aforesaid observations, WPA 9254 of 2024 is disposed of. Reports so submitted be kept with the record. A copy of the report be handed over to learned advocate appearing for the petitioner.
My petition wala. Cyber crime wala. What has happened? Bank account. 1,10,000 rupees was lying.
She has shared the PAN details, other details upon receiving a call.
Thereafter, not only that, 1,10,000 has already been siphoned up. Thereafter, 3,50,000 loan has been sanctioned in my name. How it is possible? It is in collusion with the bank employee, and bank to accept the complaint first.
Now a case has been registered too.
Case has been registered.
Case has been registered too.
And my lord, we have also
Recently, on 13th April,
upon investigation, my lord, it has been found that the amount has been transferred to a gateway named PayU. My lord, CDR is being obtained, my lord, pertaining to the said numbers. Also, my lord, we have sent requisition to the nodal officer, my lord, of the PayU for all the details, my lord. And my lord, we have received details. And if your lordship kindly comes to my report, my lord, para 6.
এরা পারবে না সাইবারকে দিয়ে দেবো
My lord,
it seems to be
that
tough.
can be done, my lord.
Cyber crime police station, Bidhanagar police commissioner. Huh?
Well, in the matter, what has happened? That was what arbitration proceeding has already been initiated for not paying the loan amount.
সেটা পুলিশ ইনঅ্যাকশনে কি করে ডিল হবে? মানে how can that part be dealt with by the police?
3,50,000 sanction in my name, who has received it? I have not yet signed the agreement.
You don't have to sign. You only have to now punch the button.
No, she has shared her PAN number, other details.
Petitioner is agreed by the act that
But how the second
in spite of
that means, my lord, as far as that allegation, police has got no role to play.
Information
Arbitration issues.
furnished investment of the petitioner being defrauded of rupees 1,10,000 and an alleged loan being dispersed to the tune of rupees 3,50,000, being informed to the Newtown police station. No effective steps.
My lord, just for a moment, my lord, these steps that we have been taken, my lord, is reflected in paragraph 6.
I've seen
A
that,
to H.
seen
A
that.
to H. A to H.
Subsequently, in Newtown PS case number 81/25 dated 13/4/2025 has been registered for investigation under the railway and provision. Problem is what you know. 13/4/2025 Newtown also writes IPC.
This is also cybers.
ওটা আলাদাভাবে সামলাতে হবে ওইটাই নিউটাউন দেখে নেবে হ্যাঁ আচ্ছা state has submitted a report or reflects that the amount, the current status of the defrauded aid amount was transferred to the merchant gateway PAYU, PAYU, huh? Inverted এর মধ্যে PAYU টা দিয়ে দাও আচ্ছা the investigating officer has taken in steps. However, having regard to the complexity in the investigation, I am of the view that the investigation of the case be transferred to Cybercrime Police Station, Bidhannagar Police Commissioner aid, so that at the same may be effectively investigated aid by the concerned police station. Accordingly, the investigating officer of Newtown Police Station is directed aid to transmit in the records of the case and hand over the case diary to the new investigating officer of Cyber Crime Police Station of Bidhannagar Police Commissioner.
Grateful, my lord.
Loan amount is 350 lakh, that is not
আমি কিছু করতে পারবো না, ওগুলো তো আলাদা।
liberty, that was one line of.
Police inaction case, my lord, how can that part be dealt with?
The aforesaid observations, WPA 9256 of 2025 is disposed of. Go before the appropriate forum.
Yes, one application before the appropriate authority for until the
ওটা আমার ক্ষমতার বাইরে হয়ে যাবে, ওগুলো করা যায় না।
investigation is complete.
A report so submitted be kept with the record.
My lord, report to be
A copy of the report be handed over to learned advocate appearing for the petitioner. কিছু নেই। Yes, next.
69, I beg to appear for the state.
Petitioner.
By Mr. Anta.
None appears for the আমি কি করব, none appears for the petitioner. Learned advocate for the private respondent as well as the state is present. Release the writ petition under the same heading in the monthly list of July 2025 under the
Report
same
will
heading.
be taken into
Next.
The lordship, the report will be taken.
For the state, my lord.
হারিয়ে যাবে।
Okay. 70 for the state.
State.
Yes, 70.
So now in GP panel.
Huh? Yes. Now.
Not more in PP panel.
No.
ভালো কথা।
So converted.
Petitioner. হ্যাঁ। পঞ্চায়েত মামলা
3 and 4. তাহলে পঞ্চায়েত।
শুনুন, the subject matter of the writ petition do not fall within the classification determination of the court. Accordingly, let the writ petition be released from the list. Petitioner would be at liberty to mention the writ petition before the court having determination. Next.
I am for the private respondents.
ভালো। Yes, come. আগে থেকেই বলে দিচ্ছি পার্টিশন before the civil court.
Yes, ma'am.
The direction passed.
My instruction, we are making electric income PV
Huh?
for non-suited property.
Non-suited
property.
Non-suited property.
That is my instruction.
এই দেখি রিপোর্ট আছে?
Yes,
Lordship. PS case has been started, Lordship.
তাহলে non-suited কি করে হলো?
Complaint.
My instruction.
পিটিশনার কি হলো? কি আর কিছু করা যাবে না, অ্যাপ্লিকেশন হ্যাঁ, আর রিটার্ন কি করা যাবে? পরের মামলার সাথে অ্যাডজাস্ট হয়ে যাবে। পিটিশনার আমি আর পারবো না, এগুলো সব গন্ডগোল হয়ে যাবে। অর্ডার টেক আউট অ্যান অ্যাপ্লিকেশন। I will
Last.
petitioner complains that a partition suit is pending wherein an identity aim order has been passed by the learned which court, page number learned civil judge junior division second court Uluberia, being TAS 160X of 2025. There has been in direction by the learned civil court on the inspector in charge Bagnan police station. Yet, the petitioner contains that the private respondents have been carrying out illegal construction by violating the order of the civil court. Full stop. Petitioner informed the police authorities. However, the police authorities did not take any action. State has submitted a report. Report reflects that police authorities have already registered when which police আমার এখানে দেখে মারপিট হয়েছে তো।
PS case number 254.
117(2) মানে মারপিট হয়েছে তো। হ্যাঁ,
Page 4.
Police authority is have registered Bagnan PS case number 254/25 dated 29/4/2025 under the relevant provisions of BNS. Full stop. Learned advocate for the respondent number
5 to 10.
5 to 10 submits that construction is going on, but in the unsuited property. Having considered that the police authorities have already registered a case and the private respondent admits that construction is in progress, police authorities would ensure that the order of the civil court is respected, obeyed, and implemented so far as the suit property is concerned. Full stop. In case any inconvenience is faced by the police authorities, they would inform the learned aid civil judge in of the issue. Police authorities would also ensure that no breach of the peace and no tranquility takes place and not any untoward incident results because of the strained relationship existing between the parties. With aforesaid observations, WPA number 9260 of 2025 disposal of reports are submitted be kept in the record. A copy of the report be handed over to learned advocate appearing for the petition. Next. কি হচ্ছে? হ্যাঁ?
Sitting demonstration, peaceful sitting demonstration.
Sitting demonstration, which area?
The Y channel in DD block.
না না ডিডি ব্লকে ওইটা দিয়ে দিচ্ছি
kindly see there was
you want one day it's already you are wanting long days, this is the difficulty. একদিন করবো আমি দিয়ে একদিন করলে আমি কোথাও দিয়ে দেবো, কোনো অসুবিধা নেই।
Kindly come to page 25, my lord. Page 24, my lord. That is the order passed by a coordinate bench with respect to a demonstration which the petitioners had held earlier, my lord. In that, my lord, the coordinate bench had passed an order to hold the demonstration in at the service road in front of Saurav Cricket Academy in Salt Lake, my lord. This was the order, my lord, which they had complied. If they want to hold the
now the position
demonstration over there,
now,
my lord, they can hold it.
Now the position is same because subsequently I have passed an order in that after instructions because over here near these are those school
bus stand is also there.
School Service Commission offices only.
Yes, that has come up.
That is why over there I am not.
এখানে আছে conflict আছে এখানে আছে তো that is there.
I know, I see in Salt Lake. DD will be better. This
but there is a service road, my lord, where they want to hold a demonstration, my lord. There is also a
if
service
you are ready, I have got no issues, sir.
They can hold it, my lord. We can.
We have no issue, my lord. If
one day.
At least lordship 2
days. No problem.
One day, that's.
This is why I don't want to give it. আগে দিন তো বলছো how many
already demonstrations are going on over there, my lord.
সব চারিদিকে একটা যাতা
it will create a chaos, my lord, and it will.
That is why I don't want to lead. কি হলো?
At least lordship 2 days.
It is the public who will suffer.
At least 2 days, lordship.
Then go to College Square.
Everybody wants to hog the limelight with the place.
College Square, that Bokim Chatterjee Road facing.
If that is there, but I have no issue.
Do it for 3 days. 3 days. College Square দিয়ে দিচ্ছি 3 days College Square facing Bokim Chatterjee Street. Ask your Calcutta police officers to come. Ask your Calcutta police officers to come and give instructions. He's from Bidhannagar. Tomorrow I'll pass the order. All right. How many persons?
300.
300.
200 to 300, my lord.
That cannot be.
এইগুলো করলে ঝামেলা হয়ে যায় প্রচন্ড। Be sensible, sir. Then rotationally you do 150 alternate day. 150 alternate day. All right. Tomorrow ask a Calcutta police officer to come. Supplementary affidavit file. Date with dates and all those things tomorrow. এটা কালকে
to be mentioned.
To be mentioned সকালে অনেক টাইম খেয়ে যাবে এটা 115 এটা একটা 15 not to 115 করে রেখে দিন কালকে within that file an affidavit the dates you want to do the time period in the day I'm telling you don't extend it how much time you want from which time to which time
12 PM to lordship 5 PM
হ্যাঁ ঠিক আছে 11টা থেকে 8টা পর্যন্ত আমি দিয়ে দিচ্ছি next which date to which date
বলো date
27 28 and 29
27th 27th
May lordship May this month
তাহলে তার আগে এত আগে এসে লাভ কি আমার কাছে
12টা সময় মানে
today and 7 that was
don't do it during that time খুব গরম থাকবে ওই সময় তো
lordship it's a peaceful demonstration
very stuffy weather at that time do it এই করে দিন না 16-17 থেকে করে নিন 16-17-18 করে নিন
lordship
এই গরম
we have no issues
150 alternate days for 3 days 16th 17th 18th you do between 12 PM to 5 PM make an application bring a supplementary affidavit preferably in the morning give it to him so that he can communicate with the Calcutta police
through email
also in the night you can serve through email so that he can have instructions ঠিক আছে, কালকে থাকবে ওটা 115.
Grateful.
You are for the state.
I am for the Indian Opinion Railway
I am
Authority.
for the state, my lord.
For the petition.
Ready? Who is the affected party?
Only
For the
Union of
petition of-
India, Railway
Union of India, you have instruction.
The allegation against the Railway Authority. My lord, this is a commercial transaction, dispute relating to commercial transaction. There was an agreement, my lord.
Where is the representation?
My lord, my presentation is page number 24, annexure P3. My lord, this is the dispute due to forceful positioning.
Opposite a forceful takeover by the help of RPF data.
Kindly see the page number
Station at Poshim Parna দেখছি এটা. So you have given it to OC Purshura.
My lord,
Huh?
due to forceful position of the Railway Authority. My lord, come to page number 23, my lord, annexure P2. This is the main page due to which grievance is raised.
তাতে installation hall contractor টাকে. আরে সেটা ঠিক আছে. Your allegation is 24.
Allegation is 24.
Is
Based on this internal memo of Railway Authority 23, page number 23.
So what are you wanting actually?
Reposition of my vault.
এটা আমার কাজ নয়. Railway authorities are not within my.
Arbitrator has already appointed by this honorable court against the application moved by learned friend by the same petitioner, my lord. And all dispute can be raised before the arbitrator.
That is a separate, sir. But there, what have you have received a representation? OC Purshura, have you done anything?
My lord, this is not no congressional officer is made. Huh? Forceful position, my lord, that is the himself, my lord, take position, my lord. Kindly see the report, my lord. He is representing the patient, my lord. At the time of the, kindly see, my lord, D, annexure D.
Oh, so big lovely.
Nothing
The easy domain of the police authorities or railway authorities?
Railway authorities, my
lord.
Nothing has been taken over.
Rail ke nahi.
I am for the Railway Authority.
No. Which court takes up railways? This is not a police problem.
Railway Authority, well, there is no special determination about Railway Authority. Arbitrator has been appointed by my learned friend's application.
Police has no role, my lord.
And wherein all dispute was directed to be raised, my lord. Kindly go to the order of this honorable court, my lord. On the same issue. Issue is same, my lord.
Earlier you have approached. Earlier have you approached?
Yes, by filing an application article.
Huh?
Arbitration application.
Earlier he has approached this High Court.
Yes, by filing an arbitration application. Arbitration has been passed for the agreement, Lord, but this is a part of the agreement. Dispute regarding the possession, taking over, handing over. After
interim order rejected, my lord.
After expiring the tenure, my lord, he has been dispossessed.
Oh, wow.
After vacating the interim order, initially they went to the Hooghly District Judges Court and obtained an interim order.
That was vacated.
That was vacated.
Learned advocate appearing for the petitioner submits the ad he has filed the present with petition as there has been inaction on the police authorities as officer in charge Purshura police station did not respond to the representation. The main thrust of contention of the petitioner is that the private opposite parties have forcefully taken over the possession with the aid and assistance of Railway Protection Force on 7/3/2025 at 12 p.m. Learned advocate appearing for the state submits that the police authorities had no role to play, had no role assigned because of the property belonging to the railway authorities. Learned advocate for the respondent number
5 to 7, madam.
5 to 7 representing the railway authority is submits that after expiry of the tenure, possession was taken, and to that effect, petitioner has already approached the
my lord, possession was taken over, my lord, by the present of the representatives of the petitioner, my lord. This is my report. Kindly see, my lord.
They are saying otherwise.
No. Possession has been taken with the consent, the representative of the petitioner is present there, my lord.
The petitioner has approached now. Petitioner has approached the court for invoking the arbitration agreement. Accordingly, huh?
Stay order is there. And arbitrator has been appointed, my lord.
Accordingly, a sole arbitrator has been appointed by the Honorable Court in AP-COM oblique 164 oblique 2025. Since the court is since the arbitrator is in of the issue pursuant to direction of the High Court, petitioner will take up the issue before the arbitrator, who is arbitrator. Police authority is cannot are not empowered under these circumstances to respond to the grievance expressed by the petitioner. With the aforesaid observations, WPA 9266 of 2025 is disposed of. Sabak office chalo. চারটে কি ফিক্স আছে আর কি আছে কি হিয়ারিং মেট একটু লিখে দাও না 75 ঘন্টা লিখে দাও না তারপরে ধরছি
My lord, item 77 will be called for or released, my lord.
Mr. Banerjee will decide. Yes, which for the state? Yes. Tati, কি আছে? Yes, sir. What is your grievance?
I am registered owner of the state property of my brother and other matters. They are private respondent matters. They are taking physical and mental torture and as well as
Disturbing your enjoyment of the property. তাই তো হ্যাঁ কিছু নেই petitioner petitioner is aggrieved by the fact that in spite of informing the police station, have you 35 in spite of informing the inspector in charge Farakka police station, no steps have been taken. According to the petitioner, the private respondents, have you made them private respondents? হ্যাঁ আছে তো নেই according the petitioner
brother, sister, and
the family members are interfering and trying to grab the property of the petitioner and also attempting to throw them away from the property. Full stop. Why haven't you made them a party? Achha. Further, the petitioner and the other family members are also subjected to assault and their livelihood their life has been made miserable because of the continuous physical and mental torture being inflicted. State has submitted a report.
Third paragraph.
The report reflects that on receipt of the information, the inspector in charge of Farakka police station have taken steps.
And the third paragraph of the first paragraph.
Taken steps, have taken steps by drawing up proceedings under section 126 of the BNSS, having considered that there is a dispute, or there is a family feud, which is difficult for the police authority is to directly interfere. If the petitioner is aggrieved, petitioner will approach the learned aid, jurisdictional magistrate, and in case directions are passed, the police authority would be empowered to take action pursuant to the directions of the learned magistrate. In the alternative, police authority is, as they have been in keeping vigil, they would continue the surveillance and ensure that there is no breach of the peace and breach and not tranquility and not any untoward incident resulting from the inimical relationship existing between the parties. With the aforesaid observations, WPA 9268 of 2025 is disposed of. Reports are submitted. Be kept in the record. A copy of the report be handled and applicable for the petitioner.
75.
Yes,
It's an unfortunate person who lost his eyes for hitting by
yes.
person who is living.
What are you wanting now?
Wanting impartial investigation because the person who hitting my eyes, hitting me, is police person, police personnel from Shantiniketan PS. He hitting by use his gun butt on my eyes.
Page 16, your lordship, kindly see page 16.
Of the
petition.
Read petition.
The prayer, first prayer. It is the nature of mandamas directing the responsible authority and its main agents and subordinates to appoint a special investigation team to investigate and inquire into the offense in connection with Bolpur case number so as the police authorities of Bolpur police station may be compromised or biased. Totally out of apprehension, not only I am playing lot investigations on, but
Mr. Ganguly, Mr.
can be not the fix the superior officer to
I'm lost my eyes, Lordship.
I'm not.
That is a different issue then.
Lost. There is a LP Pushad prescription.
একটা minute.
And charge sheet has been filed, therefore warrant of arrest has been submitted before the
investigation to complete হয়ে গেছে.
Complete, charge sheet submitted. And the person who is not actually fled away, we are already paid for issuance of warrant. That is the next thing. And all documents I have annexed. But he has a remedy to before the learned court below to make for further investigation, prayer from further investigation.
Produce a case diary thereafter. I'll just only check what medical documents you have collected. I will not pass any orders.
I have anything all documents.
Page number 41, your lordship.
All documents, medical documents, everything.
Page number 41, your lordship.
No, what they have. You have.
Yes, kindly see below the documents. All documents below. Medical Center, Ramakrishna Medical Center. Page 36.
Just tell me one thing. He is in service. The accused.
Accused?
Yes, your lordship.
Okay. কি নাম?
হাসেম আলী আবার কি?
Posted in Shantiniketan PS.
That is for them, sir. Then he should come within the fold of law, sir. এটাতে একটা বড় প্রবলেম হয়ে যায় কোর্ট তো আফটার আমাকে তো ডিসিশন নিতে হবে accused is a police person. Now warrant of arrest is pending. If he doesn't take any steps, police authorities, you see.
No, my lord, accused Mineral Sheikh and son of so-and-so, district Birbhum, and Sahabaz Sheikh. Both, my lord, against both, my lord, the arrest warrant has been issued.
You see, your case was started against Hasem Ali.
But
especially it came to reveal identity of other accused.
Lordship, kindly see.
Yes.
The 35-3 notice was issued. Second page of the report. Accused Hasem Ali so and so surrendered before the landed SCGM, Dolpur Court on 21st February and released on bail. As per source of information came to reveal the identity of other involved accused person, Mineral Sheikh transactions.
Who are they? Minal Sheikh and Shahbaz Sheikh?
They are also accused.
Accused.
They are not the police officers or police personnel.
They are police personnel or no?
No.
Only Hasim Ali.
Hasim Ali, you take steps if you are aggrieved, sir.
Cancellation
It has been
bail.
granted bail.
I'm filing after the
What are you wanting now? Say, tell me, charge sheet has been served.
partial investigation
Investigation complete to
after filing my writ petition.
I don't think so, sir.
Yes.
30th March.
30th March.
30th March.
30th March. But don't get any information.
April 25. 10th of April.
10th of April. I have.
30th March, charge sheet filed.
All right, what I'm doing for the time being, because see, charge sheet has been done. You receive the copies from the court below. I'm directing. If you have any grievance, you address that court, come back to this court. Petitioner alleges that since one of the accused happens to be a police personnel, proper investigation, proper investigation.
Can I give the
proper investigation was not carried out in connection with Bolpur PS case number 75/25 dated 13/2025. And as such, pray aid for investigation by an independent agency. However, state has submitted a report which reflects that charge sheet has been submitted before the jurisdictional court under the relevant provisions of BNS 2023 against 3 accused persons, out of which 2 of the accused persons are absconding. In view of the investigation having been concluded, I direct the petitioner to apply for supply of the documents the prosecution proposes is to rely upon in this case. If such an application is made before the jurisdictional court, the same may be supplied within a period of 15 days. Petitioner would be at liberty to take out an application for further investigation in case petitioner is aggrieved regarding the materials collected by the investigating agency and or any other accused being discharged from the case. Also, learned a magistrate would dispose of the say application in accordance with law, preferably within a period of 60 days from the date of filing of such application. Full stop. In case the petition petitioner will thereafter exhaust other remedy is available to him under the law. With the aforesaid observations, WPA 9270 of 2025 is disposal reports submitted. We kept in the record copy of the report. We had it on Nana Advocate available.
Sir, flat the
আর করবে সবাই
up to 80.
Next.
Up to 80.
80.
80.
Other councils are waiting actually.
My next item.
The hearing is there is a hearing of
76 all are here.
All right.
The petitioner for
Petitioner 76.
76.
Civil matter.
petitioner not
All right, up to 80. Yes.
I am appealing for the private respondent 6 and 11.
Yes, sir.
Matter, Your Lordship.
Not civil matter.
I have already challenged before the LRT. I have already filed an appeal.
Yes, Mr. Dotto, you are there. Civil matter. কি বলছে মিস্টার ইয়েস মোকাররম হোসেন
Lord, Annexure P3 is a forced deed
বাহ
which is authenticated and certified by the district land and land reforms officer. Lordship, kindly turn to page.
Petitioner is my stepmother.
ঠিক আছে ম্যাজিস্ট্রেটের কাছে চলে যাও
Lord, 100 and
want to get FIR registered তো
no FIR registered, and my lord, on the other hand,
I have filed an appeal against that order, DLRO.
Lord, let it be, my lord, let
But
it tomorrow, my lord, because I have to make.
say I'm waiting.
Lord,
Your deed according to you is a forged deed.
their deed.
Their deed is a forged deed.
Forced deed. Because my lord, the deed number which they have shown, my lord, that is in another person, another vendor and purchaser, which is authenticated by the, my lord, ADSR Birbhum. And thereafter, my lord, in an appeal under section 54, the learned district land and land reforms officer, my lord, disclosed the same page 111. Lordship, kindly see for a moment.
So you are wanting a criminal case?
Criminal case, and
may I?
disturbing me.
Only 30 seconds, madam. May I?
একদম নয়।
No, see,
Petitioner is aggrieved by the fact, as he claims that the private respondents have forged
How can I forge?
Predecessor of private.
Ma'am, it was gifted by my father to my mother. Both are tied. Both have.
the private respondents are beneficiaries of a forged deed. The criminal case হবে কি করে?
I'm coming, my lord. Lordship, kindly see, my lord. One thing, my lord.
She is my stepmother. I have already challenged. I have filed an appeal before the LRTT.
And tomorrow, land matter.
It's a civil matter.
Now, nothing.
Decide your lordship.
Now arises is with regard to the recording before the concerned land revenue officer. The recording has been wrong according to them.
Well, I have challenged it.
That has been challenged.
That is challenged, your lordship.
Allow me to make my.
And you have got to make out a criminal case. I am not hearing land matter.
No, my lord. This is not land matter. This is not land matter, my lord. The annexure P3 and P5.
DLR records, it's a false deed. I have challenged that order.
Alleged forged deed is of 1980.
Yes.
Last page is the complaint. Last page is the complaint. Something has
that property has been sold to a third
number.
Page
number.
But I'm coming, my lord.
No, there is no coming. Page.
My lord, page 34, page 42. Page 42, annexure P3.
এটা ঠিক আছে হবে। এইটা এক কাজ করে এক্সচেঞ্জ অফ এভিডেন্স রাত 4:05টার সময় আমি let them submit their affidavit thereafter I'll consider.
I'll not get any.
Let them submit affidavit. Question of facts though. You say this is a forge, that it is forged.
The question of fact is already before the LRTT.
Page 111 for a moment. 111.
Let them dispute the facts.
100.
They will not admit.
It is decided by before the appellate authority under section 54 of the LRA.
What is
I have
decided?
challenged.
111.
My lord, page 111, my lord.
What is there?
My lord, lordship, kindly see, my lord.
Section complaints order and the subsequent mutation in the authority and in mutation. The mutation though.
Yes. Recording of land.
And that has been restored back to my grandfather.
Set aside with a direction to restore that is in the name of Porijon Nesha Bibi.
My grandmother.
Sheep kindly.
Her mother-in-law.
I'm coming.
You never need to change na phone
disposed of. He has made allegation of ingrace and exgrace in common order. Strict vigilance. 111 against the third party.
Yes, 111 what?
111 fourth paragraph.
Yes.
The report of the allegation of the second paragraph, the allegation of the learned advocate for the appellate is that the record framed.
Whatever is come to the last paragraph, sir. To restore the disputed plot in the name of Porijon Nesha Bibi.
Lordship, kindly.
Grandmother, mother-in-law.
You come to the 112.
They are not allowing me to make my submission.
So
how will you make my submission?
Who is Porijon Nesha?
This is not the way, my lord. I'm sorry to say. My lord, the report, fourth paragraph, the report of the DSR number so has been received, and from where it reflects that the deed being number 4158 of 1980, that is annexure P3, which they are claiming, registered at ADSR Muraroi contains different names of the purchaser and vendor, and also contains different land schedule. Thus, it appears from the record of Angura Begum, that is the mother of the private respondent, is based perpetrated fraudulent method to obtain her name to be recorded in the LR Papier number so and so. Therefore, it is crystal clear that subsequent mutations should work in the name of Masud Khan, private respondent, one of the private respondent, in LR Khotiar number so and so, by way of transfer of the legal heirs of Angura Begum, that is the mother of the private respondent, is also bad in the eye of law, insofar as it is settled law that once the foundation is removed, the superstructure falls down.
Then continue. No, then you can't stop.
The facts and circumstances, the appeals are allowed. It is filed by us.
So thereafter,
It is filed by us. The order dated 6/6/24 passed by the prescribed authority under section 51 of the WPLR Act, that is the PL and LRO. In compliance of the order of the OA number 21 of 2024, because as our name was not recorded by the BLRO, I filed an application before the LRTT. LRTT directed the concerned BLRO to consider my case. The Honorable LRTT and the subsequent mutation case number so and so by the prescribed authority under section 50 of the LR Act 1955 in mutation case proceeding number so and so are hereby set aside with the direction of BLR. Set aside, that is my case was turned down before the BLRO, and if the BLRO hold that the Angura Begum is the owner.
No.
Where from are you saying? To restore this in the name of Porijon Nesha Bibi.
Porijon Nesa Bibi, that is my grandmother.
Mother-in-law.
Sorry, mother-in-law.
My grandmother.
Who, my lord, gifted the property annexure.
বাস ঠিক আছে আর নয় হয়ে গেছে বাকিতে অ্যাপিল করতে হবে
My complaint is lordship kindly my
petitioner is aggrieved
my lord, only one
he is represented no more sir you go to the appeal court sir no I have given enough time go to the appeal court পুলিশের আর কি করা আছে আমি তো বুঝতে পারছি না
they are disturbing my position
এতক্ষণে এই কথা বলছো
Disturbing is the third person, not me. I am not in possession.
এতক্ষণে এই কথা বলছে
One
the property to third person.
Bulbul Ahmed is in that property sold.
Let them say that they are
petitioner is aggrieved by the so if you quarrel like this unfortunate after 40 years of practicing you start this I am dictating order you can be aggrieved there is an intra-court appeal go over there sir I have given you enough audience so petitioner is aggrieved by the act that the private respondents have sold away the property in spite of the findings of the district land and land reforms officer Shuri Birbhum. Petitioner claims that there were fake and forged documents prepared which were brought to the notice of the concerned land officer and the officer in the appeal preferred at the behest of the present petitioner decided to arrive at a conclusion which holds the contentions of the petitioner to be correct. However, the private respondents have been beneficiary and the petitioners have been subjected to wrongful loss. Full stop. What is your contention?
I have already challenged in order to the
আচ্ছা ঠিক আছে
because there I have sold this property to the third person. He has already mentioned in his
আচ্ছা ভালো হচ্ছে
He is in possession, not me.
সেই হাওয়ায় মামলা হচ্ছে হোক learned advocate appearing for the private respondent submits that an appeal has been referred in respect of the order of the এটা কি BLRO of the district land of the district land and land reforms officer which is pending before the WBLRTT. Full stop. Gallo. Respondent admits that he has sold away the property. As such, full stop. Learned advocate for the state has submitted a report. Report reflects that in order to restore peace and tranquility, police authority have taken steps and drawn up proceedings under section 126/135 of the BNSS. Learned advocate for the petitioner submits that there has been interference with the property and disturbance has been created by the private respondents. Be that as it may, since the police authority have been continue their surveillance pursuant to the proceedings drawn up by them under section 126 of the 135 BNSS, I am of the view that the police authorities would ensure that no untoward incident results because of the strained relationship between the parties. First up, if the petitioner is also granted liberty that in case petitioner has documents in his possession, he would approach the jurisdictional magistrate by way of invoking the relevant provisions of BNSS. Learned magistrate would assess and ascertain whether a case has been made out and accordingly exercise his discretion in accordance with law. With the aforesaid observation, WPA 9272 of 2025 is disposed of. Reports are submitted. We kept with the record. Copy of the report be handed over to both the parties. So, দেরি করবে।
Copy of the report.
হ্যাঁ বলেছি তো 77 কে আছে
77, my lord, I am for the state, my lord.
Petitioner is not there. Tomorrow, petitioner is not there.
My lord, come to the prayer in portion, my lord.
Petitioner is not there. 78.
Oh my.
It is there. Oh, no report. Not next week. I'm getting. In view of the prayer advanced by the state and the petitioner are being represented, list the repeat another same heading. কবে করবো 14 on 14 May 2025. Next.
But I am appear on behalf of the petitioner, my lord.
আবার শেষ মুহূর্তে সে আসবে রেডি
Service.
My lord, I am appearing on behalf of the state, my lord.
I am whenever I am going to cultivate there, my lord, the private respondent are coming and disturbing.
Your plot
My
of
lord, may I allow to submit subject to your correction, my lord? Both parties are the owner of the land. There is no demarcation. I have been a police officer. I have advised them to go before the civil court.
Police cannot advise me to go.
No. Petitioner claims that the private respondents are interfering at the time wherein he is involved in cultivation. To that effect, information are being furnished to the police authorities. However, the same did not yield any result. State has submitted a report reflects that the land referred to at the by the petitioner is an undemarcated property and both are co-sharers of the same property. Both are co-sharers of
my
the
lord.
Having considered the fact that the petitioner has a petitioner also one of the co-sharers, as has been admitted in the police report. Police authority would police authority would continue their surveillance as they have already drawn up a proceedings under section 126 of the BNSS and ensure that no breach of the peace or tranquility or any untoward incident results, particularly with regard to the issues of cultivation when it is carried on at the respective part of the property by both the parties. Full stop.
Yes.
The aforesaid observation, WPA 92715 of 2025 is disposed of. Report we kept with the record. A copy of the report we handed over to London.
Highly obliged, my lord.
Want to do it or no? Next day, তাহলে দেখি কালকে করবো। হবে না, 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 other lawyers are waiting now. Now 2 hearing matters are there. Fixed ম্যাটারটা ওনারটা তো আছে, আর কার একটা হিয়ারিং আছে? কার? Yours?
মালয়েশিয়া।
কোথায়? ধীরাজ ত্রিবেদী কোথায়? Bring him tomorrow. It will be in the list. Ask Mr. Trivedi to come tomorrow. There is a passport matter. He is not attending. As long matter, actually, what happened over here, it was cancelled, and the person got it from that embassy. 5 minutes break, sir. I'm coming back. No, not now. Tomorrow. আমি ঘুরে আসছি। 1 ঘন্টা 45 মিনিট পর 45 মিনিট পর। হ্যাঁ, না, না, হ্যাঁ, ও একটু করছে, আপনি দেখে নেবেন। কাউকে একটা পাঠিয়ে দেবেন 45 মিনিট পর। হবে না হিয়ারিং। This matter will continue now. He has come from Delhi. I'll continue. Let him complete. Tomorrow you will continue. 5 minutes, sir. I'm coming back. Just I'll hear you.
Wait, please, Your Lordship.
You'll be placed from your compilation?
My Lord, I had submitted a list of date note.
Yes, yes.
I had submitted, my Lord, a compilation of judgment.
Are you going to start from your compilation?
Compilation, my Lord, today.
Yes.
My Lord, just to preface, I had read before your Lordship, my Lord, the list of dates indicating, my Lord, that this inquiry or investigation under money laundering, my Lord, commenced on 24th of March. I have been arrested on 3rd April, my Lord. And the officer, I read, my Lord, the grounds of arrest. There are two documents, my Lord, grounds of arrest and reasons to believe in terms of 19. I had read before your Lordship, my Lord, that they quoted extensively whatever has been done by the predicate offense agency. And my Lord, there is nothing so far as material is concerned which is mentioned. There is some kind of a story. It's a factual narrative given by the officer, but we do not know, my Lord, on the basis of what material. Is it a statement? Is it a document? On what basis is he making those accusations? As before,
According to you, sir, what I have understood, if I'm correct, is that the ground of arrest which has been handed over,
my Lord,
to the petitioner,
my Lord,
is nothing but what is there in the predicate offense.
my Lord. This is one.
Therefore, the material in his possession,
my Lord,
which is there in section 19,
my Lord,
is not reflected in the ground of arrest
my Lord,
for the petitioner to understand what is the case against him.
There are two factors, my Lord. I'll improvise on it so that I can split it up. So ground number one, my Lord. Under 19, the officer had to gather material in possession on the basis of which he would write reasons to believe that the person is guilty. Before this is fulfilled, he cannot arrest. So, my Lord, he cannot rely upon material collected in investigation of a, my Lord, another agency. That may be a commencement point because that's an interlink. He is a parasitic of investigating a parasitic offense, which is dependent on that offense. But, my Lord, dependence doesn't mean borrowing that investigation. His investigation is entirely different because they are determining conduct, whether good, bad, ugly, worse, what kind of involvement in the criminal offenses there. That's the job of the other agency. But this ED officer has to determine the laundering part. So his investigation is independent. It has to be within the four corners of, my Lord, the PML Act 2002, nothing beyond. PML Act 2002, my Lord, stipulates conditions for, my Lord, every kind of an action, whether it is, my Lord, search, is it, my Lord, seizure, it is freezing, it is attachment, it is calling a person to make a statement under 50, it is, my Lord, any kind of action which is contemplated thereunder. It has, my Lord, special provisions. It, my Lord, also, my Lord, I showed to your Lordship section 62, which said, my Lord, vexatious search or arrest. Also section 63, my Lord. If a notice is issued to a person under section 50 and he fails to comply with it, either appear, my Lord, or doesn't speak the truth, because under 50, there is, my Lord, three things. One, that the officer who's calling, he is, my Lord, has a power of a civil court to enforce attendance. Two, my Lord, proceeding before him is a judicial proceeding in terms of 193 and 228 of the penal code. Three, my Lord, that the person who is, my Lord, summoned is under an obligation to state the truth before him. So these are different matters, my Lord. These are different level altogether. So, my Lord, whether Article 20, Clause 3 would prevail, that would be, my Lord, determined on a factual basis. But, my Lord, let me say that an ordinary a person is called, he is under this obligation. Therefore, my Lord, the admissibility of statements under Section 50 stands on a different footing than, my Lord, a statement recorded by a police officer during investigation in an ordinary crime, which is the scheduled offense in this case. So there are no parallels. He could not have borrowed, say, a confession made before a police officer under section, which is hit by section 25. I do not know what material I showed to you, Lordship, Lord, KTMS Muhammad, if my Lord would recall. That, Lord, a FARA investigation, a FARA confession being used by the income tax man, that I will use that confession there. My Lord, Supreme Court abhorred the idea, can't be. Otherwise, my Lord, you don't have, there is no segregation left then. So, my Lord, as we stand today, there are 3 or 4 arguments. I'll quickly make it. Number one, my Lord, Under 19, the reasons to believe have to be real, based upon material, which is, my lord, admissible in evidence, based upon all or entire material, my lord. He can't pick and choose a material. Number two, my lord, that 19(1) cast an obligation on him to pass an order of arrest, and that order, my lord, has to be based upon, my lord, the satisfaction which he arrives at on the basis of materials there and then. He can't improve it today. I said, my lord, that if I read his reasons to believe and grounds of arrest, as I understand, my lord, grounds of arrest are the grounds which would, my lord, show that why the arrest is necessary. Whereas, my lord, reasons to believe are the first requirement that, my lord, the man is guilty based upon the material basis. The word is on the basis of which. So the day of arrest is that basis, 19(1). So, my lord, I also said that, my lord, 19(1) stands on a different pedestal in the entire, my lord, I would say, statutory, my lord, history of our country. It was the first such provision introduced in the any enactment. And, my lord, in PMLA also, there is no such requirement for any other action except arrest, that the arrest, the yardstick is of that of guilt. So, my lord, having to touch that, I said, my lord, that in this case, reasons to believe and grounds of arrest are identical. There is no difference. And that's what, my lord, is discussed even in Kejriwal. My lord, the next point I said was, my lord, 19(2) had to be complied with. So here, my lord, reasons appear to be sham, pretense, confusing. If you are giving me reason, I don't want this investigating officer's factual narrative. You are a very bad man. You have indulged in X activity, Y activity. You and so, whom I do not know, but the first time in my life I've seen him in the jail. The gentleman, Lord Chirag Kapoor. I had no connect. So you and Chirag Kapoor have met. You have done this without furnishing any material, without furnishing material in the courtroom today. It is not part of his affidavit. I do not know why. Why could, my lord, I be deprived of his material on the basis of which he could redact it? That's what I'm going to read, my lord, Arvind Kejriwal, to your lordships. He, my lord, now says probably, and that of course he has to. Once your lordships call for the file, he will say, I have this file, I will furnish. His affidavit and, my lord, his grounds or reasons are now on poles apart, my lord, position. There is something which is absolutely different here, and I've prepared, my lord, made an endeavor to prepare a chart in the rejoinder. The second argument was, my lord, if we go beyond 19(1), is 19(2), which, my lord, I said use the word immediately. Punjab High Court, my lord, said 24 hours. Supreme Court, they themselves withdrew their SLP. I showed, I think, my lord, that order, Dilbagh Singh. So here, now first time I've come to know that, my lord, they had sent the material after 3 days. So 4th April is the arrest, 7th April they've sent the material. And how have they sent? I don't know, because there is an acknowledgement and forms provided. Have they sent in that, my lord, in the compliance with the procedure, the forms and rules which are prescribed or not? So I do not know, my lord, that your lordships will call upon them to say. The third argument is, my lord, which is again, my lord, of a totally different league, which is, my lord, the remand orders, duty of the court. So, my lord, I have read few paragraphs. I'll read it today. What is the duty of the court at the stage of remand? It is his duty to satisfy that 19 is complied with. And if he fails to discharge that duty, remand orders would be rendered patently routine and mechanical, my lord, and cannot cure constitutional infirmities. It's fundamental rights violated. It's the court's obligation to look into it. The third or fourth argument, my lord, as I build up.
So is it required pursuant to those two judgments? Of that Prabhu Purkayas and that Vian Kumar,
Lord,
subsequent remand orders would automatically be cannot cure the.
Lord, the original judgment is 1969, Madhulimai. So if I can read that, my lord, today, I'll start with Madhulimai.
So subsequent remand orders, I don't think is your point over here.
If original, my lord, Devinder Pal Singh Bhullar is the judgment, Constitution Bench. If initial action is not in consonance with law, all subsequent proceedings will fail.
Because earlier different judgments are there according to the facts of the case. Earlier it used to be said that the learned magistrate has taken cognizance of learned magistrate has passed the subsidy, it's been regularized and waiver of right. Now it's said that the illegality continues.
Correct. Please have a look at my case digest I gave to your lordship.
Yes, page number.
One is, my lord, case compilation, one was case digest, where, my lord, I had given extracts of cases.
You were not there on the earlier date. You are virtually appearing.
If we have not given, we have not. Just give.
Page number?
My lord, serial 17, page 48. We have made some changes in it, but which maybe we actually on every day he improvised something. Just turn to Lord serial number 17 in Madhulemai, 1969 judgment. Just see, brother. Otherwise, we'll point out the page to him, please. Article 22(1) embodies a rule which has always been regarded as vital and fundamental for safeguarding personal liberty in all legal systems where the rule of law prevails. For example, the Sixth Amendment to the Constitution of the United States of America contains similar provisions, and so does Article 34 of the Japanese Constitution of 1946. Whenever an arrest is made without a warrant, the arrested person has a right to be informed not only that he is being arrested, but also of the reasons or grounds for the arrest. The House of Lords in Chrysler versus so-and-so went into the origin and development of this rule. In the words of Viscount Simon, if a policeman who entertained a reasonable suspicion that X had committed a felony were at liberty to arrest him and march him off to a police station without giving any explanation of why he was doing this, the prima facie right of personal liberty would be gravely infringed. Viscount Simon laid down several propositions which were not meant to be exhaustive. For our purposes, Lord, we just skip these two and come to Lord, serial number 3. Another copy of this old one. It's circulate. In any case, you have given in the given the compilation. You are serial number 3. Requirement that the person arrested would be informed of the reason why he is being naturally. Disease naturally does not exist if the circumstances are such that he must know the general nature of the alleged offence for which he is detained. It remains to be seen whether any proper cause has been. First, you do it for my friend. This is not fair. Can I print out? It's not fair. Send us off. Yes. This is different. But it remains to be seen, para 11, whether any proper cause has been shown in the return for declining the prayer of Madhu Lemai and other arrested persons for releasing them on the ground that there was non-compliance with the provisions of Article 22(1) of the Constitution. My Lord, in Ram Narayan Singh, now please mark this, my Lord, Ram Narayan Singh is a Constitution bench judgment. Ram Narayan Singh, it was laid down that the court must have regard to the legality or otherwise of the detention at the time of the return. In the present case, it was so-and-so filed. Your Lordships may straight away, my Lord, skip a few lines. It has not been contended on behalf of the state that the circumstances were such that arrested persons must have known the general nature of the alleged offences for which they had been arrested with a proposition 3 so-and-so. nor has it been suggested that the show cause notices which were issued on November 11, 68 satisfied the constitutional requirement. Madhu Limayas and therefore are entitled to be released on this ground alone. The two requirements of clause 1 of Article 22 are meant to afford at the earliest opportunity to the arrested person to remove any mistake, misapprehension, or misunderstanding in the minds of the arresting authority, and also to know exactly what the accusation against him is, so that he can exercise the second right, namely of consulting a legal practitioner of his choice and to be defended by him. Clause 2 of Article 22 provides the next and most material safeguard, that the arrested person must be produced before a magistrate within 24 hours of such arrest, so that an independent authority exercising judicial powers may without delay apply its mind to his case. The Criminal Procedure Code contains analogous provisions in section so and so, but our constitution makers were anxious to make these safeguards an integral part of fundamental rights. This is what Dr. B. Ambedkar said while moving for insertion of Article 15 capital A as numbered in the draft bill, which corresponded to Article 22. Article 15A merely lifts from the provisions of the CRPC two of the most fundamental principles which every civilized country follows as principles of international justice. It is quite true that these two provisions contained in clause 1 and 2 are already to be found in the CRPC, and thereby probably it might be said that we are really not making any very fundamental change, but we are, as I contend, making a fundamental change, because what we are doing by the introduction of Article 15 capital A is to put a limitation upon the authority both of Parliament as well as of the provincial legislature not to abrogate those two provisions, because they are now introduced in our constitution itself. Now 12, my lord, and this is very significant, my lord, this 12th paragraph. Once it is shown that the arrest made by the officers were illegal, it was necessary for the state to establish at the stage of remand the magistrate directed detention in jail custody after applying his mind to all relevant matters. This the state has failed to do. The remand orders are patently routine and appear to have been made mechanically. All that Mr. Chagla has said is that if the arrested person wanted to challenge their legality, the High Court should have been moved upon under appropriate provisions of CRPC. But it must be remembered that Madhulima and others have, by moving this court under 32, complained of detention or confinement in jail without compliance with the constitutional and legal provisions. If their detention in custody could not continue after their arrest because of violation of 22(1) of the Constitution, they were entitled to be released forthwith. And my lord, the orders of remand are not such as would cure the constitutional infirmity. This disposes of the third. So, my lord, with this advent of law, I travel to, my lord, Pankaj Bansal, I showed to your lordships, my lord, where, my lord, I relied upon paragraph 14. The, my lord, it's the same echo. There, my lord, the learned ASG had vehemently contended that, my lord, after remand orders are passed, there's no question of the court's interference. And, my lord, that's what, my lord, Pankaj Bansal, the Supreme Court, reiterated, that if the initial arrest is bad and the magistrate has not applied his mind to the all proximate live and causal link there, therefore, my lord, the remand orders will not measure up. And that is, my lord, where the judicial review lies. And I am therefore challenging the remand orders well before your lordships. The third on the subject, my lord, one of the my lord, treatise on this subject I wanted to read was Arvind Kejriwal that day. So, my lord, Arvind Kejriwal has set these tones for 3-4 things which I've said in my words. But let me quote, my lord, the author of the judgment. The author of the judgment has delivered one more judgment, my lord, in January 25, which is in Radhika Agarwal. And Radhika Agarwal, my lord, is a judgment for GST and Customs Act cases, where, my lord, the author of the judgment, the my lord, Honorable CGI says that we have held as a ratio in Arvind Kejriwal this, and this has to be followed in arrest in customs as well as GST cases. So I don't have to labor much now. That, my lord, that judgment is not of reference, because on 2 points in the end, they made a reference in Kejriwal about need or necessity to arrest. So allow me to read, my lord, from Radhika Agarwal, the quotes straight away. Page, my lord, Given to my lord, or in the compilation, is it in the extract? No, then give Radhika. Give the judgment. You have it? What should I read from KP? Take it. My lord, I will go to Kejriwal. My learned colleague is alone today, so I won't blame her. Her companion is not here. So, my lord, Arvind Kejriwal on page 17, my lord, of the case extract, brother. A bare reading, paragraph 9, my lord. It's okay. This is my lord Radhika Agarwal. I can give it to my friend. May I take from Radhika Agarwal, my lord? It'll be quicker because, my lord, the author himself describes what they have held. So I'll straight away go to Radhika. Please take me to Radhika. My lord, paragraph 30, if your lordships would go to. This was, my lord, the arrest under the customs and GST. Paragraph 30, my lord, will find, my lord, at page 14 of this. 1/4. Pagination is on top left. No, that's why.
Paragraph 13.
Paragraph 30, my lord, at page 14.
30. Yes.
Arvind Kejriwal versus Directorate of Enforcement, a recent judgment authored by one of us, is a dictum relating to PMLA. This court held that power of arrest granted to the Directorate of Enforcement under Section 19 is fenced with certain preconditions. These preconditions act as stringent safeguards to protect life and liberty of individuals. The relevant portion reads, a bare reading of the section reflects that while the legislature has given power to the director and so to arrest a person, it is fenced with preconditions and requirements, which must be satisfied prior to the arrest of a person. The conditions are, he must have material in possession. On the basis of such material, the officer should form and record in writing reasons to believe that the person to be arrested is guilty. And third, person arrested as soon as may be must be informed of the grounds of arrest. And these preconditions act as stringent safeguards to protect life and liberty of individuals. We shall subsequently interpret the words material reason to believe guilty. Before that, we will refer to some judgments of this court on the importance of Section 19(1) and the effect on the legality of arrest upon failure to comply with statutory requirements. Mark this, my lord. Legality of arrest upon failure to comply with statutory requirements. Whether it is one or many, it won't make a difference, my lord. The moment it is, my lord, infringed any, my lord, procedural requirement, it will go to the, my lord, in interpreting, my lord, penal laws and their applicability, your lordships have always applied the strictest rule. And my lords have said, even if two interpretations are possible, one which leans in favor of liberty would be adopted, my lord. One of the latest one was, my lord, Rakesh Kumar Paul in that 167(2) matter, my lord. In that, my lord, that was a beautifully written judgment by, my lord Justice Lokur. And, my lord, one of the courts was this, my lord, when two interpretations, one leans in favor of liberty. Please, my lord, go to now paragraph 31. In Kejriwal, a combined reading of Pankaj Bansal, Prabir Prokayastha, and Vijay Madan Lal Chaudhary was adopted by this court. It was held that power to arrest a person without a warrant and without instituting a criminal case is a drastic and extreme power. Therefore, legislature had prescribed safeguards in the language of 19 itself, which act as exacting conditions as to how and when the power is exercisable. These safeguards include requirement to have material in the possession of DOE, and on the basis of such material, the officer must form an opinion and record in writing that there are reasons to believe that the person arrested was guilty of an offense punishable under PML Act. The grounds of arrest are also required to be informed forthwith to a person arrested. The contention of the DOE that while grounds of arrest were mandatorily required to be supplied to the arrestee, reasons to believe being an internal and confidential document need not be disclosed was decisively rejected in Arvind Kejriwal. It was held that reasons to believe are to be furnished to the arrestee such that they can challenge the legality of their arrest. Exceptions are available in one-off cases. Now, my lord, please mark this, where appropriate redactions of reasons to believe are permissible. The relevant portion reads thus, and I'm reading, my lord. Once we hold that accused is entitled to challenge his arrest under 19, The court to examine the validity of arrest must catechize both the existence and soundness of the reasons to believe based upon the material available with the authorized officer. It is difficult to accept that reasons to believe as recorded in writing are not to be furnished. As observed above, the requirements in 19(1) are the jurisdictional conditions. Mark this, my lord. They are jurisdictional conditions to be satisfied for arrest, the validity of which can be challenged by the accused and examined by the court. Consequently, it would be incongruous, if not wrong, to hold that accused can be denied and not furnished a copy of the reasons to believe. In reality, this would effectively prevent the accused from challenging their arrest, questioning the reasons to believe. We are concerned, now, my lord, please mark this, questioning the reasons to believe. I may very well question it. It's not an empty formality. I have given you reasons to believe. I have therefore satisfied 19(1). If I can lift the veil, my lord, and I can persuade your lordships to lift the veil and see through the real intent that reasons to believe are nothing but, my lord, a mere ipse dixit of this officer based upon no material or based upon inadmissible material or non-existent material, my lord, your lordships will not hesitate to call this bluff and, my lord, quash this arrest as being, my lord, invalid and illegal. My lord, please have a look at further, my lord, to line. We are concerned with violation of personal liberty and the exercise of the power to arrest in accordance with law. Scrutiny of action to arrest, whether in accordance with law, is amenable to judicial review. It follows that reasons to believe should be furnished to the arrestee to enable him to exercise his right to challenge the validity of arrest. Then, my lord, we would accept para 42, my lord, that in a one-off case, it may not be feasible to reveal all material, including names of witnesses and details of documents, when the investigation is in progress. This will not be the position in most cases. DOE may claim redaction and exclusion of specific particulars and details. However, the onus to justify redaction would be on the DOE. The officers of the DOE are the authors of the reasons to believe and can use appropriate wordings with details of the material as are necessary in a particular case. As there may only be a small number of cases where redaction is justified for good cause, this reason is not a good ground to deny the accused access to a copy of the reasons to believe in most cases. Where the non-disclosure of reasons to believe with redaction is justified and claimed, the court must be informed. The file, including the documents, must be produced before the court. Thereupon, the court should examine the request, and if they find justification, a portion of the reasons to believe in the document may be withheld. This requires consideration and decision by the court. DOE is not the sole judge. My lords have gone to the extent of saying that you have to disclose the material. Accused must have access to those materials. If you want to claim redaction, if you want to withhold something, you should inform the court, and then the court has to decide whether it has to be withheld or not. They are not the sole judges. I can't have, my lord, better words than, my lord, the Supreme Court itself saying. No, my lord, para 43, my lord. Section 173(6) of the code permits the officer not to furnish statements or make disclosures to the accused when it is inexpedient in the public interest. In such an event, the police officer is to indicate the specific part of the statement and append a note requesting the magistrate to exclude that part from copy given to the accused. He has to state the reasons for making such request. The same principle will apply. Now, my lord, para 33 is again back to, my lord, Radhika. Arvind Kejriwal also holds that courts can judicially review the legality of arrest. This power of judicial review is inherent in 19, as the legislature has prescribed safeguards to prevent misuse. After all, arrests cannot be made arbitrarily on the whims and fancies of the authorities. This judicial review is permissible both before and after criminal proceedings or prosecution complaints are filed. Please mark this, my lord. Judicial review is permissible before and after criminal proceedings or even after, my lord, prosecution complaint is filed. I am at the outset, my lord, before your lordships. Para 34, my lord. On the nature of material, now I'm coming to that, my lord. This is one of the most significant points. On the nature of material examined by the DOE, Arvind Kejriwal states that such material must be admissible before a court of law. Mark this, my lord. Admissible before a court of law. This is because the designated officer is required to arrive at a conclusion of guilt based on the material examined, and such guilt can only be based on admissible evidence. The relevant portion reads thus. DOE has drawn our attention to use of the expression material in possession in 19(1) instead of evidence in possession. Though etymologically correct, this argument overlooks the requirement that designated officer should and must, based on material, reach and form an opinion that arrestee is guilty of the offence under the Act. Guilt can only be established on admissible evidence to be led before the court and cannot be based on inadmissible evidence. While there is an element of hypothesis, as oral evidence has not been led and documents are to be proven, the decision to arrest should be rational, fair, and as per law. Power to arrest under 19(1) is not for the purpose of investigation. Please mark this, my lord. This one line, and I've been demonstrating, my lord, that once they, my lord, choose to arrest me for investigation, it is bad. Power to arrest is not for the purpose of investigation. Arrest can and should wait, and the power in terms of 19 can be exercised only when the material with the officer enables them to form an opinion by recording in reasons in writing that the arrestee is guilty. Then, my lord, para 35. The IO is also required to look at the whole material and cannot ignore material that exonerates the arrestee. A wrong application of law or arbitrary exercise of duty by the officer can lead to illegality in the process. The court can exercise judicial review to strike down such a decision. Referring to errors in decision-making process, Kejriwal records how such errors can vitiate judgment or decision of the statutory authority. Para 67 of Kejriwal. Error in decision-making process can vitiate a judgment, decision of a statutory authority. In terms of 19(1), a decision-making error can lead to arrest and deprivation of liberty of the arrestee, though not akin to preventive detention cases, but given the nature of order entailing arrest, it requires careful scrutiny and consideration. Yet at the same time, courts should not go into the correctness of the opinion formed or sufficiency of the material on which it is based, albeit if a vital ground or fact is not considered, or the ground or reason is found to be non-existent, the order of detention may fail. In Center of PIL versus so-and-so, this court observed that in judicial review, it is permissible to examine the question of illegality in the decision-making process. A decision which is vitiated by extraneous considerations can be set aside. Similarly, in so-and-so, elaborating on the expression decision-making process, this court held that judicial interference is warranted when there is no proper application of mind on the requirements of law. An error in decision-making process crops up where the authority fails to consider a relevant factor and considers irrelevant factors to decide the issue. Then, my lord, para 36 of my lord Agarwal, that, my lord, what is the ascertainment, my lord, about the material in possession, and para 44 of my lord Kejriwal is quoted. I'll straight away read para 44 of Kejriwal there. We now turn to the scope and ambit of judicial review to be exercised by the court. Judicial review does not amount to a mini trial or a merit review. The exercise is confined to ascertain whether the reasons to believe are based upon material which establish that arrestee is guilty of an offence under the PML Act. The exercise is to ensure that DOE is acted in accordance with law. The court scrutinize the validity of the arrest in exercise of power of judicial review. If adequate and due care is taken by the DOE to ensure that reasons to believe justify the arrest in terms of 19, the exercise of power of judicial review would not be a cause of concern. Doubts will only arise when reasons recorded by the authority are not clear and lucid, and therefore a deeper and in-depth scrutiny is required. Arrest, after all, cannot be made arbitrarily and on the whims and fancies of the authorities. It is to be made on the basis of valid reasons to believe, meeting the parameters prescribed by the law. In fact, not to undertake judicial scrutiny when justified and necessary would be an abdication and failure of constitutional and statutory duty placed on the court to ensure that the fundamental right to life and liberty is not violated. I don't have better word, my lord, resounding words than this, my lord. My lord, para 67 of Kejriwal, 65 of Kejriwal, and 66, my lord, as to, my lord, judicial review while examining the legality of arrest. Let me, my lord, go to, my lord, 65. We have already referred to the contours of judicial review expounded in Padam Narayan Agarwal and Dr. Pratap Singh. We have also referred to the principles of fairness, reasonableness. In Amrendra Kumar Pandey, this court elaborated on the different facets of judicial review regarding subjective opinion or satisfaction. It was held that courts should not inquire into correctness or otherwise of the facts found except where the facts found existing are not supported by any evidence. Not please, I pause here. I'm not wanting your lordships to, my lord, examine as the shoes of the investigating officer. But, my lord, this is if they are not supported by any evidence at all, or the finding is so perverse that no reasonable man would say that the facts and circumstances exist. Secondly, it is permissible to inquire whether the facts and circumstances so found to exist have a reasonable nexus with the purpose for which the power is to be exercised. In simple words, conclusion has to logically flow from the facts. If it does not, then the courts can interfere, treating the lack of reasonable nexus as an error of law. Thirdly, jurisdictional review permits review of errors of law when constitutional or statutory terms essential for the exercise of power are misapplied or misconstrued. Fourthly, judicial review is permissible to check improper exercise of power. For instance, it is an improper exercise of power when the power is not exercised genuinely, but rather to avoid embarrassment or for wreaking personal vengeance. Lastly, judicial review can be exercised when the authorities have not considered grounds which are relevant or has accounted for grounds which are not relevant. Now, my lord, the doctrine of proportionality has been applied, and my lord, in Arvind Kejriwal. Now, my lord, I would straight away take your lordship to para 46 of my lord Kejriwal, because my lord, this is a definite ratio. 46 of my lord Radhika, which I've kept in highlighted, my lord. There only. There only, my lord. There only. Quoted there. 46 in Radhika Agarwal. Same page, my lord, page 20, my lord, I was reading. In the judgment copy, my lord. For the aforesaid reasons, we do not find any inconsistency between Section 19 and PML Act and Section 104 of the Customs Act. We are of the opinion that principles and ratio developed in the case of Kejriwal and principles specifically discussed and delineated in paragraph so and so are equally applicable to the power of arrest. So, my lord, with this, my lord, I may humbly submit that, my lord, Arvind Kejriwal is a treatise. I, my lord, will respond in rejoinder when my friend takes over. Just a conclusive remark I wanted to make, my lord. And I'm confronted with the same situation as of today. I'm citing a live law report, and why am I citing? Newspaper reports are never cited, my lord. They are not good law. But my learned friends, brothers in Delhi, including the learned ASG, and that too in Arvind Kejriwal's case, I happen to be part of it, cited live law. So, my lord, I am citing today's live law. And, my lord, this is an observation. It's an obiter. I am just, my lord, showing what is brewing, my lord, these days. Give me my copy. The Supreme Court on Monday remarked that there is a pattern of Directorate of Enforcement making allegations in the complaints without referring to specific material to support it. A bench of so-and-so. Sorry. Give me a copy also. Pass. A bench of so-and-so was hearing a bail plea of so-and-so as accused in Chhattisgarh liquor scam. We have seen umpteen number of complaints of ED. This is the pattern. Just make allegations without any reference to anything. Justice so-and-so, my lord said. I'm not, my lord, quoting any further. These are all obiter. That's not my job. I know my duty as a counsel. What I'm saying is I'm just borrowing this line. There is a lot of things said in the reasons, in the grounds, in the remand application, and to the contrary, in, my lord, the affidavit, which is filed in opposition before your lordships. I am saying, my lord, what is the evidence to support it? And your lordships will now ask, my lord, the ED officer, that whatever you said in your affidavit, or whatever you said in the documents earlier, my lord, the grounds, reasons, and demand. What is the basis of saying that? Why are you saying that? And how are you saying that? Which document, which statement? And why are you withholding it? Why, my lord, an affidavit? This is a very important, my lord, aspect that I'm arguing, irrespective of, my lord, the result or fate of this case. Whether, my lord, it is this way or that way, doesn't matter, my lord. And eventually, I and my learned brother are, my lord, part of an evolution of law. I must submit to your lordships, my lord, how a counter ought to be filed. That's very necessary, my lord. As I have learned, my lord, in preventive detention law that I practiced a bit, my lord, that, my lord, the moment an illegality and arrest is brought to your lordship's notice, my lord, by way of a habeas corpus petition, the first rule is that your lordships will place all other matters beside and hear that matter. And second rule is, my lord, that my lords will straight away call upon the state to justify that the arrest is legal. It's not for me to demonstrate that it is illegal. It is for him to justify that it is legal. This exercise actually ought to have been carried out. Our magistrates are, my lord, too overpowered, with utmost respect. They hardly go into the matter. It's a very short hearing.
The remand hearing cannot be, my lord, longer than what it is required. But, my lord, this is the right time that if they bring the material to the court, what are the corresponding, if you made an allegation, why can't you write based upon this statement, based upon this document? If you don't say that, my lord, we are left with an empty rhetoric of an arresting officer. And, my lord, maybe good, maybe he has material. I do not say that, my lord. Maybe he can justify in a given case. My lord, it has to change then. Then, my lord, what is good for the goose will be good for the gander. He can't get away by not doing it. So, my lord, he has to do it properly, and that is, my lord, a different aspect your lordships may take into consideration. About 15 minutes in rejoinder whenever my friend is done, my lord. Grateful.
Today, are you ready? I don't.
The person is behind the bars. If my friend wants time, let me have an interim release. I'm a chartered accountant. I have deep roots in society. Without creating any right in my
And a senior friend says about this, then the question will come that when the person was arrested and when he came before this court, he could take 7 days time there. And today, after he finishes off at the 6 p.m. in the evening, he wants me to answer it now. Otherwise, release interim.
I'm not saying it's court's
It was my humble submission before this honorable court, and my senior jumped up and praying for the interim release.
Wait, you tell me.
I have to seek interim.
When do you Thursday possible?
The next week, any day. Because this week we have only 2 other days. Monday is a holiday.
More than this, my lord, that in a given case, it's obviously, my lord, we are in a extremely cordial atmosphere, my lord. Your lordships are taking extraordinary time for me, and I'm truly grateful, my lord. But, my lord, this thought, my friend may take whatever time, and my lords may grant eventually, my lord, your lordship's prerogative. I must, my lord, say with some kind of, my lord, alacrity on my part. I would be failing in my duty if I don't point out. This luxury of time is never available to, my lord, the state when a person is behind the bars. The luxury of time is never available. Bombay High Court, same thing happened, my lord. I don't want to name anything further than that. But there were, my lord, there was a strict speaking order passed. I don't carry it because I don't like it. It's about my brother.
He is doing before all these honorable high courts.
This is created by the petitioners, in fact, this time concept.
All right.
This time concept is a convenient concept.
At your lordship's files? Yes, of course. I leave it at that.
You see, you will convenience of the petitioners have always been given the prerogative by the court.
And I must tell, my lord, my learned brother, on a lighter vein, my lord, that mostly we all will be here on this side more than that side. So, my lord, parameters should be set for once and for all. But I leave it at that, my lord. Your lordship's prerogative. I won't join an issue on this.
How much time will you take? You just tell me. Let me, because we are nearing the vacations. I've got to schedule everything.
I don't think I will take more than 1 hour or
1 day only, 1 hour.
1 hour or 1 hour 15 minutes roughly.
1 day you will complete.
1 day. In 1 day I will complete.
No, then he'll be coming from there. Na? That's why.
In 1 day I will complete.
Lord, give us time at 3:34, whatever suits your lordships, and we can both complete, Lord, on that day. I'll not take more than 20 minutes.
3:34 is very difficult for this court. You saw what was going
no,
on.
Lord, I can't say more than that.
This is the police.
Not the first half, maybe initial.
First half, you have no. We are overburdened.
If I'm not overreaching, I will cite one more example, my lord.
Overburden of this court is that regarding, you don't get it in other states.
I know, my lord.
The other problem is that
My lord, very recently,
venues of public demonstration.
My lord, I fully am, Lord, cognizant, and my lord, again, I respect, my lord, your lordship's, my lord, patience, and my lord, endeavor to at least hear me. I must tell you, lordship, my lord, just about a month back, I was in Madurai bench. My lord, Justice Swaminathan came to know that, my lord, we are physically hearing it was, my lord, again, a PMLA matter. 10:30 court starts, my lord. My lords kept it at 9:30 so that we could finish. So, my lord, if I could ask for something like that.
Well, for the last 2 days, including today, this honorable court is hearing this matter after beyond the court hours.
Yes, yes.
Court here is not beyond court hours. There is no. I don't believe a concept
got out of Supreme Court at 8 p.m. My lord. Less than
I don't believe that there is any beyond court hours.
It's all your lordship. But my lord, my friend is right. With the burden of files that your lordships have, it is extraordinary, my lord.
No, police, other matters are comfortable. But very discomfortable are the political matters over here. हाँ,
Correct, my lord.
हाँ, तो
I am also a culprit in that category in many
हाँ,
cases, my lord. So I
so
would say.
that part of these venue demonstration at public and private properties,
My lord.
and we've got to face that.
Any time, my lord, which suits lordships, we can both conclude. My lord, if my learned brother takes an hour or hour 10 minutes, I'll take maybe 20, 25 minutes.
So I'll conclude on the next date.
My lord.
Because only we, otherwise we are nearing the vacation.
Yes, my lord.
And I'll take at least 2-3 days to deliver the judgment also.
My lord, my lord.
Given a, Tuesday. To come back on Tuesday, sir, 13th.
My lord, sir.
Tuesday, or rather, I will pray on Friday, Thursday, Wednesday.
Next day.
Well, Wednesday or Thursday, any one day next week.
At least give me 48 hours time, because I also require infrastructure to deliver.
Now I leave it to your lordship.
Do it on Tuesday.
Well, 3 days I am here. Difficulty is Tuesday one matter is fixed. Wednesday one matter is fixed. Thursday one matter is fixed.
I thought you come after doing all the matters.
So any day I come, I have to come after that.
After that.
And your lordship will take after 4:30. And all these matters 3:30 are fixed. So after 3:30 finish, I will come at join 4:30.
Oh, my lord, the morning time, as I suggested, my lord, if possible, an hour in the morning.
Our staffs don't come at that time. This is a difficulty.
I won't bother you, lordship, lord, whatever. Tuesday is fine, then, my lord, at 4:30.
But
my friend is able to make it at 4.
In case Tuesday it's not completed, Wednesday you have got to continue, sir. And
Say that Tuesday, Wednesday, and Thursday I have 3 matters fixed at 3:30.
In case
it spills over.
It spills over, Wednesday I finish.
May not spill over. You know Calcutta High Court, how things operate over here. If the council's courts are do matters, there are circumstances created when you can't do the matter also. One day you have been also a victim of circumstance, I believe.
Please,
Irrespective of the importance of the matter. Things are not always within. So
let us set one thing. Even if there is any resolution, I will do the matter.
No, you cannot now. Some resolutions are there.
We cannot avoid.
Usually 3:30 lawyers cooperate with me. I am very happy, but there are certain exceptional circumstances.
Yes, my lord.
Certain
That, my lord, God forbid,
some stalwart expires.
Yes, that makes a difference.
That makes a difference.
We are part and parcel of
the profession, and I cannot also. So even in such circumstance, if I am unable to sit also, then on it will just move on to 14th.
Right.
I'll complete this matter on 14th.
Truly grateful, my lord.
So as of now, it is fixed on 13th at 4:30.
Sure. Learned senior advocate appearing for the petitioner has concluded his argument. Mr. Chakraborty, learned aid, special public prosecutor, CBI, CBI Directorate of Enforcement, would commence his argument. With consent of both the parties, the hearing of the writ petition is fixed under the same heading on 13th May 2025 at, I'm keeping it at 4 p.m. It will start around 4:30.
Yes. My lord, may keep it at 4. As and when my brother arrives, we'll start.
At 4 p.m.
My lord will be continuing the new motions at least up to 4:40.
New motions will complete tomorrow. Will be completed tomorrow, sir.
Come back and your lordship will continue up to 4:40, 4:45.
No. The new motions, I don't have any, because yesterday I took 100 matters. Today I took 82 matters. 80 matters and 2 in the morning.
Regular thing when your lordship was in revision, new revisions used to get finished. The old revisions revived. Here also it will revive.
So
the same thing is going.
the urgency in the new motions will go off by this week.
At least we have some benches where matters are being taken up.
Whatever it is, sir. The only thing is that I'm carrying the heavy backlog of these court.
Yes. That's what I was referring to. If new motions get over, the backlogs are there. Court applications, contested applications, all will come up.
This bench hearing matters are not there, sir. even if I found the hearing matters which I have inherited, those could have been disposed of in the first
In the
place.
first round. Had it been before your lordship. Had it been before your lordship.
Every case has a fate, my lord, and everything has a time.
My understanding, new motions are even pending from 2023.
Yes, I have segregated that. I believe I will be able to just in order to reduce the monthly list. I have asked them to categorize them in 3 sectors. 155 to 2023 matters are there in the monthly list.
So your
I'll
lordship
take
finish it up within 2 days.
that. I
Maximum 2 days.
Thank you, sir.
Deeply obliged. Deeply obliged.